Section 62 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Oscar T. Caldwell for Embezzlement, Chicago, Illinois, 1855, Part 5. Mr. Blackwell. The crime charged against Caldwell is the blackest on the black catalog of crimes. Mr. Caldwell was the trusted agent and officer of the Chicago and Burlington Railroad Company, and if he abused their confidence and stole their money, he ought to be punished. No crime is more difficult to be proved, none more difficult to defend against than this of larceny and embezzlement. But I insist you shall be sure of the clearest evidence before you give a verdict that he is guilty. If there is a man on this jury who believes in his own infallible judgment, who is unwilling to listen to the arguments of counsel, I hope no client of mine may ever again fall into his clutches. Such a man is no better than an obstinate mule. We are all fallible, however much we are oppressed by the protracted length of this trial. I beg you will consider the public interest not only, but the interest of this prisoner now in your hands. Your mind should be as blank pieces of paper receiving impressions from the law declared by the court and the evidence produced before you. I wish you to commence with the presumption of innocence, which indeed is the obligatory injunction of the law upon you. You are entirely to disregard the finding of the grand jury because before that body there was no examination of the witnesses for the accused. The prosecution relied upon proofs of the receipt of certain moneys and a failure to report and hand over to the company. In the third place, they depend upon proof that upon making an average of the receipts of all the conductors on the line for 4 months, it appeared that the prisoner's returns of money averaged much below that of each one for each one, and below the average of each and all for the whole time. Our position is that the prisoner is to be presumed innocent until every reasonable doubt of his guilt is removed. There was, in this case, a power behind the throne greater than the throne. The throne was the people. The power behind it was the Chicago and Burlington Railroad. At the head of the road was Colonel Hammond. The immaculate John Whitworth had dubbed Hammond a colonel, but I preferred to call him by the name he himself assumed while on the stand, Father Hammond. Hammond opens to Caldwell with, "I have always acted as a father toward you," and that Caldwell answered, "Yes, you have been kind and a father." Now this kind father's conduct to this adopted son, from the day to this hour, will pass in review before you. Father Hammond employs spies and emissaries, not so much to detect Caldwell as to confirm his own suspicions. Pinkerton and Company are employed and put on the track of Caldwell. The tables of averages of the reports and returns of moneys collected by the conductors on the Chicago and Burlington line for a period of 4 months had cut quite a figure in this case. They ought not, in my opinion, to have been admitted in evidence. Mr. Follett, who made them out because he was directed to, first made them out in a just and proper manner, viz., from April to October. But this did not suit the purpose of Mr. Joy and Father Hammond. They sought to cipher out the guilt of Caldwell, and so they ordered the receiver to prepare a table of averages from a subsequent time. It is evident, as the jury evidently saw, that the longer the period of time included in an average, the more just would be it to all parties. But an average of this kind was unreliable in the nature of things. It was in testimony that the receipts of conductors on that road varied between $15 the lowest and $490 the highest receipts for a single trip. With the pendulum of receipts oscillating through so extended an arc, how could counsel offer a table of averages between 7 conductors for 4 months and upon it base a criminal prosecution? The testimony shows Mr. Follett, as he said himself, had not been ciphering out the conviction of Caldwell in the performance of his regular duties, but was expressly directed to make up such tables by his employers, and to use his own words. He did no more than he was told to. When the large 4th of July receipts were taken out of the averages, Caldwell ran no train on that day. It materially reduced the average discrepancy between prisoners' returns and those of other conductors. Mr. Blackwell alluded to the official statement that had been made that he was a frequenter of Young America Drinking Saloon, and that the statement had been reported by the public press. He had already stated that on the occasion referred to he was not at the Young America, but if he were a frequenter of that place, he might be expected to have Young America blood in his veins, and the prosecution might have an opportunity of seeing the effects of the contents of Young America on hot blood. He also alluded with much feeling to the violent attack that had been made on the prisoner and on his friends and counsel by John Wentworth in the Daily Democrat. The defense were characterized as blacklegs, who were seeking to bring an outside influence to bear on the jury in this case. The prisoner in this case, if clearly proven guilty, was guilty of one of the worst crimes and ought to be punished. If he was not guilty as charged, then indeed was he deserving of sympathy. Every night during this trial he had been watching by the bedside of a sick wife. Throughout the day he sat there listening to and defending himself against his powerful accusers. His wife was still sick and expecting to be confined every hour. Mr. Stewart: I feel the great responsibilities of the hour. I think I know what my duties are, and I hope I have made the discretion, as I know I have the firmness to discharge them. My generous opponent, Mr. Blackwell, may be assured that I feel quite as sensitive as he would seek to make me feel with regard to the embarrassments necessarily surrounding a stranger who has no personal relations with any who hear him. I am a stranger, gentlemen, to you and to your people. I have come here at the instance of the president of the Chicago and Burlington Railroad Company. Able counsel had been employed for the defense. The prosecuting attorney was encumbered with an unusual press of criminal business, and with the exception of Mr. Arnold, the members of your bar were generally preoccupied. Under this state of things, it was thought advisable that I, who chanced to be an old personal friend of the president and of the superintendent of the road mentioned, should bear a part in this case. All this will not make one here white or black. It is with the proofs we have to deal. It is alone with the pertinent facts in the case that I will consume your time. It was intimated that the people have no farther interest in this trial, that the public prosecutor has abandoned the prosecution because other counsel have been employed by the railroad company to support Mr. McElroy, and also because up to the time of the presentment by the grand jury, the people, as represented by their regular officers, knew nothing of the prosecution, took no initiative, nor felt any interest in the case. Well, suppose this were so. Is it unusual? Of the hundreds of indictments found every year in Chicago, how many are the citizens informed of beforehand? It is in the nature of the case that, almost always, the initiation of a prosecution is at the suggestion, if not by the act of private individuals, or it may be, of a corporate body, and the rest of the community do not know and need not know of the matter until the day of public trial. At this hour, do the people know what officers of the law are on the track of an undetected criminal? Do they know the crime and its circumstances? Need they know? Nevertheless, prosecutions are not individual enterprises. The style of a criminal prosecution is, in the name of the people of the state of Illinois. If all the people rose en masse, and with one acclaim prosecuted a man, would it not be a good, a lawful, and a proper prosecution? Then, if the prosecuting attorney is aided by one man or 100, by one corporation of men, or by several associations, is the prosecution not also proper and every way just? So much for the waste of words about the people being supported in this case by the Chicago and Burlington Railway Company. The principal officers in charge of the Chicago and Burlington Railway discover strong probabilities that one of their employees has repeatedly converted to his own use the company's funds. They go to the police agency in this city and complain of these depredations. They wished, if forced into a criminal prosecution, to produce a salutary effect upon the morale of railway service. They preferred first to satisfy their own minds of the guilt of their conductor, and then to obtain, if possible, some degree of restitution. Was not all this in the usual order of things? Was the conduct of Messrs. Joy and Hammond inquisitorial? It was not competent for them to proceed personally in all of the investigation preceding a prosecution. The organization of a municipal or an independent police department is elaborate and requires all the attention of its members. They therefore, and very properly, sought the aid of the Detective Police Agency, firmly established here by Pinkerton and Company, and conducted so skillfully, so successfully, and with such undeviating integrity to all parties, that it has become a beneficent institution of the Western country. The chiefs of this organization are deputy sheriffs, authorized to make arrests. They have organized a system of espionage, having extraordinary facilities for the detection of crime. Undoubtedly they have done this with the expectation of reward in money, as well as in the public reputation, which Mr. Rucker frankly confessed on the stand was a part of his expectation in the event of success. It was admitted by the senior counsel for the defense this morning that Mr. Rucker was a man not only of marked abilities, but more than that, of unquestioned integrity, a man who would never assist in prosecuting a man of whose guilt he was not entirely convinced. Indeed, the admission, frank as it was, is only demanded by the facts of the case, while in the whole history of American jurisprudence there is no instance of a conspiracy on such a scale as this to prosecute an innocent party. It appears that Oscar T. Caldwell, the prisoner, was formerly engaged in a ticket office at LaSalle, Illinois, with a salary of $1,000 a year, and that while holding this office, he applied for and received a conductorship on the Chicago and Aurora Railroad, the salary of which was but $720 per annum. It has been suggested that one explanation for this unusual course of leaving a large salary for a smaller one was because of the preference of his family to reside in this city. Perhaps it was so. I by no means think it conclusive of Caldwell's guilt that he resigned the ticket office with the salary of $1,000 and went on the cars at $720. But it appears that at a subsequent period he held the office of ticket agent in this city, having resigned the conductorship at a salary of $1,000 per annum, and that while in this office, the work of which is light and at regular hours, here, where he was constantly with his family who were now living in the beautiful city they had so much desired, that while in the ticket office in this city, while in such excellent health, that he never so much as complained of the few hours confined within doors, he applied to Colonel Hammond for a train of cars on the Chicago and Burlington Road, and was appointed conductor at a salary of $720. Here again was a loss of $280 per annum by the change of position. More than this, the duties of a conductor are onerous, and his hours irregular. In this case, he was up for all of 2 or more nights during the week, was absent from his home and his family one half the time, and all this increased exposure and enhanced laboriousness with $280 less salary. What are the inferences? Gentlemen, I do not insist upon this as proof of guilt, but I urge upon your attention the consideration of these significant acts, these most suspicious circumstances, that you may see how the confidence of Colonel Hammond was displaced by fears, how his fears became more than realized when the investigations produced their results. The first result of the investigation was the startling fact that Caldwell was uniformly behind the other 6 conductors on the road in the amount of monies reported and returned as collected on the trains. The tables of averages you will take with you in your retirement. They reach over a period of 4 months and exhibit his average receipts for each week, for each month, and for 4 months. Also the average receipts of each of the other 6 conductors who ran with him. Also the average receipts for Caldwell for each month as compared with each of the conductors, and his average total receipts for the 4 months as compared with the average total of each of the other 6. The result of these careful calculations was the discovery that Caldwell uniformly reported less money than any other conductor, less for each week, less for each month, and less for the whole period. Remember, gentlemen, that the 7 conductors on this line run round, as they phrase it, so that in turn each had a chance at the heavy or light receipts of each day in the week. These demonstrations convinced Colonel Hammond that he could no longer, in justice to the company, permit Mr. Caldwell to hold the office of conductor, in which character he was receiver of their monies on the cars. He could not let the matter pass, though his feeling for Caldwell was such that the steps he was forced to take were most painful. Colonel Hammond, after seeing the results of the tables of averages, applied to Pinkerton and Company for their services in ascertaining the existence of positive proofs of the criminal practices of the prisoner. Pinkerton and Company said to Colonel Hammond, "Your business on the trains is so conducted that it is difficult to detect peculations. You have no checks, no vouchers, no guards of any description. We know of nothing better than to place men on the trains who will watch this conductor, who will ascertain the number of passengers and the amount of fares on a given trip, and who shall pay their own fares in peculiar and marked money. Now, gentlemen, right here let me ask, had Oscar T. Caldwell been an honest man, would he object to being watched in any manner? Would not the result of such watching have been conclusive of his innocence? The witnesses sent out on the 9th reported the number of fares paid Caldwell, from which it appeared, among other convicting circumstances, that on the return trip Caldwell received 7 through fares and reported but 3. When the person of Caldwell was searched, there was found several of the identical marked bank bills paid him by these witnesses, bills too large to be needed for change, and a tally book in the prisoner's handwriting, which confirmed the statements of the witnesses and proved the falsity of his report and return of monies. The reports of the witnesses were made several days prior to the arrest and consequent discovery of the tally book. The admissions and confessions of the prisoner conclude my brief allusion to the points of evidence relied on for conviction. The application of savage epithets to gentlemen connected with the Northwestern Police Agency will only commend itself to the fears of those whose conduct will not bear scrutiny, or to the hope of revenge in those who have been detected. The substantial citizens, the right-thinking men of Chicago, not only endorse the character of Pinkerton and Rucker, they do more. They believe them among the most useful members of society. In placing 4 men upon the cars to watch Caldwell, Pinkerton and Company did not anticipate the collection of so much positive proof as would form the basis of a criminal prosecution. But in the order of things, there were occurrences not looked for. It was through no success of the spies that this telltale tally book was found on the person of Caldwell. This fatal tally book, with the convicting memoranda in the handwriting of the prisoner, thus ever with crime. It is a law of nature, of the God of nature rather, that crime is forever its own detector. The man who is unwise enough to commit crime is therefore weak enough to leave disclosing tracks behind him. The lines of all nature, whether in the spiritual or the physical, run parallel and straight, and like the chords of a harp, when a deviating and discordant hand sweeps over, they give out the harsh announcement of the crime. By the mysterious laws of this wonderful human organism, a series of concealments is not permitted. Man is not morally amphibious, that he may elect to live in the element of crime. Cunning ones may contrive to remain for a brief time under its polluting waves, but, like the diver for hidden treasures, they must quickly come again to the surface and the light. Were it otherwise, society must crumble. The zealous counsel for the defense seek to weaken the testimony of the 4 spies who went out with Caldwell on the 9th and returned on the 11th by attacking the character of one and the accidental peculiarities of the other 2 brought on the stand. Bridgman is characterized as a galvanized marble statue. The meaning of this unfortunate conjunction of irrelevant words is not apparent. I never saw a galvanized marble statue. But, gentlemen, if the immovable, unexcitable countenance of Bridgman is intended, I have only to say that it is as his creator stamped it. He is, we admit, a man of few words. It is characteristic of his profession as a detective policeman, a profession in which he excels. The fact that his family are in Washington City is his misfortune and theirs. He has not yet earned money enough to bring them on here. But is Bridgman the first man who, unable to find profitable employment in the older cities, has worked his way hither, trusting to employment that will enable him to send money for their passage to this land of plenty? In the universal splurge made by one of the counsel for the accused, an almost dramatic effect was attempted on the unwarrantable declaration of their own, that the witness Benedict was a state's prison bird. Without consuming any time, it is enough to state that the B.F. Benedict called as a witness here is no state's prison bird. The man who convicted him is not in this room. Some Benedict may have been convicted somewhere, not this Benedict. Without saying an ungraceful thing of this beautiful city, whose hospitalities I have enjoyed, it is patent that if Pinkerton and Company had need of scoundrels and state's prison birds, they had no need of going beyond the purlieus of Chicago. But observe the transparent motive, effect upon the jury, of this attempt to prove Benedict a convict, of this attachment taken out for him. Did they propose to bring him on the stand again? No, for they knew he was in a distant state. Could they attack his testimony? No, for it is substantiated and corroborated by other witnesses, and by singularly conclusive corroborating circumstances, the finding of the marked gold coins, etc. Could they insinuate that Benedict did not go out on the 9th of September train, did not pay the marked money to Caldwell? No, for they volunteered declarations of the integrity of Rucker, and Rucker swears Benedict did do these things. More fatal than these, even, are the conclusions of the evidence against the prisoner. Benedict and Bridgman, corroborated in points by Jddykst, testified to 7 through passengers paying fare from Burlington to Chicago on the 11th. Caldwell's tally book testifies to the receipt of 7 through fares from Burlington to Chicago on the 11th. This, gentlemen, is an instance in the manner of which this defense has rushed upon its destruction in assailing the testimony for the people. Gentlemen, I call particular attention to the qualities of the defense. Is it honest, or is it fraudulent? If fraudulent, you would be sure it was adopted to cover up something. I now undertake to demonstrate that this defense is fraudulent with regard to this tally list, purposely fraudulent. It was a point in the defense to prove that the memoranda, BC 7, in Caldwell's tally list, indicated 7 passengers from Burlington to Cameron, and not to Chicago, whereby the testimony of the 3 witnesses to 7 passengers from Burlington to Chicago was to be discredited. A triple chain is hard to be broken, but harder is it to establish a lie. The tally list indicates, in BC 7, 7 fares to Chicago, and not to Cameron, because first, the tallies are the first made when the conductor passed through the cars on leaving Burlington, and if these do not indicate Chicago, then no through fares are tallied to Chicago on that trip. But the report of the prisoner shows there were Chicago passengers on that trip. Second, where Cameron is meant, CAM is the abbreviation. Third, the marked money paid by some of those passengers for through fares was found on the prisoner. But fourth, Cameron, the fifth station coming west, is reported by Caldwell himself in his written report. None. Thus have the defense fallen into the pit of their own digging. Caldwell reports that there were no passengers from Burlington to Cameron on the 11th of September, and he does report, though less than the actual number, through fares from Burlington to Chicago. Here is one demonstration of a fraudulent defense. Counsel for the accused admit the testimony of the boy Jddykst to be true. Now Jddykst corroborates the testimony of Benedict and of Bridgman in very important particulars. This will have its due weight with you. This proof of a fraudulent defense reacted upon the prisoner, for it was a defense directly suggested by him. The testimony of Rucker, Jddykst, Benedict, and Bridgman separately, and taken as a united and interwoven whole, presented as a welded chain, no link of which can be weakened. Jddykst, Benedict, Bridgman, and West were the four men sent out on Caldwell's train of the 9th and who returned on his eastward train on the 11th for the purpose of paying their own fares in marked money and reporting the number of passengers and fares. All were provided with marked money and particular instructions. Jddykst was provided with a gold double eagle and a $10 bill, both marked. To Bridgman was given a gold eagle and two $5 bills. To West a gold eagle and a $10 bill. To Benedict 3 double eagles. Each coin and each bill given the witnesses was distinctly marked. Now, gentlemen, let us see the result of this carefully prepared plan. On the person of Caldwell at the time of his arrest, September 15th, was found the identical $10 bill, number 1422, letter A, Citizens Bank, Fulton, Oswego County, New York. That Jddykst testifies to having paid him for fare on the 11th. Why was this money not reported and returned to the company for whom he received it? Are $10 bills the most convenient for change? At the same search of Caldwell, they were found on his person two identical $5 bills, numbers 87 and 200, on the New Bedford Bank, which Bridgman had paid for fare. Were these retained for change? Benedict returned to Mr. Rucker 2 eagles and a $1 gold piece. One of the eagles was the identical coin, marked, that Rucker gave to Bridgman on starting. The other was the identical coin that Rucker marked and gave to West to pay his fare, coming eastward from Burlington. The sum of $205 was the amount found on the person of the prisoner at the time of his arrest, among which was the marked money I have described. The memoranda or tally sheet I have already alluded to. Now you have seen that the multiplied corroborations of Benedict's testimony crushed the hypothesis that his testimony was convenient evidence. I next pass to notice the argument of the defense, opened with such an air of triumph, that if there were deficiencies in the prisoner's report and return of monies for the 9th and 11th, it might be accounted for by the assumption that on the trip previous he had reported 2 or more through fares than he had retained money for. But the evidence as to the fares paid him and the number of through passengers eastward and westward, taken in connection with the prisoner's tally list, and then with his conductor's report, are conclusive that the company owed him nothing for previous overpayment. Singularly enough, this portion of the evidence seems to have been quite overlooked by counsel for the prisoner. The argument that the prisoner was a bad accountant and liable to mistakes is, when examined, fatal to a presumption of innocence. The marks on this tally list show that the prisoner kept it correctly, for it corresponds with the testimony of the witnesses on the train. Indeed, it will be remembered that the train was a light one each way, giving abundant time and opportunity to keep it correct. This tally list shows not only that it was correctly kept. Bear in mind, gentlemen, that it is the conductor's report, with the accompanying and corresponding return of fares that was false, but that in the alterations made during the calculation as to the amount he would dare to keep back. There was deliberation and coolness. You will examine these fatal ink marks drawn over the pencil marks in which the tally was first made. The footings on the report are the same as the footings in the tally list. While arguing the presumptions of innocence, counsel for the accused had instanced the fact in evidence that in making his report in return for the 9th and 11th, prisoner made a mistake of $4 against himself. Here again was one of those fatal leaps in the dark. For do they not now see that a conductor had first counted out his bank, deposit of $30 or $40 made with conductors for convenience in making change, and then paid over all the money remaining, could make no such mistake against himself? The fact of having made that mistake tells against the prisoner, because it proves that he had beforehand concluded about how much of the company's money to retain, and had made up his report to suit that predetermination, and not to fit the amount of money remaining after counting out his bank, or the specific sum of the company's money constantly retained for convenience in making change. The evidence shows that Caldwell's bank was not quite a fixed institution, but subject to contractions and expansions. Instead of being always exactly $40, it was sometimes much lower, and again very considerably higher. It is more than probable, for instance, that at the time he was searched, the $200-odd found on his person was nothing more or less than the plethoric representation of that fluctuating institution, his bank. When Caldwell was at the office of Pinkerton and Company, he denied having received any orders or instructions to pay over the identical money received for fares, except so far as necessarily paid out in making change. Here, gentlemen, holding up a memoranda, is a memoranda in Caldwell's handwriting, made on the back of that very printed order, which, as has been proved, was handed to him by the receiver. The reason of the order to pay over the identical money, with the exception stated, was this: it had been the custom, not very criminal perhaps, of conductors to take the gold and the best of the bank bills received for fares, and sell to brokers with the depreciated paper that forms the currency of Chicago, and is received as such on deposit at the banks, the conductors realizing a handsome aggregate percentage on the operation. To check this practice, the order in question was issued. In 2 or 3 instances, more fares are reported than are tallied. In 2 of these instances, the fares thus reported amount to 20 cents, and in the other instance, to but a few cents, whereas in the single item of 4 through fares not reported, although on the tally list, the money collected and kept amounts to $24. Making a total of all the fares collected on that trip, I find they amount to 61. Of these, 59 are reported. Remains there any doubt that this tally list is the tally list of the eastward and westward trips of the 9th and 11th of September? Of the 61 fares, 57 are identical in the conductor's report and in the tally. The pretense that the bank tally list used on the Chicago and Burlington line is not convenient to keep on, or that it is liable to cause mistakes, is a childish allegation. I am sure a child of 6 years ought to understand it. I know that a conductor on the Galena Railroad was brought here to testify that tally lists were of no account, and that the blank used on the C&B Railroad was one he could never understand. Gentlemen, the conductor who says he cannot understand this tally list is either a simpleton or a knave. If a simpleton, he is unfit to be entrusted with the lives of passengers. If a knave, let his employees look to their receipts. About the confessions made by this unfortunate young man I shall not speak at length. Their simple statement is the most powerful presentment. Both Colonel Hammond and Mr. Rucker told him at the outset that they wished him to make no admission whatever, that such proof of his delinquencies as were convincing were already developed, and yet these gentlemen are denounced by the prisoner's counsel for as much as they did not assist him to counsel on the night of the 15th, and, greater offense than that, because they were willing to compromise a felon. At first there was no willingness, not to say desire, to pursue Caldwell with the criminal prosecution into which he has since forced them. They wished to save, not to ruin him, if he would make such restitution as he was able, or, to use the magnanimous words of Colonel Hammond himself, such restitution as he himself thought was due the company. His resignation would be received, and he, Caldwell, allowed to go elsewhere and win again the position of a good citizen by an honest life. All this was rejected in the blindness that ever obstructs the perceptions of the criminal, because he is a criminal. I pass over the confessions made at the office of Pinkerton and Company, and come to those made in the jail at the last interview with Mr. Rucker at the time. Bear in mind, at the time when both Caldwell and Rucker supposed that the arrangements of restitution or settlement made by and with the consent of his counsel were about consummated. Rucker spoke, as he honestly felt, sympathy with Caldwell, and proposed to go with him out of the jail, asked him how he felt, and Caldwell replied in substance that he felt bad, very bad, that he was ruined, that the whole thing was out, that he ought not to have taken the money, that he wished he had never come to the city, and that he lived too fast. Ah, gentlemen, the pivot on which all this sad drama turns is condensed into that single expression, I have lived too fast. Pregnant words, they should fall from this courtroom like a tocsin on the giddy whirl of young men below. That multitude that has watched with varied emotions, but all with intense interest, the progress of this trial, should carry it forth and spread it in the saloons and in all the popular resorts of youth. I have lived too fast. It is most forcible, as it is the most graphic expression of the unhealthy life that characterizes, I shall be allowed to say, a multitude of young men in this beautiful city. In no town in the world do the centers of allurement and temptation bear such a proportion to the population. Extravagance in dress, extravagance in living, dangerous extravagance everywhere is apparent to the observer, nor need that observer wear puritanical glasses to see what I allude to. Perhaps it is the inseparable incident of the marvelous growth of this great city, and when things become more settled, and when the more conservative institutions of society become established, their superior moral force will cause all other elements and tendencies to revolve around the true central influences of society. We have been reminded of the social position and, of what comes still closer, the family relations of the prisoner. Gentlemen, no one of us is insensible to these appeals. They may be made never so often, may be made for unworthy persons, but the old words, love, family, children, are words alive. They have, like truth, an affinity with the soul of man, and never fall dead in the street. But we must sympathize with the husband only, not with the criminal. The crime committed, all the rest follow. Wife and children are the hostages, as it were, that a man leaves with society for his good conduct. It is not for me to speak of this prisoner as more degraded than he really is. I have no purposes to subserve by denunciation. My aims in my unwelcome duty in this prosecution lie wide of such an object. We do not gainsay his previous reputation. The first man was tempted by heaven's first, best gift to man. None of us are above evil incitements. None of us beyond the prayer, lead us not into temptation. Gentlemen, the case is now with you. If you can conscientiously acquit this prisoner, do so. If you are entirely convinced of his guilt, as charged, remember that justice is the highest attribute of humanity. The case was submitted to the jury without any instructions from the court, both parties waiving instructions. The jury retired in charge of an officer about 7 p.m. At 11 p.m., the jury not having yet agreed, the court adjourned till Monday morning at 9 o'clock. The verdict, November 26th. About 9:30, the jury came into court and informed the court that they had not yet agreed upon a verdict, some of them stating that they thought they could not come to an agreement. The court suggested that they had better retire again and consult together, that they had the Sabbath to consider and reflect upon the matter, and perhaps after an interchange of views and opinions, this morning they might be able to agree. In conclusion, he informed that he did not consider this a case in which he considered himself authorized to discharge the jury. About 6:00 p.m., the officer having charge of the jury reported to the court that they had agreed upon a verdict, whereupon they were brought into court. The jury, through their foreman, W.A. Tryon, handed to the clerk their verdict as follows. We, the jury, find the defendant guilty, in manner and form as charged in the indictment. We find the value of the property stolen to be $36 and fix the term of imprisonment in the penitentiary at 1 year. Mr. Dickey, on behalf of the prisoner, demanded that the jury be polled, which being done, the jurymen severally declared that the verdict rendered is and was their verdict. End of section 62.
Section 63 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by T.R. Love. American State Trials, Volume 1 by John D. Lawson. Trial of Mordecai M. Noah for breaking open and publishing a letter, New York City, 1818, Part 1. The narrative. Politics were likely to take on personal charges and recrimination in New York State in the first part of the 19th century, and there were yellow newspapers then as now. Between two prominent journalists, there was much hard feeling, and when one of them got hold of a letter addressed to the other, he published it in his newspaper with very sarcastic comments. For this he was hauled before the court to answer a charge of opening a private letter. He denied the charge, saying that it had been sent to him by someone he knew not whom. The judge told the jury that it was no offense to publish a private letter without the owner's consent, but if they thought that the editor had broken the seal and opened the letter either himself or by his command, he would be guilty. The jury convicted him, but the court set the verdict aside on the ground that the evidence was all in favor of the editor's story on this point. The trial. In the Court of General Sessions for the City of New York, February 1818. Jacob Radcliffe, Mayor. John B. Coles. Reuben Munson, Alderman. The defendant Noah, during the last term, was indicted for a misdemeanor at common law. The indictment consisted of 5 counts. The first 3 charged the intercepting, opening, and reading a private letter written by one Barnum of the partnership firm of Barnum and Nelson, Poughkeepsie, New York, and addressed to Alden Spooner of the City of New York. And in the other 2 counts, as having been written by each of the said partners individually, which letter related to the private affairs and business of Barnum and Nelson and Alden Spooner, that the letter was written, sealed, and transmitted by Barnum and Nelson to Spooner, and that defendant, on October 22, 1817, did intercept, open, and read the letter to the scandal and disgrace of defendant, and to the great injury of Barnum and Nelson and Alden Spooner. The 4th count recited that Barnum and Nelson, corresponding by letter with Alden Spooner on the 27th of October, last wrote and addressed to him a private letter which defendant, November 22, 1817, intending and contriving to harass and injure, said Spooner, did obtain and get in his custody and possession, and did publish and expose the contents thereof to diverse persons to the number of 50 or more, to the jurors unknown. The fifth count alleged that defendant on November 4th, 1817, intended to harass, etc., did illegally, indecently, and injuriously obtain and get said private letter into his custody and possession, and did then and there, in a newspaper called the National Advocate, edited by him, the defendant, print and publish the matters contained in said letter, and did in the same paper print and publish comments and strictures on the letter and its contents thereof, which said letter and comments are set out in the indictment. Open footnote. The following are the article and the contents of the letter being that part of the article which is printed in italics. Close footnote. Small fry. It is a remarkable circumstance that, prior to the election for governor in this state, a number of presses were decidedly hostile to Mr. Clinton, and this hostility was marked by peculiar traits of opposition, such as would lead an observer to believe that nothing but principle could rise to it. After his election, these presses, with an apparent simultaneous movement, came out in his favor. Had this sudden conversion been merely an acquiescence to the will of a majority of the legislature, who were induced to nominate him, it would not have been surprising. But to change with an unexampled rapidity from the extreme of opposition to the extreme of flattery and adulation satisfied us that a suitable consideration had been promised them. We made this charge openly, as we abominate the spirit of corruption, which is now the order of the day in this state, but designated the devoted presses under the general denomination of small fry. We did this for the simple reason that every press not purchased would not assume to itself the title. Accordingly, our experiment produced the desired effect. Those who felt and winced at the charge were loudest in their denunciations and calls for proof that they were regulated by considerations of interest. Accident has given us something in the shape of proof, and we now avail ourselves of the opportunity to convince our readers that with all the patriotism and devotion of the small fry to the public welfare, that they keep a watchful eye on the main chance and a bright lookout for a portion of the loaves and fishes as the promised reward for their consistency. The following letter, addressed by the editors of the Poughkeepsie Observer to Mr. Spooner in this city, we found in our office, open. How it came there we are unable to say, but it serves to illustrate our general positions in relating to the presses in this state, and as Mr. Spooner is our friend and neighbor, though we do sometimes disagree on special points, he will not complain at the liberty we take in publishing it, recollecting that all is fair in politics, and, at the same time, the letter relates to public affairs, in which we take some interest. Poughkeepsie, October 27, 1817. Sir, although entire strangers, we trust you will excuse these few introductory lines. A friendship was kept up between us and your predecessor, B. Irvine, Esquire, although we never saw each other, and for whom we entertain a very high regard. We wish to transfer that friendship to you. We have heretofore acted as agents for the Columbian at this place, and shall continue still to be of all the service to you we can, feeling with you the same political principles, and acting for the same cause, our acquaintance, and perhaps sometimes a concert in action, may be beneficial to us both. So far, so good. This is only introductory, a kind of scraping of acquaintance between these disinterested gentlemen who, being once agents for the Columbian, wish to hold the same appointment. It seems that a closer acquaintance with Mr. Spooner is desirable, and that if they lay their heads together and act in concert, it may prove, mark, reader, not important to the credit or honor of the state, but beneficial to them both. Here are two independent editors confederating to see how they can best serve themselves at the expense of the state. But fair and softly, let us hear their professions of political friendship. We take a lively interest in your warfare with Noah, and hope the time is not far distant when this wretch, thank ye, gentlemen, very much obliged for the compliment, will meet with that general detestation which the pander of an unprincipled junta merits. You have a bitter knot of factious demagogues to contend with, but we trust you will yet triumph over all opposition. Here is a Machiavel for you among the small fry, who think that the best road to favor among the Clintonians is to abuse us roundly and soundly, and to express their abhorrence of the Republicans in this city, who will not consent to allow such creatures power or influence. This is very well for an introduction, and after this Spooner must not doubt their sincerity, as the sine qua non all apostates is to vilify the Advocate and its editor, as if either could possibly be affected by such village cocks, who crow loudest when they most want feeding. But the best of the joke is that a shade of a shadow of a skeleton of a party in this city known as Clintonians, terming the Republicans, who beat them by a majority of upwards 2,000 votes in the last election, a bitter knot of factious demagogues. But let us continue to publish this letter as it was written. The steamboat Richmond, when opposite this place about daylight this morning, met with an accident in breaking some part of her machinery. She lies near here, and will be unable to proceed until she can repair, which cannot be, it is said, until some casting can be obtained from Salisbury, which has failed. This, of course, has no connection with the object of the letter, but now comes the main point. Now we arrive at the denouement, and he that has ears to hear, let him hear. We wish to have something done this winter by the Republicans to distribute the printing of the state laws more generally among the printers of his state. The patronage to the state printer is enormous. We suggested a plan to Mr. Irvine, which he said he approved of. We will write to you upon this subject in a few days. Respectfully, your assured friends, signed, A. Spooner, Esquire. Barnum and Nelson. We should like to have a peep at these truly disinterested gentlemen when reading their letter in our columns. Blush they cannot. Men who merely change ground to share the patronage of the state are past blushing. This, then, is to be the price of their coming out in favor of Mr. Clinton, and this confirms our position. The state printing is in the gift of the legislature, and it is valued at many thousands of dollars. And to silence these hungry cormorants, it is to be distributed to those most active in support of Mr. Clinton. This is supporting the purity and independence of the press, according to the new order of things, and thus emoluments of office belonging to the people are made an instrument of corruption, and subservient to the basest views, to purchase presses for the purpose of puffing men into notice by the most abject flattery and adulation. Hugh Maxwell, Mr. Bogardus, and Mr. Van Wyck for the prosecution, Mr. Fisk and Mr. Price for the defendant. Witnesses for the prosecution: Charles P. Barnum, am one of the firm of Barnum and Nelson, printers of the Duchess Observer in the village of Poughkeepsie, wrote the letter in question on October 29th, and sealed and directed it to Alden Spooner, Esquire, editor, The Columbian, 69 Pine Street, New York. Delivered it to Eli Barnum, a passenger on board the packet driver, Captain Taylor, from Poughkeepsie to New York, and directed it put in the letter box of the packet. Mr. Nelson did not know the contents of the letter. Mr. Price: what object had you in view in writing that part of the letter wherein it is stated, We wish to have something done this winter by the Republicans to distribute the printing of the state laws more generally among the printers of this state. Mr. Bogardus. This question has no bearing on the case. The gist of the offense is breaking and opening a private letter, the contents of which is not a matter in controversy. The court overruled the question. The letter is in evidence, and the intention of the writer is to be judged by its contents. Eli Barnum. On Friday, October 31st, I arrived in this city in the packet driver, and, according to the directions received from Charles P. Barnum in Poughkeepsie, put the letter, which was sealed, in the letter box of the sloop, and the next day, in looking there, found it was taken away. But what will Mr. Buell say to this arrangement? He is state printer, and to keep so, he has lately sent in his adhesion, notwithstanding which, such is the veracity of this small fry, that they spare neither friend nor foe. Now, how this is to be arranged between them we cannot say. Buell, while he has a charge of tobacco left in his pipe, won't relinquish the state patronage. The Caliban Herald will, of course, quarrel with his neighbor, the Observer, for forestalling him. Spooner won't like any interlopers in distributing the loaves and fishes, and eventually Mr. Clinton will be glad to get rid of them all. Let the stricken deer go weep, the heart ungalled play. For some must watch while some must sleep. Thus runs the world away. An envelope, admitted to be in the handwriting of the defendant, setting forth his intention of publishing the letter, bearing the date on the 3rd day of November 1817, in which envelope the letter was enclosed by the defendant to Alden Spooner, was produced and read in evidence to the jury. Alden Spooner. I never had any correspondence by letter with Barnum and Nelson previous to the reception of the letter in question, which was enclosed in an envelope directed to me by defendant on November 3rd. The letter was open at the time it was received by me, and the next morning I found its contents published in the National Advocate, accompanied by strictures and comments. The envelope set forth the intention of the defendant to publish the letter in that manner, but I did not write or speak to him against the propriety of that publication. Afterwards I published the letter myself in the Columbian, conceiving it my duty to render the matter clear to my patrons. Witnesses for the defense. George L. Birch. On Saturday morning, November 1st, between 8 and 9, I found the letter opened on the floor of the front office of the National Advocate, in which office I am a clerk. No other person at that time was in the office. Saturday is the Jewish Sabbath, and defendant, who is of that religion, does not attend to business on that day, and comes only occasionally into the front office, where he attends to his editorial business. Am positive that defendant had not been in the office that morning before the letter was found. Think he was not there during the remainder of the day. Without examination, I took the letter and laid it on the desk, going out of the office again on business. On my return, finding the letter was directed to Spooner, laid it under a weight with other papers. On Monday morning, November 3rd, about 8 or 9, defendant sent for me to come into the back office and inquired where I had obtained the letter, which defendant then had in his possession. And I gave the same account of finding it as I have just related. A boy from Spooner's office had been to the Advocate office for a paper, and it was supposed that this boy had dropped it on the floor. Cross-examined. Naphtali Phillips was the proprietor of the Advocate, and of the same religion with defendant. Phillips was not at the office on Saturday. Defendant smiled when he inquired about the letter. I do not know that an inquiry was made concerning the finding of the letter of any other person except myself. The editor and proprietor of the Advocate were in the habit of receiving letters from Poughkeepsie in the packets. Moses S. Phillips. I am son of the proprietor of Advocate. on the morning of November 3rd was in the front office, and finding a letter under the weight directed to Spooner, curiosity induced me to open it and read it. I carried it to the defendant, then in the back office, who inquired where I had obtained it, which I told him. Defendant then requested me to ask Mr. Birch to come there, when he gave some account of finding the letter as he has just related. I had neither heard nor seen anything of the letter until Monday morning. After reading the letter, defendant said, "This will blow up all their schemes." Samuel Berrien was in the office and heard the letter read by defendant, who afterwards took a copy and enclosed the original to Spooner in an envelope. Naphtali Phillips did not see the letter until Monday morning, when I received it from defendant. Was not in the office on Saturday, but was there with defendant the following day. On reading the letter, I advised defendant to retain the original and not let it go out of his hands, inasmuch as the writer in one part of that letter called defendant a wretch, which I conceived was libel, and that defendant, by giving up the letter, would deprive himself of the proof requisite before a grand jury. Against this advice, defendant took a copy of the letter and then enclosed the original in an envelope to Spooner. Afterwards, examined the strictures and comments written by defendant and published in the Advocate on the 4th of November, and fully approved of them before they were published. End of section 63. Section 64 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by T.R. Love. American State Trials, Volume 1 by John D. Lawson. Section 64. Trial of Mordecai M. Noah for breaking open and publishing a letter, New York City, 1818, Part 2. Mr. Price called on counsel for the prosecution to produce the authorities on which it was intended to sustain the prosecution. Mr. Van Wyck read from 2nd Hawkins, page 301, section 4. There can be no doubt but that all capital crimes whatsoever, and also all kinds of inferior crimes of a public nature, as misprisions and all other contempts, all disturbances of the peace, all oppressions, and all other misdemeanors whatsoever, of a public evil example against the common law, may be indicted, but no injuries of a private nature, unless they some way concern the king. The 17th section of the Act of the United States concerning post offices and post roads, Graydon's Digest, page 341, enacts that if any person shall take any letter or packet not containing any article of value or evidence thereof out of the post office, or shall open any letter or package which shall have been in the post office or in the custody of a mail carrier before it shall have been delivered to the person to whom it is directed, with design to obstruct the correspondence, to pry into another's business or secrets, or shall secrete, embezzle, or destroy any such mail, letter, or packet, such offender, upon conviction, shall pay for every offense a sum not exceeding $100. Mr. Fisk. I rise with no inconsiderable degree of embarrassment as counsel for the defendant, not because I consider the least blame is imputable to my client in a criminal point of view, but because throughout the criminal code there is no authority, no precedent for so extraordinary a prosecution. I have searched the authorities and looked in vain for a precedent which might justify this indictment, and after a most diligent inquiry, am bold to say that the highest charge contained in this indictment is not a public offense. If it were so, why do the laws of the United States annex a penalty to the offense? For it surely cannot be denied but that this statute is remedial and intended to prevent an offense unknown to the common law. On this occasion, defendant was unwilling, at the commencement of the trial, to move to quash the indictment, well knowing that the facts in the case would not warrant the charge in the indictment of breaking open a seal and reading a private letter. Not admitting that this is anything more than a private wrong for which the party injured might sustain his civil action, we nevertheless repel the charge, and contend that the evidence does not support it, but expressly proves the contrary. All the evidence in the case fully supports our position that the letter came into the hands of defendant after it was opened by some other person. The breaking of the seal of a letter is an act which it is reasonable to suppose would occur frequently. Had it ever been considered an indictable offense, there might surely have been found some precedent, either in our records of criminal jurisprudence or in those of England. To say the most of it, it is but a private wrong, or an infringement of imperfect right. Under the circumstances of this case, it was a laudable act in defendant to publish this letter with strictures and comments. This letter contained an atrocious libel against defendant. It called him a wretch, and the writer, moreover, spoke of a concert between his firm and Mr. Spooner, his correspondent, the avowed object of which was to have something done by the Republicans at Albany this winter to distribute the state printing more generally. This, if not a plot, was a matter relating to the interests of the people in general, and ought to have been exposed. In a country of equal rights, no citizen should be subjected to a criminal prosecution for a matter uncertain and not well defined, for, as an elegant writer has remarked, miserable is the situation of the subject where the law is undefined or unknown. Mr. Price to the jury. The act of breaking open the seal of a private letter is not an indictable offense. Had it been, surely some precedent could be found for such an indictment in the judicial records of that country from whence we have derived our criminal jurisprudence. The offense was against the private rights of individuals only, and not against those of the public. But in this case, the evidence clearly shows that the defendant is not guilty of the offense laid in the first 3 counts. The letter came into his possession opened, and under the circumstances it was just and laudable in him to give it publicity. Let any unprejudiced man on this jury lay his hand on his breast and say whether, if he had received a letter in the manner this was received, wherein he was called a wretch, he would not have published it with comments on the conduct and motives of the writer. Nay, more, whether he would not, in the language of one of the witnesses, have retained the letter and laid it before a grand jury. Besides, the avowed object in the letter was to effect something in concert with Mr. Spooner, touching the distribution of the state printing more generally. We wish to have something done this winter by the Republicans. Now, as the object to be effected this winter was confined exclusively to those whom the writer was pleased to term the Republicans, I confess it gave me some considerable degree of alarm. It really looks ill. There used to be a party in this state termed Federalists, with whom I acted, and I therefore regretted to see that by the terms of that letter the Federalists were not to be consulted relative to the measure of distributing the state printing. It was to be done by the Republicans, and for the Republican printers only. I confess the jury is to lay aside all party prejudices. You were impaneled to pronounce the law as it stands, unbiased by party feelings, and it is not your province, however it might gratify the political opponents of defendant, to step in the place of legislators and make that a law which was not so before. Mr. Bogardus, Mr. Van Wyck, and Mr. Maxwell summed up the case for the prosecution. They contended that a private letter was a species of unprotected property, and that among men in every country a seal had been considered sacred and inviolate. Every member of the community was concerned in the preservation of that peculiar property which was protected by public opinion alone. If no precedent could be found for an indictment for the specific offense laid in this, it is because no man had ever yet been so depraved as to be guilty of its perpetration. It cannot be denied that the act is highly immoral and concerns the public interest, which constitute the distinguishing characteristics of a public offense. Though there is no direct evidence that defendant broke the seal and opened the letter, yet the circumstances of the case fully justify that conclusion. Defendant was the first person in whose possession the letter was found after it had been surreptitiously obtained, and counsel urged to the jury that he had not satisfactorily accounted for the possession. In the next place, he made an improper use of the letter by publishing its contents. Had he, as is pretended, found the letter open, he ought, as an honest and honorable man, to have sent it unread and unexamined to Mr. Spooner. Open footnote. Mr. Maxwell admitted that no evidence existed in the case showing that the defendant broke the seal, but he contended that as this was a private letter, defendant had no right to publish its contents with strictures and comments. The other counsel for the prosecution opposed this admission and insisted that there was evidence to warrant the conclusion that defendant broke the seal. Close footnote. It was not just to argue that because no precedent for such an indictment could be found, that therefore this prosecution could not be maintained. It was sufficient to say that the act in itself was indecent and immoral and concerned the interests of the public. In the case of him who in the public streets of London stripped himself naked, there might not have been, and probably was not, a precedent of an indictment for such an offense to be found, and yet a public prosecution was maintained, and in the case of William J. Jenner, tried in this court, no precedent existed of an indictment for so singular an offense, and yet his counsel, by not raising the question, tacitly admitted that the indictment was supportable on general principles. Ratcliffe, Mayor. To the jury. This is a new case, and the first question presented for consideration is whether it is a misdemeanor in any individual to break the seal of a private letter and publish its contents. It is not the case of a letter intercepted by the authority of government or a public officer, which under certain circumstances might be justified and necessary to detect designs against the public safety or peace. The case before us is that of an individual who is charged with committing the act without such authority. It is admitted that there is no precedent for such an indictment, but counsel for the prosecution contend that on general principles the charge against the defendant must amount to an offense. In the absence of precedent or direct authority, we can only resort to general principles, though it would be more satisfactory to have former decisions for our guide. To constitute a misdemeanor punishable by indictment, two things appear to be essential. First, that the act be in itself improper or immoral, and secondly, that it be of public interest or concern, and have a tendency to produce general or public evil. It is not the immorality of an act alone which constitutes a public offense. Many gross frauds and injuries are committed by individuals towards each other, for which there are no other than private remedies. But when the act complained of be also of a public nature, and the community have a general interest in suppressing or preventing its repetition, it then becomes a public offense, punishable by indictment. Upon these principles, and the best consideration we have been able to give this subject, the court is of the opinion that the breaking open and publishing a private letter is a misdemeanor, and therefore indictable. Correspondence by letter has become very extensive and important. Next to that of personal intercourse, It is a medium of communication the most general and interesting of any that exists in a civilized community. It may relate to matters of friendship, of business, and to all the concerns of human life, whether of a public or private matter. A letter is usually protected by a seal to guard it against public inspection, and by the common consent of the world, this seal is to be held sacred. It is the interest of every man in the community that it should be so, and to permit it to be violated would lead to incalculable evils and strike at the root of all public and private confidence. If, therefore, the proof in this case can support the charge that defendant broke open this letter, or, which would amount to the same thing, if he had any agency, directly or indirectly, in doing it, in the opinion of the court, he ought to be found guilty. The direct evidence of the witnesses on the subject is that it was found open on the floor of his office, but it was contended by some of the counsel for the prosecution that there are circumstances which go to show that he must have had an agency in procuring and breaking open the letter. If there be circumstances to satisfy you of this, according to the opinion we have expressed, the indictment would be sustained. Otherwise, defendant ought to be acquitted. Another question is also made. Considering the evidence not to warrant this conclusion against defendant, and the letter to have been found open on the floor of his office, and that it came to his hands in that situation, as stated by the two witnesses, Birch and M.S. Phillips, is the act of reading and publishing it an indictable offense? As far as my own opinion is concerned, I have no hesitation in saying that I consider it incorrect, as between individuals, to read or make use of a private letter addressed to another to whom it is known to belong, whether it be found open or not. The proper course for a defendant, I think, would have been to have sent this letter to Spooner, and to have published nothing on the subject. On this point, however, I am sensible a difference of opinion exists among the members of this court, but it does not affect the legal question, with respect to which there is no difference. It is not every incorrect or improper act which is indictable. To render it so, it is necessary, as before stated, that it should be of a public nature, and of a general evil tendency, or the community have not such an interest in it as to make it the ground of a public prosecution. The finding a letter open is not a common occurrence, and can rarely happen. Generally, it must have reached the owner, and have been lost or mislaid through his negligence or carelessness. The public have, therefore, no general interest on this question, and the law does not provide against the carelessness or negligence of individuals. Whether, therefore, it be or not be incorrect or immoral to read and make use of a letter found open, by publication or otherwise, contrary to the intent of the writer or his correspondent, it is in our opinion not a matter of public concern, and therefore not indictable. It has also been made a question whether the strictures and comments of the defendant which accompanied the publication of the letter, or the use made of it in connection with those comments, does not amount to an offense. The strictures and comments do not, in our opinion, alter the case, or affect the question on the present indictment. If they are indictable at all, it can only be by the way of prosecution for a libel. Having expressed our opinion as to the law on the questions that have been made, it is admitted, as has been contended by counsel for defendant, that you have a right in this, as in all criminal cases, to judge of the law as well as the fact. But in deciding on the law, it must rest with you to consider how far it is prudent or discreet to respect the opinions delivered by the court. The jury retired and returned with a verdict of guilty. Mr. Price demanded that the jury should be polled, which was done, and they confirmed the verdict. On February 6th, the verdict of guilty was set aside by the court, and a new trial ordered on the ground that the verdict was against the weight of the evidence. The jury, said the court, had really decided, contrary to the opinion of the court expressed to them, that the reading or publishing of a letter, whether found open or not, was an offense. End of section 64. Section 65 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by T.R. Love. American State Trials, Volume 1 by John D. Lawson. Trial of Alden Spooner for libel, New York City, 1818. The narrative. The second act of this drama of Noah and Spooner finds the latter indicted for printing in his newspaper the charge that Noah made use of a letter, the one in the previous case, knowing it to be stolen. Here the jury, which curiously enough was composed of some of the same men that sat in the trial of Noah and convicted him, could not agree, were discharged by the court, and the prosecution went for nothing. The trial. Before the same judge and in the same court as in Noah's case. Defendant was indicted for a libel published in a newspaper called the New York Columbian of the 2nd day of November last against Mordecai M. Noah, the editor of a newspaper called the National Advocate. Mr. Maxwell, Mr. Fisk, and Mr. Price for the people. Mr. Bogardus and Mr. Van Wyck for the defendant. When the jurors were called, it appeared that some of them had served on the trial in the preceding case. The court inquired of counsel for the prosecution if they had any objection to make such jurors. They answered in the negative. The libel set forth in the indictment was part of a long editorial article headed Madness of Party, and animadverting on the conduct of the General Committee of the Republican Party in this city, in sending a delegate to Philadelphia to join in a public dinner and congratulate a particular party in that city on their recent triumph in an election. The matters alleged as being libelous set forth in the indictment were in the following words. Yes, Republicans of New York, the National Advocate of yesterday exhibits the fact that a general committee, of which Mr. Jonathan Thompson was chairman, and Mr. Benjamin Romaine, secretary, thought it necessary to send a representative to Philadelphia to join in this carousel, and by addressing and toasting to propitiate the favor of the triumphant party. And who is the representative of this faction, who seek to foment the feuds of civil war among their brethren of a sister state? Who is the grand depository of the political virtue of this great metropolis? Gentle reader, Major Manasseh Moses Noah was this high dignitary. The political consequence of this great state rested on the shoulders of this modern Atlas, a stranger, with no ties of family or property, the knight of the broken seal, who converted to his own use property known to be stolen. The publication having been admitted, it was read in evidence to the jury, and the prosecution rested. Mr. Van Wyck to the jury. As the gravamen in the indictment consists in calling the prosecutor the knight of the broken seal, who converted to his own use property known to have been stolen, defendant would prove that this part of the publication referred to the stealing of a certain letter, sealed and transmitted by Barnum and Nelson, printers, at Poughkeepsie, to the defendant in this city, and that such letter in its passage was intercepted and opened before it reached him, and was published by the prosecutor under circumstances in which he must have known that it was surreptitiously obtained. Defendant would contend before the jury that inasmuch as a letter is not the subject of a felony, that therefore no libel is contained in this publication. Mr. Van Wyck offered to read a passage from the National Advocate of the 4th of November to show that the prosecutor himself considered the libelous matter in the conclusion of the publication, to refer to the transaction concerning this letter. Mr. Price, the particular part of the publication attempted to be explained, was insulated and had acquired a publicity through the state among persons who were not acquainted with the particular circumstances of the transaction concerning the letter, and who, most probably, were not in the habit of reading the Advocate. Counsel for the defendant had, therefore, no right to give in evidence any construction made by third persons which the libel on its face would not warrant. The testimony was withdrawn. Charles P. Barnum testified to the same facts in relation to the letter as are stated in his testimony in the preceding case. The letter of Barnum and Nelson, set forth in the 5th count of the indictment in the same case, was here read in evidence. Counsel for the prosecution offered to read passages from the National Advocate of November 4th, 12th, 15th, 18th, and of December 2nd and 3rd, with the same view, and for the same purpose as that of the 4th of November above stated, was offered. Counsel for defendant objected. The court. The evidence was admissible for the purpose of showing what was understood to be the species of property alleged in the publication as known to have been stolen, in connection with or in confirmation of what appeared from the publication itself. At any rate, defendant had a right to produce such testimony in mitigation of his punishment should he be convicted. Passages from these several papers were read, from which it appeared therefrom that the prosecutor considered the libelous matter contained in the conclusion of the publication as having reference to the transaction concerning the letter. Counsel for the prosecution offered to read the conviction of the prosecutor for the purpose of showing by the verdict of the jury that the letter was stolen. Counsel for defendant said that the evidence offered was so manifestly absurd that they would not argue the question before the court. The court. The evidence is inadmissible and unnecessary inasmuch as the facts relative to the transaction are already before this jury, or might be proved so as to enable them to judge of the matter for themselves. Evidence in rebuttal. Mordecai M. Noah. I have never made use of property known to be stolen, nor have I ever made use of a letter known to be stolen. On Monday morning, 3rd November, Moses S. Phillips brought the letter to me opened, saying, "Here is a curious letter," that he had found it on the desk under a weight in the front office, and he then looked down the back of the letter and unfolded and read it, without examining its direction. I sent for Mr. Birch, inquired of him where he obtained the letter, and he said that he had found it on Saturday morning on the floor of the front office, open. I had never heard of or seen the letter until Monday morning, and besides inquiring of Mr. S. Phillips and Mr. Birch, had made further inquiries to ascertain how the letter came on the office floor opened, but could obtain no satisfaction. Soon after the letter came into my hands, I showed it to N. Phillips, the proprietor of the paper, who advised me to retain the original as it contained a libel. Notwithstanding this, I took a copy and enclosed the original in an envelope to Mr. Spooner, stating therein how it was found and also my intention of publishing it in the Advocate. Do not recollect whether Samuel Berrien was in the office and heard the letter read, but if he were, he approved its publication, as did also the proprietor of the Advocate. Under then existing circumstances, I considered it perfectly justifiable to publish the letter, and would publish it again. There was a public meeting and a dinner given by certain political men in Philadelphia, and I went there as a private citizen and not as a representative from the General Committee in this city. After my arrival there, I received a congratulatory letter from the General Committee here to be presented to the meeting. I have lived in the city nearly my whole life and was educated here, have been consul of the United States at Tunis. John O. Sullivan, was consul of the United States at Mogador, first became acquainted with the prosecutor at Gibraltar when he was on his way to Tunis as consul of the United States. His character was fair and unblemished, and his manners and demeanor those of a gentleman. Have read the publication in question, and had I seen it published against any other individual whom I had not known, I should have thought the person alluded to had been guilty of an offense equal to stealing. The publication, in my opinion, is calculated to hold the prosecutor up to public ridicule and contempt. Jonathan Thompson. Mr. Noah was not sent to Philadelphia as the representative of the General Committee, of which I was chairman. The character of the prosecutor is perfectly fair and unblemished. Mr. Van Wyck. Do you know the verdict of yesterday, and did you hear the evidence on that trial? If so, what do you now think of his character? I heard the evidence of yesterday and a part of this day, and I retain the same opinion of his character as I have before stated. Mr. Van Wyck. Suppose you were to find a letter directed to an individual, broken open, lying on your office floor. Would you consider it a justifiable act to open, read, and publish its contents? That would depend on circumstances. I think, standing in the situation of the prosecutor, had such a letter been found by another, opened, and brought to me, wherein I had been called a wretch, I should have pursued the same course he did, if not a more rigorous one, towards the writer. The Mayor, to the jury. Notwithstanding, in the discussion of this case, much has been heard, much of party views and purposes. The court hopes that such considerations will be discarded from your deliberations. Cases of this description generally originate among printers, and it is a subject of regret that the press has become so licentious. Notwithstanding this, the same rules of law and evidence are to be applied in determining cases in which editors and printers were concerned as in any other. The court deems it unnecessary to enter so extensively into the definition of libels as to comprehend every case of that description. It is sufficient for the purpose of this case to say that any malicious writing or publication exposing or holding up another to public hatred, contempt, or ridicule was libelous. The doctrine on the subject of the defense or justification of what would otherwise be deemed a libel has been very much agitated in the courts of this state, until by an act of the legislature and the decisions which have taken place, I consider it settled that malice is the criterion of a libel on a public prosecution. It is provided, however, that the defendant may give the truth in evidence, but it is not of itself a justification, unless the publication also proceed from good motives, and be intended for justifiable ends. A publication may, in some cases, be true and yet a wanton and cruel libel. If, for example, natural defects, personal deformity, or the misfortunes of individuals were to be made the subjects of newspaper animadversion, however true, it could not be justified, for the motive must necessarily be improper. So, on the other hand, it follows that a publication may be untrue and yet, on a public or criminal prosecution, be held innocent. If it be founded in error or mistake, and no malice appears, it would be excused from being punishable as a crime. To constitute a crime, the intention of the party accused is in material consideration, for there can be no crime without a criminal intent. It will be observed that we now speak of libels for which criminal prosecutions may be maintained only, not of remedies by civil actions for such libels, in which I apprehend a different rule to prevail. Upon these principles, the inquiry in the present case will be whether the publication in question be injurious to the character of the prosecutor, Noah, by holding him up to public hatred, contempt, or ridicule, and whether it proceeded from malicious motives. The matters charged to be libelous may be naturally classed under two heads. First, as they relate to the expedition to Philadelphia. Second, in reference to the charge of converting to his own use property known to be stolen, as stated in the conclusion of the publication. In relation to the first, it appears that the prosecutor originally went to Philadelphia in his private capacity, not as a representative or delegate from the General Committee of this city, that when there he received a congratulatory letter from the committee to be presented to the meeting in Philadelphia on occasion of their triumph in the preceding election. He then, and not before, became so far the agent or representative of the General Committee here. But this agency appears to us of little importance in respect to the charge of a libel. What is more material in this view is that he is represented in this branch of the publication as being a grand depository of all the political virtue of this great metropolis, a high dignitary, a modern atlas, on whose shoulders rested the political consequences of this state, and a stranger without the ties of family or property. These representations appear to us to be intended to hold him up to ridicule and contempt, and if you are of that opinion, the defendant ought to be found guilty. As to the next branch of the publication, the prosecutor is here represented as the Knight of the Broken Seal, who converted to his own use property known to be stolen. If this charge of converting to his own use property known to be stolen is to be taken in its broad sense, unexplained and unconnected with any transaction to which it referred, it would be an atrocious libel. But it is contended that it manifestly referred to the case of the letter which has been so much a matter of discussion, and that it must have been so understood. The transaction concerning this letter had already been the subject of great controversy, and it does appear to us that the circumstances attending this publication and the introductory remark, calling the prosecutor the Knight of the Broken Seal, indicated strongly that the charge related to the letter. It was so treated by the prosecutor himself in his subsequent publications concerning it, and I think it would naturally make that impression on the mind of anyone. Technically speaking, or in a legal sense, a letter cannot be the subject of a felony, but this consideration alone would not furnish an excuse to the defendant. A letter is still a species of property, the purloining of which is considered unlawful, and for anyone to be subjected to the imputation of converting to his own use a letter known by him to have been thus obtained would be highly injurious and therefore libelous. Supposing that the publication had reference to the letter and was so understood, the next inquiry is whether the letter is to be considered as having been, in fact, purloined, and that known to the prosecutor. Considering the manner in which the letter was found on the floor of the office, and its coming into the possession of Noah, as stated in the testimony, if conjecture were to be indulged, it is probable that someone took this letter from the vessel in which it came, opened, and ascertained its contents, and, for the purpose of making mischief, threw it or dropped it in the office of the prosecutor. But were the circumstances such as to indicate to Mr. Noah that it must have been purloined? If they were, he must of course have known them. It was found open on Saturday morning, recently after its date, on the floor of his office. It remained in the office until Monday morning, when it was handed to him. It was addressed to another to whom it belonged. It contained, among other things, a libel upon himself, and related to the distribution of the business of the state printing, from which it seems he was to be excluded. It is not probable that the writer or his correspondents would have put this letter in the way of Mr. Noah, yet there is mystery concerning it, and all that can be said is that if you think the circumstances were such as ought to have satisfied him that the letter had been purloined on its passage to the rightful owner, then this part of the publication would be justified, as far as relates to the truth of the facts alleged in it. There is no doubt he converted it to his use by publishing it. Whether it was purloined and he ought to be considered as knowing it, are among the matters of fact in the case which belong to you to decide. Admitting the letter was purloined, and that the prosecutor ought so to have regarded it, still, according to the principles we have mentioned, another question remains. Did the publication containing this charge proceed from good motives, and was it intended for justifiable ends? For although true in point of fact, the motives and the ends are to be considered. The defendant was entitled to vindicate his own rights and expose the injury, if any was done to him, in relation to this letter. But if he went beyond this and was actuated by malice or had in view any unjustifiable purpose, he would still be liable to this prosecution. In a case depending so much on circumstances and the intention of the parties concerned, we do not consider it the duty or the province of the court to express a decided opinion farther than has been done, and we leave the question for your determination. The jury disagree. The jury retired at 6 p.m. At 8 o'clock the next morning they came into the court and stated that they had not agreed on a verdict, and that it was not probable they could ever agree. The court considered it useless to send them out again and discharged them. End of section 65. Section 66 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by T.R. Love. American State Trials, Volume 1 by John D. Lawson. The Trial of Mordecai M. Noah and Alden Spooner for Contempt of Court, New York City, 1818. The Narrative. The third act in this interesting drama finds both editors before the judge for contempt. Noah's paper, after the verdict against him, had assailed the jurors in good style, charging that it had been obtained through political influence. Spooner's paper had made similar charges on the result in his case. Brought before the court, they made abject apologies and were discharged with a reprimand. The trial. In the Court of General Sessions, City of New York, February 1818, Jacob Radcliffe, Mayor. After the verdict of guilty was rendered against Noah, and while the motion for a new trial was pending, a juror delivered to the court several copies of the National Advocate, edited by Noah, containing reflections on the conduct of the jury in rendering the verdict they had given, and claimed the protection of the court. The court delivered the newspapers to the district attorney, saying that the court could not regularly notice the publications contained in them unless the papers were verified by affidavit, showing by whom they were printed or edited. Mr. Maxwell, district attorney, produced an affidavit of H. Spence stating that M. M. Noah was the editor and N. Phillips the proprietor of the National Advocate, to which affidavit were annexed the papers mentioned, dated 14th, 15th, 16th, and 17th January. Several passages from these papers were read. The first contained a long editorial article headed Liberty of the Press, in substance attributing the result of the prosecution against Noah to the influence of party, complaining with considerable severity of the grand jury for finding the bill, and of the petite jury for finding the verdict they did, alleging it to be against evidence. The article concluded with the publication of Barnum and Nelson's letter at full length. The paper of the next date contained a communication signed Blackstone, wherein the writer endeavored to show that the indictment was without precedent, and the verdict contrary to law and evidence. The paper further contained several editorial articles on the injustice of the verdict, in one of which it was stated, We were pained to see an attempt made for party purposes against law and evidence to convict a citizen for a misdemeanor, etc. The third paper contained another editorial article attributing the verdict to the efforts of a pensioned band and accusing that band of an attempt to sully the purity of justice. The fourth paper contained several articles in relation to the trial, attributing the proceedings and verdict to the influence of DeWitt Clinton and asserting that he had an agency in procuring the conviction against law and evidence. The writer complains of bending justice to meet a specific purpose, and in another article it was stated that the Clintonians obtained a verdict which does them no honor and the jurisprudence of the city no credit. The court, on reading the affidavit and passages from these several papers, directed them to be filed with the clerk, and on motion of the district attorney, ordered rules to be entered that M. Noah and N. Phillips show cause why attachments should not issue against them for these contempts. Mr. Maxwell read a similar affidavit attached to the New York Columbian of January 16th, which contained the following article. After Mr. Jonathan Thompson, chairman of the General Committee, had given his evidence in case of the People against Spooner, a gentleman said, "If this is the high priest of the congregation, what must be the deacons and elders? What must the worshippers be, when such is their idol?" Mr. Maxwell moved the like rule against Alden Spooner, the printer and editor of that paper, which was ordered. Mr. Maxwell moved that parties against whom the rules, as above mentioned, had been entered at the last term, show cause why attachments should not issue against them. The parties appeared in person and by their counsel. Mr. Price for Noah objected to the proceedings for irregularity, in this that copies of the passages complained of as matters of contempt had not been served on the party at the time the copy of the rule to show cause was served. This was necessary for the purpose of apprising the party of the matters he was called upon to answer. Mr. Maxwell contended that the papers containing the matters of contempt were pointed out, and that the party was sufficiently apprised of the particulars by the several papers filed when the rule was entered. The mayor considered the objection hypercritical, and that it was sufficient for the district attorney to proceed and point out the several matters of contempt in the newspapers accompanying the affidavits, and if the party then wished a further time for answering, the court would grant it. Mr. Maxwell presented interrogatories to be filed with the clerk to be administered to the parties. He considered this to be the practice. The mayor did not consider that authority to apply to this stage of the proceedings. The parties are brought into court to show cause why the rules granted at the last term should not be made absolute, and it now rests with them to show this cause. If they do not, the rules become absolute, of course, and the attachments will issue, on the return of which the interrogatories are to be filed with the clerk, to which they must answer under oath. They may, however, waive or supersede this proceeding by consenting to answer or purging the contempts at this time. Mr. Maxwell marked with a pen the several passages alleged to be contemptuous in the papers filed. Mr. Price questioned the jurisdiction of the court in proceeding to punish for a contempt not committed in the face of the court. It was a rule in England that no court of inferior jurisdiction should proceed by attachment to punish a party for an alleged contempt not committed in the face of the court. The mayor. This objection, if well-founded, is inconsistent with everything that had been done and ought not now to be made. This court possesses all the powers of a court of oyer and terminer over cases within its jurisdiction, and if it cannot punish for contempts like these, it had better be abolished. The court is not disposed to hear counsel on that objection singly, and wishes to know of counsel whether his clients were prepared to show cause on the merits of the charges against them. If so, the court requests all the points relied on to be stated at once. If they were not prepared, the court will give a longer time. Mr. Price for Noah and Mr. Van Wyck and Mr. Drake for Spooner filed an affidavit for each of the parties, stating in substance that in neither of the papers on which the rule was granted did they mean or intend, either directly or indirectly, any contempt of this court. The Mayor. The impropriety of publishing any matter in a public newspaper reflecting on the conduct of juries or of witnesses or of the court in any judicial proceeding while it was pending and undetermined must be manifest to all. The matters of contempt on which the rules against Noah, Phillips, and Spooner were granted at the last term related to 2 cases which were pending and undetermined at the time the publication appeared. In the one, a verdict had been rendered against the defendant, and his counsel had moved for a new trial. The court had not decided on that motion. In the other, the jurors, after hearing the evidence, could not agree and were discharged, and the case was still pending. The court is of the opinion that it can never be tolerated that any party in a judicial proceeding or any other person should be permitted to publish any matter relative to such proceeding reflecting on the motives or conduct of jurors, witnesses, or of the court while the case is pending. It is obvious that such publications are calculated not only to impeach the administration of justice, but to bias the public mind, to excite prejudices, and to influence the future decision of a case, and must therefore be considered as high contempts. In respect to witnesses and jurors, it ought to be recollected that they do not come voluntarily into a court of justice, but are compelled by the process of law. They are, therefore, entitled to the protection of the law against attacks and abuse of this kind, and if they cannot be so protected, the most dangerous consequences to the whole system of our jurisprudence would ensue. Should another case of this kind occur, we should be disposed to punish with severity, if not to the extent of our power. Under the circumstances of the present cases, believing that no contempts were intended, we shall receive the apology offered and order the rule to be discharged. Defendants discharged. End of section 66.
Section 67 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tatiana Chichilla. American State Trials, Volume 1, by John D. Lawson. Trial of Clement L. Vallandigham for Sedition and Rebellion, Cincinnati, Ohio, 1863. Part 1. The Narrative. In the second year of the War of the Rebellion, the administration of President Lincoln was hotly attacked by the Democratic opposition in Congress and in the country. The suspension by the President of the writ of habeas corpus, which made him practically a dictator, was bitterly opposed. And while at the opening of the war there were more volunteers than could be used, the enthusiasm soon subsided, volunteering almost ceased, and in March 1863, Congress authorized the President to make drafts for the national forces at his discretion. This course was declared by the Democrats to be unconstitutional, was so held by the Supreme Courts of New York and Pennsylvania, but was upheld by the federal courts. Riots broke out in New York and other large cities, which were suppressed only after bloodshed. Clement L. Vallandigham, a member of Congress from Ohio until 1862, was a leader of the radical element of the Democrats in the West, often called butternuts or copperheads, and he lost no occasion to denounce the administration. Referring to arbitrary arrests, he declared that Lincoln, Stanton, and Halleck should be arrested. Ohio was to elect a governor in 1863, and Vallandigham was an aspirant for the Democratic nomination. He went over the state making speeches bitterly denouncing the conduct of the war. He was a strong and able leader, a successful orator, a dashing politician of the Douglas type, but without the deep sincerity that characterized Douglas. The last and most violent of his speeches in this canvass was made at a great Democratic meeting at Mount Vernon. General A.E. Burnside, after his disaster at Fredericksburg, was assigned to the Department of the Ohio, with headquarters at Cincinnati. Soon after he was installed in the new position, he issued a war order stating that declaring sympathy for the enemy would not be allowed. Burnside soon had his eye on Vallandigham and sent agents in citizens' clothes to hear his speeches. These agents declared the speech at Mount Vernon incendiary, and Burnside determined to arrest Vallandigham. On May 5th at 2 o'clock in the morning, a band of soldiers beat upon the door of the Vallandigham home in Dayton, and, being refused admittance, they burst in the door, seized Vallandigham in his bedchamber, and carried him to Cincinnati. In a few days the distinguished prisoner was tried by a military court, before which he refused to plead and whose jurisdiction he denied. But the trial went on, and Vallandigham was found guilty of declaring disloyal sentiments, and was sentenced to close confinement during the remainder of the war. General Burnside approved the decision, but Mr. Lincoln commuted the sentence to banishment to the Southern Confederacy, the sentence of the court to be carried out only in case of his return. The banishment was duly executed by General Rosecrans. There was a vigorous Democratic protest from all sides against this summary dealing with Vallandigham. A great meeting at Albany, New York, strongly condemned the proceedings, and sent a set of resolutions to the President requesting, almost demanding, a reversal in the case of the Ohio statesman. Mr. Lincoln answered in a long argument for the necessity and the constitutional warrant for the system of arbitrary arrests. He touched a popular chord when, in speaking of the universal rule of inflicting the death penalty for army desertions, he said, "Must I shoot a simple-minded soldier boy who deserts, while I must not touch a hair of the wily agitator who induces him to desert?" Vallandigham did not remain long in the South. He escaped in a blockade runner and repaired to Canada. While there, he was nominated by the Democrats for governor of Ohio, and the convention that made the nomination appointed a committee of eminent citizens to address the president in favor of a revocation of the order of banishment. Lincoln offered to revoke the order if they, the members of the committee, would sign a paper promising to do all in their power to aid and encourage the Army and Navy in suppressing the rebellion. The committee replied that they would not enter into any bargains or contracts with the president for the return of Vallandigham, that they asked it as a right and not as a favor. The Ohio canvass went on, and the Democrats declared that if their candidate were elected, they would meet him at the state line and conduct him to the Capitol in such numbers as to protect him from attack. But the news from Gettysburg, from Vicksburg, and from Port Hudson was so favorable to the Union cause that the war party took new courage and swept the state, electing their candidate John Brough over Vallandigham by a majority exceeding 100,000. The trial. Before a military commission held at Cincinnati, Ohio, May 1863. Brigadier General R.B. Potter, President, Lieutenant Colonel E.R. Goodrich, Colonel John F. DeCourcy, Major J.L. Van Buren, Major J.M. Brown, Major A.H. Fitch, Captain P.M. Leidig. On April 13, 1863, Major General Burnside issued an order, General Order No. 38, which was promulgated at Cincinnati, Ohio, the headquarters of the Department of the Ohio, that hereafter all persons found within our lines who commit acts for the benefit of the enemies of our country will be tried as spies or traitors, and if convicted will suffer death. This order includes the following class of persons: carriers of secret mails, writers of letters sent by secret mails, secret recruiting officers within the lines, persons who have entered into an agreement to pass our lines for the purpose of joining the enemy, persons found concealed within our lines belonging to the service of the enemy, and in fact, all persons found improperly within our lines, who could give private information to the enemy. All persons within our lines who harbor, protect, conceal, feed, clothe, or in any way aid the enemies of our country. The habit of declaring sympathies for the enemy will not be allowed in this department. Persons committing such offenses will be at once arrested, with a view to being tried as above stated, or sent beyond our lines into the lines of their friends. It must be distinctly understood that treason, expressed or implied, will not be tolerated in this department. All officers and soldiers are strictly charged with the execution of this order. On May 4, 1863, an order was issued from the headquarters of the Department of the Ohio, by command of General Burnside, for the arrest of Honorable Clement L. Vallandigham, and that he be taken before a military commission at Cincinnati to be tried for violation of General Order No. 38. The commission met on May 6th, 7 of its members being present. Captain F.J. Cutts appeared as judge advocate. Clement L. Vallandigham appeared in person. The president asked the prisoner if he had any objection to any of the members, to which he replied in the negative. The judge advocate presented the following charge: publicly expressing, in violation of General Orders No. 38, from Headquarters, Department of the Ohio, sympathy for those in arms against the government of the United States, and declaring disloyal sentiments and opinions, with the object and purpose of weakening the power of the government in its efforts to suppress an unlawful rebellion. In this, that the said Clement L. Vallandigham, a citizen of the state of Ohio, on or about the first day of May, 1863, at Mount Vernon, Knox County, Ohio, did publicly address a large meeting of citizens, and did utter sentiments in words, or in effect, as follows, declaring the present war a wicked, cruel, and unnecessary war, a war not being waged for the preservation of the Union, a war for the purpose of crushing out liberty and erecting a despotism, a war for the freedom of the blacks and the enslavement of the whites, stating that if the administration had so wished, the war could have been honorably terminated months ago, that peace might have been honorably obtained by listening to the proposed intermediation of France, that propositions by which the northern states could be won back and the South guaranteed their rights under the Constitution had been rejected the day before the late Battle of Fredericksburg by Lincoln and his minions, meaning thereby the President of the United States and those under him in authority, charging that the government of the United States was about to appoint military marshals in every district to restrain the people of their liberties, to deprive them of their rights and privileges, characterizing General Orders No. 38 from Headquarters, Department of the Ohio, as a base usurpation of arbitrary authority, inviting his hearers to resist the same by saying, "The sooner the people inform the minions of usurped power that they will not submit to such restrictions upon their liberties, the better," declaring that he was at all times, and upon all occasions, resolved to do what he could to defeat the attempts now being made to build up a monarchy upon the ruins of our free government, asserting that he firmly believed, as he said 6 months ago, that the men in power are attempting to establish a despotism in this country, more cruel and more oppressive than ever existed before. All of which opinions and sentiments he well knew did aid, comfort, and encourage those in arms against the government, and could but induce in his hearers a distrust of their own government, sympathy for those in arms against it, and a disposition to resist the laws of the land. The prisoner asked delay to procure counsel, stating that he was engaged in preparing his plea and required advice. The commission was cleared for deliberation, and on its reopening, the judge advocate announced, as its decision, that the commission would require the accused to plead guilty or not guilty to the charge and specification, and would then adjourn for half an hour to permit the accused to procure counsel, when the commission would proceed to hear the evidence for the prosecution. The prisoner denied the jurisdiction of the commission and refused to plead. The commission directed that the plea of not guilty to the specification and charge be entered for him by the judge advocate. Witnesses for the government. Captain H. R. Hill. Am captain of the 115th Regiment Ohio Volunteer Infantry. I was present at a meeting of citizens held at Mount Vernon on or about May 1st, 1863, and heard the accused address that meeting. I was leaning on the end of the platform on which he was speaking. I was about 6 feet from him. In order to state his remarks in the order in which they were made, I will refresh my memory from manuscript notes made on the occasion. The speaker commenced by referring to the canopy under which he was speaking, the stand being covered by an American flag, the flag which, he said, had been rendered sacred by democratic presidents, the flag under the Constitution. After finishing his exordium, he spoke of the designs of those in power being to erect a despotism, that it was not their intention to effect a restoration of the Union, that previous to the bloody Battle of Fredericksburg an attempt was made to stay this wicked, cruel, and unnecessary war, that the war could have been ended in February last, that a day or two before the Battle of Fredericksburg a proposition had been made for the readmission of Southern senators into the United States Congress, and that the refusal was still in existence over the President's own signature, which would be made public as soon as the ban of secrecy enjoined by the President was removed, that the Union could have been saved if the plan proposed by the Speaker had been adopted, that the Union could have been saved upon the basis of Reconstruction, but that it would have ended in the exile or death of those who advocated a continuation of the war. That Fournier, who was a well-known correspondent of the Philadelphia Press, had said that some of our public men, and he, Fournier, had no right to speak for any others than those connected with the administration, rather than bring back some of the seceded states, would submit to a permanent separation of the Union. He stated that France, a nation that had always shown itself to be a friend of our government, had proposed to act as a mediator, but that her proposition, which, if accepted, might have brought about an honorable peace, was insolently rejected. It may have been instantly rejected. That the people had been deceived as to the objects of the war from the beginning, that it was a war for the liberation of the blacks and the enslavement of the whites. We had been told it would be terminated in 3 months, then in 9 months, and again in a year, but that there was still no prospect of it being ended. That Richmond was still in the hands of the enemy, that Charleston was theirs, and Vicksburg was theirs, that the Mississippi was not opened, and would not be so long as there was cotton on its banks to be stolen, or so long as there were any contractors or officers to enrich. I do not remember which word, contractors or officers, that he used. He stated that a Southern paper had denounced himself and Cox and the Peace Democrats as having done more to prevent the establishing of the Southern Confederacy than 1,000 Sewards, that they proposed to operate through the masses of the people in both sections who were in favor of the Union. He said that it was the purpose or desire of the administration to suppress or prevent such meetings as the one he was addressing, that military marshals were about to be appointed in every district who would act for the purpose of restricting the liberties of the people, but that he was a freeman, and he did not ask David Todd or Abraham Lincoln or Ambrose E. Burnside for his right to speak as he had done and was doing. That his authority for so doing was higher than General Orders No. 38. It was General Orders No. 1, the Constitution. That General Orders No. 38 was a base usurpation of arbitrary power, that he had the most supreme contempt for such power. He despised it, spit upon it, he trampled it under his feet. That only a few days before a man had been dragged down from his house in Butler County by an outrageous usurpation of power, and tried for an offense not known to our laws by a self-constituted court-martial, tried without a jury, which is guaranteed to everyone, that he had been fined and imprisoned. That 2 men had been brought over from Kentucky, and tried, contrary to express laws for the trial of treason, and were now under the sentence of death. That an order had just been issued in Indiana denying to persons the right to canvass or discuss military policy, and that, if it was submitted to, would be followed up by a similar order in Ohio. That he was resolved never to submit to an order of a military dictator, prohibiting the free discussion of either civil or military authority. The sooner that the people informed the minions of this usurped power that they would not submit to such restrictions upon their liberties, the better. Should we cringe and cower before such authority? That we claimed the right to criticize the acts of our military servants in power. That there never was a tyrant in any age who oppressed the people further than he thought they would submit to or endure. That in days of democratic authority, Tom Corwin had, in face of Congress, hoped that our brave volunteers in Mexico might be welcomed with bloody hands to inhospitable graves, but that he had not been interfered with. It was never before thought necessary to appoint a captain of cavalry as provost marshal, as was now the case in Indianapolis, or military dictators, as were now exercising authority in Cincinnati and Columbus. He closed by warning the people not to be deceived, that an attempt would surely be made to enforce the Conscription Act, that they should remember that this war was not a war for the preservation of the Union, that it was a wicked abolition war, and that if those in authority were allowed to accomplish their purposes, the people would be deprived of their liberties and a monarchy established. But that as for him, he was resolved that he would never be a priest to minister upon the altar upon which his country was being sacrificed. There were frames covered with canvas, all of which were decorated with butternuts. One banner, which was borne at the head of a delegation, bore the inscription, "The Copperheads are coming." I saw hundreds of the audience wearing butternuts, and many of them were wearing copperheads cut out of cents. I heard no cheers for Jeff Davis, but I heard a shout in the crowd that Jeff Davis was a gentleman, and that was what the president was not. Mr. Vallandigham. Did not the speaker refer to the Crittenden propositions and condemn the rejection of them? In endeavoring to show that the restoration of the Union was not the object of the war, he stated a number of means, this among others, by which the war could have been ended. He considered from the fact that none were adopted, that this was proof that the restoration of the Union was not the object of the war. Mr. Vallandigham. Did I not quote Judge Douglas's declaration that the responsibility for the rejection of those propositions was with the Republican Party? The judge advocate objected to the question. The commission decided that the question would not be admitted. Mr. Vallandigham. When speaking in connection with Fournier's press, did I not say that if other Democrats in Washington and myself had not refused all ideas and suggestions from some prominent men of the party in power to make peace on terms of disunion, that I believed the war would have been ended in February? When speaking of the proposition that it was not a war for the restoration of the Union, he stated that if the Democrats in Washington had united in a plan for the permanent separation of the Union, the thing would have been accomplished in February. Mr. Vallandigham. Did I not expressly refer to myself in that connection, and say that I had refused, and always would refuse, to agree to a separation of the states, in other words, to peace on terms of disunion? He stated something to that effect. He stated that he wished to have a voice in the manner of which the Union was to be reconstructed, and that he wished also our Southern brethren to have a voice. Mr. Vallandigham. Referring to the Richmond Enquirer article, did I not say that it, Jeff Davis's organ, had called upon Dictator Lincoln to lock up Mr. Cox, Senator Richardson, and myself in one of his military prisons, because of our doing so much against Southern recognition and independence? Yes, substantially, he did say so. Mr. Vallandigham. Referring to General Orders No. 38, did I not say that, insofar as it undertook to subject citizens not in the land, or naval forces, or militia of the United States in actual service, to trial by court-martial or military commission, I believed it to be unconstitutional and a usurpation of arbitrary power? He did, except the words insofar. Mr. Vallandigham. Referring to 2 citizens of Kentucky tried by military court in Cincinnati, did I not say that what they were charged with was actual treason, punishable by death, and that, if guilty, the penalty by statute was hanging, and they ought to be hung, after being tried by a judicial court and a jury? Instead of which they had been tried by a military court, as I understood, and sentenced to fine and imprisonment, one of them a fine of $300? That was, in substance, what he said. Mr. Vallandigham. Did I not also say, in that connection, that the rebel officer who was tried as a spy by the military court at Cincinnati was legally and properly tried and convicted, according to the rules and articles of war, that was a clear case where the court had jurisdiction? In my recollection, that he denounced the court as an unlawful tribunal, and that he did use the above language, and then gave the instances referred to in my direct testimony. He probably did refer to Campbell's case. Mr. Vallandigham. Did I not distinctly, in the conclusion of the speech, enjoin upon people to stand by the Union at all events, and that if war failed, not to give the Union up, to try by peaceable means, by compromise, to restore it as our fathers made it, and that though others might consent or be forced to consent, I would not myself be one of those who would take any part in agreeing to a dissolution of the Union? Yes, he said he and the peace men were the only ones who wished the restoration of the Union. Mr. Vallandigham. Did not one of the banners you refer to as decorated with butternuts bear the inscription, "The Constitution as it is, and the Union as it was"? One of them bore that inscription. Mr. Vallandigham. Do you mean to be understood to say that I heard the reference to Jeff Davis or gave any assent to it whatever? I cannot say that he did. It was said loud enough for him to hear if his attention had been directed that way. He gave no assent, neither did he give any dissent. Mr. Vallandigham. What was the size of the crowd assembled there that day? It was very large. End of section 67.
Section 68 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Clement L. Vallandigham for Sedition and Rebellion. Cincinnati, Ohio, 1863. Part 2. May 7th. Captain Hill continued. Mr. Vallandigham, in speaking of the character of the war, did I not expressly say, as Mr. Lincoln, in his proclamation, July 1st, 1862, said, this unnecessary and injurious civil war? I do not recollect that he did. The language he made use of I understood to be his own. Mr. Vallandigham, again, in speaking of the character of the war, did I not expressly give, as proof, the President's proclamation of September 22nd, 1862, and January 1st, 1863, as declaring emancipation of the slaves in southern seceded states, and as a proof that the war was now being waged for that purpose? Mr. Vallandigham, I offer this question as an explanation of the purpose and object of my declarations as to the present character of the war, and as my authority for my statement. If I stated what the President stated, I could not be held disloyal for so doing. The Judge Advocate. The question is one which clearly puts in question not the utterance of certain words, opinions, and sentiments, but their propriety, truth, and justice when uttered, and requires the Commission to pass judgment, not upon sentiments uttered by the accused, but upon certain proclamations of the President of the United States. The question is designed not to meet the merits of the case, but to prepare a record in his case of a political character, and for political uses. The President. The question will not be admitted. Mr. Vallandigham, did you continue at the same place during the delivery of the whole speech? I did. Mr. Vallandigham, were your notes taken at the time or reduced to writing after the speech was over? They were taken at the time. All I used before the court were just as they fell from his lips. Mr. Vallandigham, were you not in citizen's clothes, and how came you to be at Mount Vernon that day? Did you go to Mount Vernon for the purpose of taking the notes and reporting the speech? I was in citizen's clothes, and I went up for the purpose of listening to any speech that might be delivered at that meeting. I had no order to take notes or report. Mr. Vallandigham, did you take notes of any other speech? I commenced taking notes of the speech of Mr. Cox, but I considered it harmless after listening to him a short time, and stopped. I took no notes of any other speeches. Mr. Vallandigham, were you not expressly sent to listen to my speech on that occasion? I was not, any more than to the other speeches. Mr. Vallandigham, by whom were you sent? By Captain Andrew C. Kemper, Assistant Adjutant General of the Military Commandant of the city of Cincinnati, Ohio. I reported to Colonel Eastman himself, and from there went to Headquarters Department of the Ohio. John A. Means, am Captain 115th Ohio Volunteers, was present at a meeting of citizens held in Mount Vernon, Ohio, on or about May 1st, 1863. Heard the accused address that meeting, most of the time about 10 feet in front of the stand, directly in front. I heard the whole of his speech. He stated at one time that the war was not waged for the preservation of the Union, that it was an abolition war, that it might have been stopped or peace restored some time ago, and the Union restored if the plan which had been submitted had been accepted. The accused stated that, if the plan he had proposed himself had been adopted, peace would have been restored, the Union saved by a reconstruction, the North won back, and the South guaranteed in their rights, that our army had not been successful, that Richmond was not taken, Charleston nor Vicksburg, that the Mississippi was not opened, and would not be so long as there was cotton to sell, or contractors to enrich. He spoke in regard to the rebuke of the administration at the last fall election, that no more volunteers could be had, that the administration had to resort to the French conscription law, that he would not counsel resistance to military or civil law. That was not needed, that if people were unworthy to be freemen who would submit to such encroachments on their liberties. He was then speaking of the Conscription Act. He said he believed the administration was attempting to erect a despotism, that in less than 1 month, Mr. Lincoln had plunged the country into this cruel, bloody, and unnecessary war. He stated that General Orders No. 38 was a usurpation of power, that he despised it, spit upon it, and trampled it under his feet, and that he, for one, would not regard it. He styled the officers of the administration and the officers of the army as minions of the administration or as Lincoln's minions. I do not recall anything else. I will add that he said he did not ask Todd or Lincoln or Burnside whether he might speak as he was doing and had done, that he was a free man, that he spoke as he pleased and where he pleased. He said that proclamations and military orders were intended to intimidate the people and to prevent them from meeting as they were then that day doing, that he claimed the right to discuss and criticize the actions of civil and military men in power. He advised, at the close of his speech, to come up together at the ballot box and hurl the tyrant from his throne. In one part of his speech, he styled the president as King Lincoln. Mr. Vallandigham, did you make any notes at all of my speech, or are you testifying solely from memory? I took no notes of the delivery of the speech, but after Pendleton commenced speaking, went to the hotel and made minutes. I made those minutes an hour and a half or thereabouts after I heard the speech. Mr. Vallandigham, you speak of my saying the North might be won back. Was it not the South might be won back, her rights being guaranteed under the Constitution? No, I noticed this particularly. It struck me very forcibly. Mr. Vallandigham, you say that I said that I would not counsel resistance to military or civil laws. Did I not expressly counsel the people to obey the Constitution and all laws, and to pay proper respect to men in authority, but to maintain their political rights through the ballot box, and to redress personal wrongs through the judicial tribunals of the country, and in that way put down the administration and all usurpations of power? He said at the last of his speech to come up united at the ballot box and hurl the tyrant from his throne. I did not understand him to counsel the people to submit to the authorities at all times. I do not remember the languages stated, but part of it I remember. Mr. Vallandigham, did I not say that my authority to speak to the people in public assemblages on all public questions was not derived from General Orders No. 38, but from General Orders No. 1, the Constitution of the United States, George Washington commanding? I understood him to say that his authority to speak to the people was higher than General Orders No. 38 by that military despot, Burnside. It was Orders No. 1, signed Washington. Mr. Vallandigham, were not the words Todd, Lincoln, and Burnside used, and that I did not ask their consent to speak? He did use these words at one time. Mr. Vallandigham, were not remarks you say I made about spitting and trampling underfoot expressly applied in reference to arbitrary power generally? And did I not, in that connection, refer to General Orders No. 9 in Indiana, signed by General Haskell, denying the right to criticize the war policy of the administration? The remarks in reference to spitting upon, etc., were made in direct reference to General Orders No. 38. He, sometime afterward, in speaking of the tyranny of the administration, said that a general order had been issued in Indiana, denying the rights of the people to criticize the military power of the administration, and, if submitted to, would be followed by a similar one in Ohio. Mr. Vallandigham, were you not present in citizens' clothes? How came you to be at Mount Vernon that day? By whose order? And were you sent for the purpose of listening to and reporting the speech? I was present in citizen clothes, by order of Colonel Eastman. I was sent there to listen to the speech and report his language as near as I could, and I did make report to Colonel Eastman. The judge advocate stated that he did not propose to re-examine the witness, and having no other witnesses, would he close the testimony for the prosecution. The prisoner asked to consult with his counsel, who did not appear and had not appeared in the courtroom during the trial, before entering his defense. Witnesses for the prisoner: Honorable S.S. Cox. Footnote: Samuel Sullivan Cox, 1824 to 1889, born in Zanesville, Ohio, graduated Brown University 1846, admitted to the bar, became owner and editor of Columbus Statesman 1853, Secretary of Legation of Peru 1856, Member of Congress, Ohio, 35th, 36th, 37th, and 39th Congresses. Removed to New York 1865. Member of Congress, New York, 41st, 42nd, 46th, and 47th Congresses. Was a popular lecturer and author of a number of books. End of footnote. I was present at a public political meeting of citizens of Ohio at Mount Vernon on Friday, May 1st, 1863, as one of the speakers. I heard the speech of Mr. Vallandigham that day. Before the speaking began, I was on the stand a few feet from Mr. Vallandigham, most of the time standing near him, so that I could not fail to hear all that he said. I do not think my attention was distracted but for a few moments during the entire speech. I had not heard Mr. Vallandigham speak since the adjournment of Congress, and as I came in from the West, I did not know that he was to be there. I took an especial interest in listening to his speech throughout, Having to follow him, I naturally noted the topics which he discussed. The only allusion he made to General Burnside was, I think, near the beginning of his speech, in which he said he was not there by the favor of Abraham Lincoln, Governor Todd, or Ambrose E. Burnside. No epithet was applied to him during the speech. If there had been, I should have noticed it, because General Burnside is an old friend of mine, and I should have remembered any odious epithet applied to him. The only reference made to Order Number 38 was something to this effect, that he did not recognize, I do not know that I can quote the language, Order Number 38 as superior to Order Number 1, the Constitution, from George Washington, commanding. I cannot recall any denunciatory epithets applied to that order. I did not hear any that I can remember. The only criticism I heard was that in reference to the Constitution. Mr. Vallandigham discussed these matters very briefly, taking up the larger portion of his speech with another proposition. The other proposition was in connection with closing of the war by separation. He charged that men in power were willing to make peace by separation. He exhausted some time in reading proofs from publications of Montgomery Blair and Fournier. He also stated there were private proofs yet to be disclosed, which time would disclose. He said they pursued this thing until they found that Democrats were unwilling to make peace, except upon a basis of the restoration of the whole Union. He denounced bitterly any attempts to restore peace by a separation of the states. He denounced, in strong language, any usurpation of power to stop public discussions and the suffrage. He appealed to the people to protect their rights as a remedy for every grievance of a private nature. He counseled no resistance except such as might be had at the ballot box. Nothing said by him at all, looking to forcible resistance of either laws or military orders. He stated the sole remedy to be in the ballot box and in the courts. I remember this distinctly, for I had been pursuing the same line of remark in Chicago and Fort Wayne, and other places where I had been speaking, and with the purpose of repressing any tendency toward violence among our democratic people. My best recollection is that Mr. Vallandigham did not say a word about the conscription. He did refer to the change in the policy of the war, and I think devoted some time to show that the war had been deviated from a war for the restoration of the Union into a war for the abolition of slavery. He referred in that connection to the Crittenden resolutions, declaring the war to be one for the restoration of the Union, and not to break up the institution of a state. He occasionally used the words, the President and his minions, but I did not understand him to use them in connection with the army. It was not in that connection. It was in connection with arbitrary arrests. He applied some pretty strong epithets to spies and informers, whom he did not seem to like very much. I remember the metaphor that he would not be a priest to minister at the altar of disunion. He was speaking about the Union and his attachment to it. He invoked the people under no circumstances to surrender the Union. The witnesses, Lockie Harper, J.D. Irvine, and Frank H. Hurd, summoned for the defense, not having appeared, the judge advocate stated that it would avoid an adjournment. He would admit that they, if present, would, under oath, testify substantially the same as Honorable S.S. Cox. Thereupon the prisoner stated that he would close his defense and offer no further testimony. The judge advocate stated that he did not propose to offer any further testimony. The prisoner then read to the commission the following: arrested without due process of law, without warrant from any judicial officer, and now in a military prison. I have been served with the charge and specifications as in a court-martial or military commission. I am not in either the land and naval forces of the United States, nor in the militia in the actual service of the United States, and therefore am not triable for any cause by any such court, but am subject, by the express terms of the Constitution, to arrest only by due process of law, judicial warrant, regularly issued upon affidavit, and by some officer or court of competent jurisdiction for the trial of citizens, and am now entitled to be tried on an indictment or presentment of a grand jury of such court, to speedy and public trial by an impartial jury of the state of Ohio, to be confronted with witnesses against me, to have compulsory process for witnesses in my behalf, the assistance of counsel for my defense, and evidence and argument according to the common law and the ways of judicial courts. And all these I here demand as my right as a citizen of the United States, under the Constitution of the United States. But the alleged offense is not known to the Constitution of the United States, nor to any law thereof. It is words spoken to the people of Ohio in an open and public political meeting, lawfully and peaceably assembled under the Constitution and upon full notice. It is words of criticism of the public policy of the public servants of the people, by which policy, not by force, but by free elections and the ballot box, promoted. It was an appeal to the people to change their policy, not by force, but by free elections and the ballot box. It is not pretended that I counsel disobedience to the Constitution, or resistance to laws and lawful authority. I never have. Beyond this protest, I have nothing further to submit. The judge advocate stated that he had no reply to make to the statement of the accused, insofar as it called in question the jurisdiction of the commission. That question had been decided by the authority convening and ordering the trial, and he was not called upon to discuss it, nor had the commission been willing at any time to entertain it. Insofar as any implications or inferences designed or contemplated in the statement of his right of counsel and to have witnesses summoned for his defense were involved, the judge advocate had summoned such witnesses as the accused had requested, and he had had the benefit of 3 lawyers of his own choice as counsel, who had, however, remained continuously in an adjoining room during the continuance of the trial. The accused himself, for some reason unknown, not having introduced them before the commission, though the commission had expressly authorized him to do so, and had adjourned to permit his obtaining their presence. The facts alleged in the specification were to be decided upon the evidence before the commission, and he believed it unnecessary to comment thereon. The question of the criminality of the facts alleged, if proved, was also a question purely for the commission, and which the judge advocate deemed it unnecessary to enforce by argument. He, therefore, without further comment, submitted the case to the consideration of the commission. The commission was cleared for deliberation. The verdict, May 16th. The commission, after mature deliberation on the evidence adduced and the statement of the accused, find the accused, Clement L. Vallandigham, a citizen of the state of Ohio, as follows. Of the specification, except the words, that propositions by which the northern states could be won back, and the South guaranteed their rights under the Constitution, had been rejected the day before the Battle of Fredericksburg by Lincoln and his minions, meaning thereby the President of the United States and those under him in authority, and the words, asserting that he firmly believed, as he asserted 6 months ago, that the men in power are attempting to establish a despotism in this country, more cruel and more oppressive than ever existed before. Guilty, and as to these words, not guilty, of the charge, guilty, and the commission do therefore sentence him, the said Clement L. Vallandigham, a citizen of the state of Ohio, to be placed in close confinement in some fortress of the United States, to be designated by the commanding officer of this department, there to be kept during the continuance of the war. The finding and sentence of the prisoner was at once confirmed by General Burnside, who designated Fort Warren, Boston Harbor, as the place of his imprisonment. But on May 19th, President Lincoln ordered that he be sent outside of the military lines on pains of imprisonment in case of his return. On May 9th, in the Circuit Court of the United States for the Southern District of Ohio, Judge Leavitt presiding. Footnote: Humphrey Howe Leavitt, 1796 to 1873. Born in Suffield, Connecticut. Removed to Ohio. Member State Legislature, 1825. State Senate, 1827. Representative in Congress, 1831 to 1834. Afterwards, for many years, Judge of the United States District Court for Ohio. End of footnote. The prisoner, by his counsel, Honorable George E. Pugh, applied for a writ of habeas corpus. The writ was refused. Footnote: George Ellis Pugh, 1822 to 1876, born in Cincinnati, Ohio, member Ohio Legislature, 1848, City Solicitor, Cincinnati, 1850, Attorney General of Ohio, 1851, United States Senator, 1855 to 1861. Order of the President, U.S. Military Telegraph, May 19, 1863. Cipher: to Major General Burnside, Commanding Department of the Ohio. Sir, the President directs that, without delay, you send C.L. Vallandigham under secure guard to the headquarters of General Rosecrans, to be put by him beyond our military lines, and that in case of his return within our lines, he be arrested and kept in close custody for the term specified in his sentence. By order of the President, Ed M. Canby, Brigadier General and AAG. End of section 68.
Section 69 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. The Trial of Moses Simons for Assault and Battery, New York City, 1818. The Narrative. Even in New York in the second decade of the 19th century, the race question was a live one. Moses Simons was the son of wealthy parents. He was a member of the bar of the metropolis of America, and was a man of good manners and address, but he was a mulatto. He associated with white men in his profession. He lived at the best hotels and dined at the best restaurants, but it was always on sufferance, and before long objections by other patrons caused him to change his landlord. He even attended the public dancing academies and danced with the white young ladies, but this soon attracted attention, criticisms and complaint being made to the dancing master. He was refused entrance one night, even after a ticket had been sold to him. He was angry and struck the proprietor, whereupon he was arrested, convicted, and fined for assault and battery. The Trial. In the Court of General Sessions, New York City, February 1818. Jacob Radcliffe, Mayor. John B. Coles, Reuben Munson, Alderman. February 2nd. The defendant, a member of the Bar of New York, was indicted for an assault and battery committed on Charles Barrett on the 8th day of January last. Hugh Maxwell, District Attorney for the People, Mr. Bogardus, and Mr. Fay for the defendant. Charles Barrett. I am a Frenchman and a dancing master. I have had under my professional care for a long time a great number of youths of both sexes in this city. My place for instruction is a public ballroom at Washington Hall, which I rent for this purpose. Any gentleman not belonging to the school, wishing to participate in the amusement with the scholars, may attend on particular days in the week by purchasing for $1 of the barkeeper a ticket, which, on being presented to the doorkeeper of the dancing room, entitled the holder to admittance. Dances at which these not belonging to the school are admitted are called public dances. On December 20th, in the evening, defendant, with his brother, attended one of the publics, and at that time my scholars expressed no particular disapprobation. Defendant and his brother came again. I was afterward informed by several of my scholars that their presence was generally disagreeable to the school, and that, unless they were excluded, a great number of the scholars would leave. Several scholars communicated the same idea to Mr. M'Intyre, the keeper of Washington Hall, who informed me of it. A few evenings later the defendant and his brother came a third time, and as soon as I saw them I took them apart from the others in the ballroom and, confidentially, imparted to them the disapprobation expressed by the scholars, at the same time informing them, as for myself, I had no objection to their being there, but that I was fearful of the loss of many of the scholars, should they continue their attendance. Both appeared to be perfectly satisfied with my explanation, and defendant announced that if I would permit them to take a turn or two in the room, as if nothing had happened, they would then leave the school. This request I granted, and they went away. On the evening of January 8th, laid in the indictment, defendant, having purchased of the barkeeper a ticket for admittance, came to the door, when the doorkeeper, according to my direction, refused him admittance. Hearing the altercation at the door between defendant and the keeper, I came up and informed the defendant that he could not be admitted, and that I, Barrett, had written him a letter which ought to satisfy him. He demanded that I give him the names of the persons who had expressed their disapprobation at the attendance of his brother and himself. I informed him that this request was impossible. He said that he would not believe me unless I would give up those names, and as I was turning to go into the ballroom, he slapped me in the face. The defence. Mr. Fay. The defendant will show that he is an accredited gentleman, that he received a liberal education in one of the best universities in the country, and that his connections are wealthy and respectable. Defendant, on this occasion, having purchased a ticket which entitled him to an admittance, was refused by the master, and in a momentary excitement of passion, while smarting under the indignity offered his feelings, he inflicted the blow. We will contend that the master, by his outrage, was, in fact, the first aggressor. He thereby struck the first blow, and had no right to complain. The defendant will further rely on the Constitution, which has declared all men equal, and the constituted authorities of the country, by whom he has been admitted by a member of an honourable profession, and, in fine, he will make his appeal to the sympathies and moral feelings of the jury, for an enlightened community will be ready to sanction this philanthropic sentiment, though varied from the words of the poet. Honour and shame from no complexion rise, act well your part, there all the honour lies. Mr. Van Dusen. On the evening of the assault and battery, the defendant purchased a ticket and came to the door of the ballroom. Barrett requested defendant not to go in, and it was my impression that Barrett shoved or pressed against Simons to prevent his entrance. Defendant requested the master to give up the names of those who had objected to his attendance, which request Barrett refused to grant. Cross-examined. The words spoken by Simons, prefatory to the blow, were, "If you will not give up the names, take that." Several witnesses testified that defendant is reputed to be the nephew of Solomon Simons, a wealthy and respectable man, at Savannah, where he received the rudiments of his education, and came into the northern states well recommended by several gentlemen of respectability. Among them was General Porter. Defendant was placed at an academy in one of the towns in Connecticut, and while there, boarded at the house of one of the first families in that state. Having finished his preparatory studies in the academy, he entered New Haven College, and during his continuance there, associated with students, the sons of respectable gentlemen, and attended the public halls. He then removed to Litchfield, in the same state, and commenced the study of the law, at Judge Reeves' Law School. He finished his legal studies at Albany, in the office of Abraham Van Vechten, an eminent counsellor of that city. While at these several places, his general character and deportment were good, and he had uniformly associated with persons of respectability. At Albany, he boarded at Gregory's Hotel, where the first gentlemen in the country were entertained. Edward C. Jennett. Have known the defendant since 1812. While with Mr. Van Vechten, defendant was much respected, and no other prejudice existed against him except that, on account of his complexion, and that not among persons of an enlightened mind. Defendant is a person of a nice, delicate sense of honour, and under the peculiar circumstances in which he is placed, his demeanour has been as prudent and discreet as possible. Rebuttal. Israel Purdy was a subscriber of Barrett, and attended the publics. The dissatisfaction of his attendants and his brother, which was pretty general in the school, rested solely on the ground of their complexion. The blow given by the defendant to Barrett was an act of retaliation. Peter Emmentire. Am the keeper of Washington Hall. The school consists of 600 or 700 young persons of both sexes. 10 or 12 of the gentlemen scholars complained to me that Barrett had admitted 2 coloured men into his public, and that if he continued to do so, they would leave the school. One of these young men told me the defendant's brother had dances with the handsomest girl in the school. I imparted these complaints to Barrett. I keep a public ordinary for gentlemen, and defendant, some time ago, dined there, and once an objection was made by a gentleman to the attendance of defendant at the dinner table. William B. Cozzens. Am a member of the firm of Marling and Cozzens, keepers of Tammany Hall. A public ordinary is kept at our house. Defendant used to dine there. I have heard frequent complaints, especially from southern gentlemen, against defendant's dining at the same table with them. I mentioned this to defendant, in a confidential manner, and he withdrew his attendance. Though I do not know whether I would have had a legal right to exclude defendant from the ordinary, yet I have no doubt this measure, on the score of interest, would have conduced to the advantage of my establishment. William L. Rose. I am a counsellor at law. I boarded at Tammany Hall while defendant attended the ordinary there. The dissatisfaction at his being at the table was general among the guests of Marling and Cousins. John Watts, for defendant. The defendant boarded at Gregory's Hotel in Albany, and while there, gentlemen of the first respectability resorted to the house, and dined at the same table with defendant. Among the rest, I recollect that Governor Ogden of New Jersey dined at Gregory's, and, in a friendly manner, shook hands with the defendant. His character is perfectly fair and unexceptional. Mr. Maxwell. Dr. Watts, suppose you had a sister at the dancing school, or at a public ball, would you be willing that she should dance with the defendant, however fair his character may be? Mr. Attorney, I have my private opinions, and those opinions are sacred. I shall, therefore, decline answering your question. Mr. Fay summed up the case to the jury, and Bogardas followed him. Mr. Maxwell summed up on behalf of the prosecution. The Mayor, to the jury. The determination of this case does not depend upon the rules of politeness, and much of the matter brought into discussion is foreign to the issue. The only point in the case is, whether the defendant is guilty of an assault and battery on Bornt. It appears that from the testimony, that defendant and his brother, being at the schoolroom of Bornt, were apprised by him, in a confidential manner, that their attendance was a matter of dissatisfaction to the scholars. On this suggestion, defendant appeared satisfied, and with his brother departed. Some time afterwards he purchased a ticket and came to the schoolroom door for admittance. After what had previously taken place, it will rest with the jury to say whether this conduct does not indicate an intention on his part of making a disturbance. It cannot be denied that the master, having hired that room for a specific purpose, had the right of excluding any person he thought proper, but it is urged that if he exposed tickets for sale in a public bar-room, whoever purchased had a right to be admitted, and that, had the master wished to exclude the defendant, the barkeeper should have been instructed not to sell him. But it will be easily perceived that this precaution could not have produced the effect, for any person, however obnoxious to the master and his scholars, could have purchased a ticket by sending another person to the barkeeper. The purchase of this ticket, admitting it to have taken place by the permission of Barrett, created a private contract between him and defendant, and the refusal on the part of the master to admit the defendant might, perhaps, entitle him to a suit to recover back the money paid, with such damages as he had sustained. But it does not appear that this assault and battery was committed by defendant while endeavouring to press his way into the room, in pursuance of his rights, but for the purpose of retaliating for that which he conceived to be an injury or insult. Should the jury believe this, it will be their duty to convict him. Verdict, guilty. Defendant fined $10 and costs. End of section 69, read by Inkell.
Section 70 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Joel Clough for the murder of Mary W. Hamilton, New Jersey, 1833, Part 1. The narrative. This is the old story of love and jealousy. At the boarding house and private inn of Mrs. Longstreth, at the village of Bordentown in New Jersey, in the year 1833, there lived her daughter, Mrs. Hamilton, the widow of a physician, and one Joel Clough, who had been a contractor and was a man of some intellect. He fell violently in love with the widow, but she gave him little encouragement, and finally let him know positively that she would not marry him. This seems to have affected him very much. He took to drink, and entered on a carouse which lasted several weeks in the neighboring cities of Pennsylvania, New York, and New Jersey. Then he came back to Mrs. Longstreth's house. Mrs. Hamilton and the family treated him in a friendly way, because he complained of being ill and spent part of the time in bed. Finally, his passion urged him to take revenge, and one day, After leaving the table and going to his own room on the plea of illness, he asked Mrs. Hamilton to come in and speak to him. She did so, whereupon he seized her and with the dirk which she had given him as a present some days before, stabbed her in more than a dozen places. The noise alarmed the family and some of the employees in the neighboring inn, who at once rushed upstairs, but seeing the dirk, most of them rushed down again for weapons. Mrs. Hamilton stumbled downstairs into her mother's arms and died. At the trial there was great excitement. Eminent counsel for the prisoner were brought from New Jersey and Philadelphia, but the plea of insanity had little to sustain it, and Clough was speedily convicted. Later he managed to escape from the jail where he was confined, but he was soon captured and expiated his crime upon the gallows. The trial. Footnote. Bibliography. Reported the trial of Joel Clough on an indictment for the murder of Mrs. Mary W. Hamilton before Chief Justice Hornblower and 4 associate judges at Mount Holly, New Jersey, in June 1833. Boston, published by Beals, Homer and Company, No. 36 Congress Street, 1833. The preface says, "This is one of the most interesting trials that has taken place in this country for many years, and with the exception of that of the Reverend Mr. Avery, it has produced quite as much excitement as any other capital trial on record. Mr. Clough is a native of New Hampshire, and is said to have an extensive acquaintance in this quarter. A correspondent of the Newark Daily Advertiser, who appears to have had a favorite opportunity for observation in the courtroom, gives the annexed interesting account of the murderer. The prisoner is, I suppose, about 28 years old. He looks very pale but rather genteel in his person and dress, and seems as if he paid much attention to his toilet. Upon taking his place in the prisoner's box, he looked up to the Chief Justice and made a graceful bow, and while the indictment was read to him, he stood erect, firm, and composed. Not a muscle of his face moved, and to the thrilling question, "Are you guilty or not guilty?" he responded in a low, soft, but yet in a firm and distinct voice, "Not guilty, sir." Friday morning was then assigned for his trial. Long before the bell rung for court on that morning, the people were pressing into the courthouse, and the crowd was so great that the sheriff had to conduct the Chief Justice through a back door into his seat. Pretty much all the female fashion and beauty of Mount Holly were present, from 100 to 200 ladies. The venerable and respected mother and sister of the deceased, and other females and members of the family, were examined on the first day. As they severally turned to look at the prisoner, when asked by the counsel if they recognized him, he, familiarly and gracefully, but with a fixed and rather gloomy countenance, inclined his head, or bowed to them, and when the old lady, with the tears running down her cheeks, turned quite round to look at him, he instantly rose and bowed to her in the most grave and respectful manner. The testimony was of the most thrilling and touching character. The description of her, Mrs. Hamilton's delicate person, her amiable character, her piercing shrieks, and her death struggles, while he held and pushed still deeper and deeper the murderer's dirk into her bosom, was truly affecting. But when the trunk was opened and the blood-stained dirk, the broken breastpin, her bloody garments, especially her corsets, pierced with 10 holes through that part of it which had covered her left breast, and stiffened and red with the cold blood of her that had worn it, as if it had been literally dyed in blood. It seemed too much for everyone but the prisoner. He looked upon the bloody credentials with a steady, gloomy gaze, discovering in his countenance, however, no internal emotion, nor in the least changing his position, which he uniformly occupies, reclining on his elbow and resting his head on the palm of his hand, on which he wears a black glove. But the effect of this exhibition, followed up by the physician's description of her broken ribs and almost riddled heart and lungs, produced a gust of feeling and emotion in the crowded audience that could not be suppressed. Every bosom swelled, Every eye was suffused with tears, and for a few moments the investigation was suspended. Throughout this protracted trial, during which an immense mass of testimony was received, not a blot or stain was affixed to the character of the lamented Mrs. Hamilton. Her reputation, adorned by every virtue that can dignify and beautify her sex, was most triumphantly sustained, and she was proved to have been chaste, beautiful, urbane, and lively, and as pure as the unclouded sky. During the recital of the tragic story of her death, many a manly cheek was bathed with tears, and the affecting relation of it by her mother was almost overwhelming. The object of the counsel for the defense was evidently to prove the insanity of the prisoner, and to attain this, their utmost efforts were directed, with what success the public must judge. The ability and fidelity, however, deserves great praise, as did also the efforts of the counsel for the prosecution. The only true and authentic confession of Joel Clough, containing his life and confession from 14 years of age, anecdotes, letters, escape, capture, etc., written by himself and placed in the hands of one of his attorneys for publication. Copyright secured, Philadelphia. Published by Robert De Silva. Number 110 Walnut Street. The title page has a picture of a man hanging on a gallows and below a coffin. There is a good page-size engraving of Clough, from the original miniature delivered by Clough to Mr. Shin, and to be sent to his mother. The portrait is that of a good-looking and intelligent man, dressed in the white collar coat and the high black stock of the day. The appendix contains a letter from Clough to his mother, written 48 hours before his execution, and letters from his two brothers to him after his conviction. End of footnote. In the Supreme Court of New Jersey, Mount Holly, May 1833. Honorable Joseph C. Hornblower, Chief Justice, and 4 Associate Judges. Footnote. Joseph Curtin Hornblower, 1777 to 1864, born in Belleville, New Jersey. Chief Justice of New Jersey, 1832 to 1846. End of footnote. May 31st. The prisoner, having been indicted for the murder of Mary W. Hamilton, was arraigned and pleaded not guilty. After 23 peremptory challenges and 7 for cause, the following were sworn as jurors: Amos W. Archer, Samuel Ridgway, Joseph Kirkbride, Samuel B. Finch, Joseph Deacon, James Logan, Absalom H. Smith, John C. Ridgway, Peter Crozer, George Black, Richard J. Bond, William Stokes. Chief Justice Hornblower. There are, I am told, some gentlemen of the press present from Philadelphia and New York for the purpose of reporting this case for publication. Now I strictly enjoin them as a duty they owe to the cause of justice to withhold their publication of the proceedings until its first termination. Footnote. Until the verdict of the jury, they severally acceded to the reports as the reporter of the trial. End of footnote. The indictment consisted of 2 counts, the first charging the prisoner at the bar with having, on the 6th day of April 1833, in the village of Bordentown, township of Chesterfield, and in the county of Burlington, murdered Mary W. Hamilton by thrusting and striking her with a dirk in her left breast, through the same and into her heart, inflicting a wound 3 inches deep and 1 inch wide, and thereby causing her death in 15 minutes thereafter. The second count charged the prisoner with inflicting 3 several mortal wounds in the left breast with a dirk, 3 inches deep and 2 inches wide, of which wounds the said Mary W. Hamilton died. John Moore White, Attorney General, Samuel L. Southard, and Joseph Warren Scott for the state. Footnote. John Moore White, 1770 to 1862, Attorney General of New Jersey, 1833 to 1838, Associate Justice of the Supreme Court of New Jersey, 1838 to 1845. Samuel Lewis Southard, 1787 to 1842, born in Baskinbridge, New Jersey, member New Jersey Legislature 1815, Judge Supreme Court 1815, U.S. Senator 1821, 1833 to 1842, Secretary of Navy 1830, Governor of New Jersey 1832, Joseph Warren Scott 1778 to 1871, was profoundly learned in the law and had a large and lucrative practice. He was appointed prosecutor of the police for the county of Middlesex, New Jersey, but beyond this, he never held any official position. He was Treasurer General of the General Society of Cincinnati and President of the New Jersey Society. End of footnote. David Paul Brown, Isaac Hazelhurst, and George Camblos for the prisoner. Footnote. Isaac Hazelhurst, 1808 to 1891, born in Philadelphia, admitted to the bar of Philadelphia 1831, city solicitor 1854, trustee Pennsylvania Institute for Deaf and Dumb, member state legislature, and was National American candidate for governor of state of Pennsylvania. George W. Camblos was admitted as attorney to the New Jersey Bar September term, 1829, but never became a counselor. End of footnote. The Attorney General. This is a case of murder, and one of the few which, by laws of the state, is punishable with death. This fact renders the issue of this trial all important to the defendant, between whom and the country you are bound to pass. In presenting before you all the facts of the case, it is particularly incumbent upon you to give them your due weight, and to consider them seriously and impartially, in order to ascertain the guilt or innocence of the prisoner at the bar. In the decision you give to this important subject, you are to show your regard for that country whose laws have been broken by the willful and deliberate murder of a helpless, innocent, and virtuous female. And you are so to deliberate upon and consider this subject, that the counsel of both the prisoner and the country may implicitly rely upon your intelligence and good faith to give it a fair, a full, and an honest decision. It is one of those cases which, from its character, and the proof on which it rests, will relieve you from much of the difficulty usually involved in trials of this kind, whether to convict the accused of murder or manslaughter. You will not doubt the murder with which the prisoner stands charged. You will not doubt who gave the fatal blow of which Mrs. Hamilton died, and there will be no difficulty in relation to the manner or the cause of her death. Everything will be made out with such perfect clearness that it will stand before you in unerring certainty as a case of murder. If the facts are proved to your entire satisfaction, you can have no doubt of the prisoner's guilt. Witnesses for the state. Mary Imlay. I know the prisoner at the bar. I knew him at Bordentown, at Mr. Thompson's, where he boarded and where I first saw him, not more than 2 years ago. He afterwards left and went to board at Mrs. Longstreth's, was in the family part of the time he was there. On the day of the murder, he breakfasted with the family, and there were present at table 3 gentlemen, Mrs. Hamilton and Mrs. Longstreth. I was making dresses, in which Mrs. Hamilton assisted me. The prisoner at breakfast was polite in helping the company. He took the little daughter of Mrs. Hamilton, about 8 years old, on his lap, patted her cheeks, and talked to her about her lessons at school. He wished Mrs. Hamilton to accept a notebook for her daughter, as he did not want it, which after some reluctance she did. Soon after he left the room, said he was going to lie down, and I saw him no more until after Mrs. Hamilton was murdered. On Saturday, between 12 and 1 o'clock, Elizabeth, the little sister of Mrs. Hamilton's, came downstairs and alarmed the house by saying that someone was murdering her sister. Mrs. Longstreth and myself immediately left the room. I went to the back entry door and let Mrs. Longstreth go on first. She went upstairs into the room where Mrs. Hamilton, her daughter, was, lifted her hands and screamed, did not see Hamilton until after she was dead, which was near half an hour after she left the room. Mary Brittenham, Hannah Herbert, Mrs. Reeves, and some others were with me when I saw her dead. Cross-examined. Lived in the house with Clough only 2 days. Had seen him frequently, but had nothing more than a mere speaking acquaintance with him. Never saw him at Mrs. Longstreth's before. He was between meals, sometimes in the room with Mrs. Hamilton. On Friday evening before her death, he went to the post office to get letters, and Mrs. Hamilton told him to see if there were any for her. He went upstairs to lie down every day. He said he had had an attack of the pleurisy, and had not got well of the pain in his side and breast. In the parlor, Clough and Mrs. Hamilton were speaking in a familiar and friendly manner together, and I saw no difference between the last interview and other times. Anna P. Longstreth. Have known the prisoner about 1 year. He lived at my mother's, Mrs. Longstreth. I was at home at the time of the murder. First saw Clough about 7 o'clock that day in the front parlor. It was on Saturday, the 6th day of April last. He breakfasted with the family. As he went upstairs, I went up immediately after him into the family room. As I was going up with a skein of yarn in my hand, I told him if he did not get out of the way, I would throw it at him, which I did in sport. He said he was going to lay down. The passage to his room was up that pair of stairs, and so was that to the family room, and he had to pass the door of the latter room to get to his own. I went downstairs and saw my sister, Mrs. Hamilton, again in the parlor. Did not see Clough again until Mrs. Hamilton's death, when he was in the yard. They were taking him away. It was not half an hour after I saw Mrs. Hamilton in the parlor until her death. Cross-examined. I am the daughter of Mrs. Longstreth. Had been absent from home, but returned about a year before my sister's death, when I found Clough there. While there, he was upon good terms with the family. Don't know of any personal difference between him and any member of it. He was kind and attentive to all, and they to him. Don't know that he was more attentive to Mrs. Hamilton than to any of the rest of the family, and he was not treated with more kindness by them than the other boarders were. Don't know of any presents that he ever gave to Mrs. Hamilton. He gave her daughter a pair of earrings and side combs on condition of her getting the premium at school, and also gave her a geography and atlas. Don't recollect his ever presenting Mrs. Hamilton with a gold watch and gold rings. She went with her cousin, Mary Thorne, and Mr. Clough accompanied them to Philadelphia, but did not return with them, but came back some time afterward. At that time, Mr. Clough had a contract on the Schuylkill. Mrs. Hamilton had a large silver watch, and she said she got it exchanged for a small gold one. I do not know that she exchanged watches with Clough, or that he ever had the silver watch that belonged to Mrs. Hamilton. He had the same watch when he returned as when he went away. I don't know of his giving her any jewelry, or with having gone with her on any other journey. He once brought my mother a box of oranges, and was very attentive to her when she was sick. He left the house on Thursday week before my sister's death, professed leave for New York, and parted on friendly terms with the family. He was absent about 2 weeks, and was thinner, and did not look so healthy when he returned as when he left. His kindness to the family appeared to be the same. After his return during the week, he said he did not feel very well, and was occasionally confined to his bed, though he generally ate his meals regularly. He never complained of illness and expressed a wish to lie down until after his return from New York. Elizabeth Longstreth. Am 13 years of age. Am Mrs. Hamilton's sister. Have lived a year or 2 with mother, Mrs. Longstreth, and Clough lived there also. I recollect Clough's leaving the last spring and going to Rochester, as he said, he being absent about a week, and returning on Thursday in April last. Saw him on Saturday morning and did not see him again until after he returned home from school at 11 o'clock. I was then in the family room upstairs with Caroline, the little daughter of Mrs. Hamilton. The latter came upstairs, looked into the room, and censured us for not wearing our aprons. Mrs. Hamilton then left the room, and soon after I heard her screaming. I stepped out, went into the entry, met the servant girl, Jane, who told me to open Clough's door. I tried once and failed. I did not lift the latch, but the second time I tried, I succeeded, and both Clough and my sister Mary came out. I stepped back into a small room over the bar, and when I looked again, they were both down on the floor. He was holding a dirk up over her. I took hold of his arm, pulled it back, and cried out, "Oh, don't!" But he did not look up. I ran down to the bar-room door and called to Mr. Brown in the bar and told him to go upstairs as somebody was killing my sister. They were lying on the floor in the entry, near the garret steps, and near the door of Clough's room. Did not see Clough strike her, and did not hear him or her say anything. He had hold of Mary. Cross-examined. Clough had been on good terms with Mrs. Hamilton, and there was no unkindness between them. Never knew of his giving her presents or going on a journey with her. Sister's room was the family chamber, and Clough's apartment was next door but one to it, 2 or 3 steps higher. When Mrs. Hamilton was on the floor, she struggled and tried to escape from him. He had hold round her waist with one of his hands when they were standing up, and she trying to get away. I saw no appearance of blood, but thought I saw him hold something up, but cannot tell what it was. When they were on the floor, I thought it was a razor. It shined when they were in the room, she struggling to get out, and he before her trying to hold her. I turned my face round, and when I looked again, he had her down and was standing over her. Jane Brown, a colored servant, lived with Mrs. Longstreth, worked for my victuals and clothes. Clough lived at Mrs. Longstreth's all the time that I did. I saw Clough on Saturday come down to breakfast, and saw him afterwards in his own room. Mrs. Hamilton came upstairs, and she said it was 12 o'clock. I asked her if she had heard Mr. Clough call her. She said she did, and was going in to him. I was in my room next to the garret stairs and next to Clough's. I heard some noise very soon after Mrs. Hamilton left me. It was in Mr. Clough's room. Elizabeth and myself both went to the room door, pushed, but did not raise the latch. I first thought the noise was like a dog's, and called to Elizabeth to come, but I thought there was a dog in Mr. Clough's room. We raised the latch. The second time we pushed, it opened, and I saw Mr. Clough put a dirk into Mrs. Hamilton. He got the point in as far as it would go, and tried to get the handle in. They were standing on the floor right against the door. I did not hear him strike but once. He had one hand round her waist, and the dirk in the other, while in the room. When I first saw her come out of the room, the dirk was in her. I saw them also in the entry, she lying down and struggling to get away from him, and he over her. They walked out of the room, he having hold of her all the time. Cross-examined. I don't know how old I am. When Clough called for Mrs. Hamilton, he said, "Mrs. Hamilton, Mrs. Hamilton, will you please come here a minute?" I saw her go into his room, saw a little of the blade of the dagger which I never saw before. Don't know what kind of a blade or handle it had. Never saw any dagger before. Elizabeth and myself both stood near the door till we saw the dagger's blade, because he pulled it out of her and stuck it in another place again. We did not know what it was then, but Elizabeth said it was a razor. Saw it afterwards when I followed Amy upstairs. She said it was a dagger. Amy Wright lived at Mrs. Longstreth's at the time of Mrs. Hamilton's death, which was 6th April. Saw Mrs. Hamilton after breakfast when I was upstairs making the beds in the front part of the house. She came to me with a cloak in her hand and said, "Here, Amy, if I should not be here next week, take care of this cloak. There is a lady who left it here, and who would likely call for it." I saw her again about 11 o'clock. Mrs. Longstreth had got some new bureaus, and Mrs. Hamilton said she would have part of them for her own use. Heard something like a child cry, and thought it was one of the children. Then heard it louder and louder. Ran up and stood on the landing of the steps. Saw Clough and Mrs. Hamilton standing in Clough's door. He had one arm, his left, around her. She appeared to be endeavoring to get away from him. He looked at me so wicked that it frightened me, and I went down. I waved my hands and said to Mr. Brown and Mr. Ralph Titus at the barroom door, "I beg you to come upstairs and see what is the matter." I then went down to the kitchen door and then returned upstairs and stood on the landing, and Mrs. Hamilton, coming down the platform, said, "Oh, I am done," and her mouth was all gore of blood. Her mother, Mrs. Longstreth, met her in a lower entry about halfway of its length, opposite the room door, where Mrs. Hamilton exclaimed, "Oh, mother, mother, I screamed, and why did you not come and help me?" As she uttered this, she fell leaning on her mother's shoulders. I returned into the kitchen and did not see her again until half an hour, when she was laid out on the settee. Cross-examined. When I came to live with Mrs. Longstreth, I found Mr. Clough there. He was on the kindest terms with Mrs. Hamilton and all the family. For some days before the murder, he did not appear to be as lively as he had been. End of section 70. Section 71 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Joel Clough for the murder of Mary W. Hamilton, New Jersey, 1833, Part 2. June 1st. Elizabeth Longstreth. Am the mother of Mrs. Hamilton, the deceased. I reside at Bordentown, where I have kept a public house 2 years. The prisoner came there in June 1831. It has been his home, but he has not been there all the time. He left my house last spring, and I understood he went to New York, whence he returned on the 4th April last, and recommenced boarding. He ate breakfast at my table on the Saturday after his return, the 6th April, in company with Mrs. Hamilton, Mary Imlay, and several gentlemen boarders. Do not recollect to have seen the prisoner after breakfast until after the fatal occurrence. Mrs. Hamilton was all the morning in the front parlor with her sister and the man towel-maker. I observed to her that I felt very unwell, and she advised me to recline on the sofa. Said she would send me a pillow and attend to the dinner herself, and she then left the room. She sent me a pillow by her little daughter, on which I rested my head. In 6 or 7 minutes thereafter, my daughter Elizabeth came to the door, screaming dreadfully, but I could not understand what she said except the words, "Go to my sister Mary." I immediately ran, and when I got to the door of the frame house back, I saw Mrs. Hamilton coming with her hair disheveled and hands upraised and waving to and fro. She came immediately to me and exclaimed, "Why did you not come? I screamed, and Clough has murdered me." I asked her what for, and she answered, "Because I would not say that I would have him, and I could not, mother, I could not." I asked her where she was. She said, "In his room. He sent for me, and he has killed me." I discovered that she was leaning as if about to fall, and I took her in my arms and led her into a small room adjacent, to lay her on the settee, which she did not reach, but fell, exclaiming, "Oh, mother, mother, I must die, I must die," and the blood gushed out of her mouth when they took me from her. When I first saw her, she was about halfway down the stairs, coming down. Cross-examined. Did not know Mr. Clough before he came to live at my house in June 1831. While he was there, we lived in entire harmony together. He was a very pleasant boarder and respected by all the family. believe he would have been willing to have paid particular attention to Mrs. Hamilton, but she was not willing to receive it. I had frequent conversations with her on the subject of Clough's attentions. When absent, he often wrote to her, although she requested him not to, and was angry when his letters were received, and threw them in the fire. I've heard her request him not to write to her. Do not know of any presents that she ever accepted of him, except an album, which he purchased in Philadelphia, and in which he got Mr. Worrell and Mr. Thomas to write, and which, after some solicitation, and asking my advice about it, she accepted. She refused a number of presents that he offered to her, among them his miniature and a large breastpin. She let Mr. Clough have the dirk last fall or summer, when he was employed on the Schuylkill, on his representing that he wanted one, as he was engaged in working with a rough set of people. It had belonged to her brother, and she had another which had belonged to her deceased husband. He frequently did errands for me while boarding with me, and I respected him as a boarder very much. He was generally of a mild, placable disposition, except when angry, and was then very violent. The letters she received from him I have frequently seen her tear up and throw into the fire. She sometimes handed them to me to read. Sometimes I read them, and sometimes I did not. Perhaps the letters did breathe affection to Mrs. Hamilton. When he returned from his visit to New York, he said he had been sick in his absence. He was dull and looked sunburnt. After his return, he lay down once or twice a day. He did not eat much on the morning of the murder, and I remarked to him that he had made a light breakfast. As to his mind, I did not observe much difference, except that he was unusually dull, which I ascribed to the circumstance of his being unwell. When Mrs. Hamilton returned from Philadelphia, at the time Clough was also there, she had the small gold watch spoken of. It was a watch which Clough had in his possession for some time. He frequently spoke to me about Mrs. Hamilton, but I always evaded the subject as much as possible. He said that he respected her very much and would go further to serve her than any other woman, but never told me that he loved her. Have no knowledge of any engagement between them, and know there was none. Know nothing about her ever going a-sleighing with him, except once last winter, a year, when she was going to Trenton and thus to Princeton, to see her mother-in-law. When he came and crowded in the sleigh, and she told him there was no room for him, and if he went, she must remain at home. She did not return with him, nor did he bring her home. I never heard that he gave her any rings or saw any in her possession. He gave her little daughter a pair of earrings, a pair of side combs, and a geography and atlas, on condition of her obtaining a premium at school. Know nothing of Mrs. Hamilton ever having presented him with a lock of her hair. Recollect Mr. Clough asking me one day if I thought Mrs. Hamilton was attached to anyone, and I replied that I thought she was not. He said he thought so too. When I saw Mrs. Hamilton first in such a fright, I thought perhaps he had killed himself, and that she had been in the chamber and had seen it. Thought it might be so from some conversation she said she had had with him the evening before, but not from anything I saw myself. Mr. Scott, you say, madam, that you thought perhaps that Mr. Clough had committed suicide from some conversation you had had with your daughter concerning him the evening before her death. Now, what were those conversations with your daughter that induced you to think so? This question was objected to by the counsel for the prisoner as illegal. The court ruled that the question was improper and illegal. Joseph H. Brown, 10 bar for Mrs. Longstreth, where prisoner boarded. Previous to the murder, went into the barroom and was conversing with 2 young men, viz., Mr. Henry Sagan and Mr. George Miller. The latter touched me on the arm and asked, "What noise is that?" I listened and said, "It is some of the girls with some of their fun." The noise continuing, with the scuffle and screech, I immediately opened the door and thought the noise proceeded from the garret of the frame part of the house, over the bar room, which I was in. I asked Miller and Sagan to follow me, and stepped on the foot of the stairs. The latter and myself went up as fast as we could, and Miller immediately behind us. After reaching the top step, saw Mr. Clough and Mrs. Hamilton on the floor of the entry. Clough had Mrs. Hamilton down, and his left hand round her back. He was rather leaning over on his left side and not entirely on the floor, with his feet drawn up in such a way that he could recover himself at any time. Saw the handle of some instrument in his right hand, the blade of which was in her breast or side, nearest to the right side, and appeared to be up to the guard. As he held it in his hand, he gave it a prying motion laterally, with the appearance of wishing to push it further in. I saw blood on and about her waist in several places, one in particular, where it appeared to be oozing or bubbling out. Immediately I found myself forced to give way, being crowded, and I gave way and stepped back so near the stairs that I found it difficult to recover from falling off. The next I saw of Mrs. Hamilton, she was on the third step going downstairs with her hands uplifted, at the foot of which her mother met her, when she exclaimed, "Oh, mother, mother, why did you not come? I called and called and called, and Clough has killed me because I would not say that I would have him. And I could not, mother, I could not, and I must die." She was then taken by her mother into a small room opening near the foot of the staircase. I then returned upstairs and entered the room of Clough. I saw him lying on the bed, looked at him a moment, walked out, and went to the spot where I first saw them lying, and there found puddles of blood on the floor. Also found a silver thimble on the floor, picked it up, and found it crushed, and saw on it the name of Mrs. Hamilton. Picked up likewise her shoe, which I examined, and found it bloody inside. I then went downstairs to the room where Mrs. Hamilton was. Her arms were supported by a young man named Luke Doughton, assisted by a young lady. I then returned to Clough's room upstairs, saw him still lying on his bed, came out and saw Mr. Sagan, who put a dirk in my hand, covered with blood up to the guard. He said to me, "Look here, what he did it with." Took the dirk, proceeded to the spot where I had seen them lying in the entry, and further along at the garret steps I saw him picked up fragments of side combs. Then turning towards the door occupied by the girls, I found a guard chain and watch key, and in stooping to pick them up, I discovered a bosom pin with a large central stone out. I took them up, and particularly examining the bosom pin, discovered that it was pierced with some instrument having a sharp point, which had passed through it. I then went downstairs with the dirk in my hand to the door of the room where Mrs. Hamilton lay apparently lifeless, and whom they pronounced to be dead. Not more than 10 minutes had elapsed from the time I first went up until this period. I then went into the bar. The dirk, which had a blade about 4 inches long, a silver guard, and a white bone or ivory handle, was here exhibited to witness. It was covered with blood up to the hilt. One of the guards was bloody and bent downwards. The point was bent as if it had come in contact with some hard or bony substance. This is the dirk with which the fatal deed was done. After going to the bar, I locked up the dirk in a drawer. Saw no more of Clough until I saw him in the backyard, seated on a bench, back of the kitchen. He looked up and said, "How do you do, Mr. Brown?" Saw him afterwards several times prior to the sheriff's taking him away, but had no conversation with him. Cross-examined. Clough appeared to me a mild and moderate man when he first returned from New York. I welcomed him home, but observed no change in his appearance until the Friday antecedent to the transaction. I then thought he looked as if he was vexed or mad about something. I did not know what. Clough looked very pale and savage. I did not attempt to lay hold of him, or to speak to him or Mrs. Hamilton, or any person there, and I had not the presence of mind to interfere. I do not know that I was afraid, but I did not like to advance toward Clough when he was armed and I was not. Do not know that he made any effort to escape. Arrangements were made soon after the murder to surround the house to prevent his jumping from the window and escaping. There were persons watching him in the backyard and in the garden until the sheriff came, near night, who took him into custody and carried him away to jail. A young man went up with a pistol into his room soon after the murder to prevent his escaping. Henry Sagan was at Mrs. Longstress on the day of Mrs. Hamilton's death and saw the prisoner there. Was in the barroom when I heard a noise with Mr. Brown and Mr. Miller. The noise was screaming and seemed the effect of trouble. I went upstairs with Brown and Miller and saw Mrs. Hamilton lying on the floor and Clough over her, not quite on the floor. She was on his left side, his elbow on the floor under her. He held a dagger in his right hand. The blade was in her body, and he made 3 movements with it. They were quick and rapid plunges, during which the dagger was not drawn entirely out, but part of it still remaining in her body. I went downstairs and armed myself with a club that I had perceived before I went up. As I approached the stairs near the barroom door, I heard Mrs. Hamilton halloo to her mother, crying out, "Mother, mother," as she was coming down, and I sprung and caught her, and brought her down a few steps and delivered her into the hands of some person near a side door, near the foot of the steps. I then asked for a pair of pistols, and called for a constable. The pistols were brought, and I took one. I then returned upstairs and saw the dagger in the entry, lying on the right of the place where they had lain, and found Clough lying on the bed. I picked up the dagger and entered Clough's room. I then delivered the dagger to some person to take care of. It did not go out of the bar until it was put in the hand of some authority. Heard Clough say, while engaged with Mrs. Hamilton on the floor of the entry, Will you? Clough lay on the bed, with one arm extended with his eyes closed. Did not speak to him or he to me. Had the pistol in my hand. A physician came in with some remedy to eject the laudanum they supposed he had taken. Dirk exhibited. This is the dirk which I found in the entry. It was bloody, and the blood was not quite dry on it then. The guard was turned down and the point a little bent. Cross-examined. Was not upstairs the first time more than 2 or 3 seconds. Did not observe any person there at the time, except Miller, Brown, and myself, and we crowded Miller in order to get downstairs. It was not the effect of fear of Clough, but he had a dagger, and I went down to get a club, which I had previously seen in the bar, to defend myself with. When I saw him in bed, he was partially undressed. His coat and stock were off. We went upstairs very fast and came down all together. Elizabeth Applegate lived at Mrs. Longstress on the 6th of April last, and saw Mrs. Hamilton that day about 12 o'clock. She came into the kitchen to me to inquire if dinner were ready. I told her it was nearly so. She then went upstairs, where I heard her speak to a servant about the dinner. Soon after this, say about 4 minutes, I was standing in the inside kitchen door, and heard her halloo. The noise she made was loud, and seemed to indicate being in trouble. She hallooed, "Oh!" several times. I next saw Mrs. Hamilton coming down the stairs, exclaiming, "Oh, Clough has killed me." I saw her when she met her mother about halfway along the entry, where she fell into her arms and exclaimed, "Oh, mother, mother, I screamed, and why did you not come and help me? And you did not come." She was then taken into the sitting room, but by whom I cannot tell. I act as cook in the family. Did not hear Mr. Clough call to Mrs. Hamilton. Mr. Clough did not appear to be very well for several days. His conduct was generally mild and kind. Hannah Herbert was at Mrs. Longstress on the 6th April last, after the death of Mrs. Hamilton. I took off the clothes she had on when she died, left them on the floor of the room, and then I laid her out. On being directed to do so, she then opened a trunk and took out a black dress and corsets, which Mrs. Hamilton had on when she died. These I took off her before I laid her out. The dress contained 7 holes, from a half to 3/4 of an inch in length, in the part that covered the left breast, presenting the appearance of having been pierced with an instrument not sharp, and of the size of a dagger blade. The corsets were also pierced in a similar manner, and dyed with blood in the part that covered the breast. These holes were in those garments when I took them off her. The corsets could not be unlaced, and the cords were cut with a knife. She had 1 shoe on and 1 off. There were wounds in the body corresponding with the holes in the dress, and blood and other matter were oozing from them. Dr. Joseph H. Cook. I am a physician. I was at the house of Mrs. Longstreth about the time of Mrs. Hamilton's death, examined the body, assisted by Dr. Dewar, and discovered 10 deep wounds in the body. I introduced the probe into one which had penetrated to the bone of the left arm. The second had struck the shoulder blade and also penetrated to the bone. The third had struck and fractured the 7th rib and completely broken it. The remaining 7 had penetrated the chest between the 3rd and 6th ribs. On opening the chest, it was ascertained that 7 of the wounds had penetrated the left lung. 3 out of the 7 had gone through the lung and penetrated the left ventricle of the heart. Several smaller punctures were discovered on her body, one of which, an inch long, appeared as if the instrument had slipped or glanced, and there were 4 or 5, apparently caused by the same instrument, which had penetrated only a short distance. The left cavity of the chest was filled with blood. Any one of the 3 wounds that touched the heart must have produced death. The one which pierced the large artery which takes the blood from the heart and circulates it through the system was inevitably fatal, and those in the lungs might have, and most probably would have, proved fatal. I have no doubt whatever that the wounds were the cause of her death. A person could walk as far as she did after being wounded in the heart, owing to the smallness of the orifice, which would not permit the blood to escape, and a dress also intercept its blood. The heart was not taken out, but carefully examined. She would be able to speak after being wounded in the heart, and it is a common occurrence in mortal wounds. She would retain her mental faculties until life was extinct. Cross-examined. If a person had the lungs perforated in 3 or 4 places, still the voice would be retained for a short time, though it would be much weakened. In this case, 1 lung was left untouched and sound. Dr. George S. Dewar. I was present with Dr. Cook at the examination of Mrs. Hamilton's body. When I saw her, she was lying on a settee, on her back, and was dead. There was 1 gash in the left arm, which reached to the bone, and 2 punctures through the skin. There was 1 on the point of the shoulder blade, which went to the bone. The 7th or last true rib was broken about its middle, being fractured entirely off, and the outward integument entirely separated from it. With the probe, we then examined 7 wounds between the 3rd and 6th ribs, and laid open the cavity of the chest. The most of these admitted the whole length of the probe, which was 4 or 5 inches in length. 2 of them did not admit it above 2 inches. We found 7 wounds in the lungs, and 3 in the heart. 3 of the 10 had entered into the cavity in the left side. All were in the left side and in the left lung. The dirk was here shown. The wounds were as deep as the length of the instrument, and the probe was as long. It would require the length of this, up to the hilt, to penetrate so deep. 4 of them were as deep as this is long. I do not entertain a doubt that either of them might have proved fatal, and I have no hesitation in ascribing her death to the wound she received and to the loss of blood directly from the heart. Cross-examined. There were 7 wounds in the chest and 3 of the 7 in the heart. There were 7 external punctures and 10 internal ones. There was something like 13 or 14 punctures altogether, and several abrasions besides. By internal punctures, I mean those that have gone through the lungs without exhibiting corresponding external wounds. There is not the least doubt that each wound would produce death. One would not, however, let off the blood, while 3 would. It is possible to sustain the voice with 7 wounds in the lungs. They would not stop the voice at once. Luke Doughton was at Mrs. Longstreth's on the day of Mrs. Hamilton's death, had been boarding there for about 2 weeks, and was sitting in the room reading when I heard the scream of a lady in the upper part of the house, appearing to be in agony, crying, "Oh, mother, mother!" Thought it might come from some of the children receiving a correction from a Barrett. I then saw 3 young gentlemen, Brown, Miller, and Sagan, run upstairs out of the barroom in a great hurry, and I threw down my book and followed them. When I got 2/3 of the way up the stairs, Sagan called out for a pair of pistols. I went and told the family in the brick house that there was something wrong in the other part of the house. I went into my bedroom, number 1, and got a pair of pistols and gave them to Sagan, as he requested. I came down and found Mrs. Hamilton in the arms of her mother. Her mother took her into a little dining room opposite to the bar-room. After Mrs. Hamilton had been in her mother's arms about 2 minutes, I took Mrs. Longstreth's place, fearing that she would go frantic. I held her about 5 minutes when she expired. I asked Mrs. Hamilton once if she ever intended to marry Clough. She answered, no. I asked her why. She said, for a very good reason, because she did not love him. I think this was on Friday the 5th, before noon. I was induced to ask her this question because it was a common report about Bordentown that she was going to marry him. Clough was polite to Mrs. Hamilton, but not more so, I think, than other persons. I think I was as polite to her as he was. We were all as attentive as is common, and I cannot say but that our attentions were all received as well as his. Clough was in the room with Mrs. Hamilton more than the rest of the boarders. George Miller was at the house of Mrs. Longstreth on the 6th of April last. We were in the bar with Mr. Brown, the barkeeper, when we heard the screaming, seemingly upstairs, and we ran up, Brown and Sagan before me. I reached the top when they had turned and were coming down. I asked Sagan what was the matter. He returned no answer and ran downstairs, as I did also. I went out and returned and found Mrs. Hamilton leaning against the wall, nearly opposite a door that opens into the bar-room. Mrs. Longstreth was with her. Mrs. Hamilton was looking her mother directly in the face, and had her eyes fixed upon her. I think Mrs. Longstreth supported Mrs. Hamilton into the room, half across which she sunk into her mother's arms. Mr. Doughton relieved Mrs. Longstreth, and took care of Mrs. Hamilton. I remained in the room until she died, from 7 to 10 minutes after she entered it. Anne Reeves. Remember the day of Mrs. Hamilton's death. I was in my own house when I heard the noise and disturbance. Our houses are about 8 feet apart, an alley between. My daughter and myself went into Mrs. Longstreth's house and into the room where Mrs. Hamilton was, downstairs, where we found her sitting on the floor in her mother's arms, and the latter sitting on the settee. My daughter and a gentleman named Doughton took her out of her mother's arms, and Mrs. Longstreth and myself went into the front part of the house, where I remained with her. And while we were there, Mrs. Hamilton died. By that time, the room was crowded with persons. When I first saw Clough, he was sitting down in the yard. Mrs. Longstreth said she wished to see him, and that if he had his proper senses, he would know her voice and notice her. After a few words, she also said she supposed his neck must pay for it. I answered that it ought to. Clough then turned his head round, and looking at me said, I am well aware of that. We then went into the house. Next I saw of him, he was walking in the backyard, but I did not speak to him. Jonas Bechtel was at home at work when I heard the scream of persons. It was not a clear but a smothered scream. I knew it was in the back part of Mrs. Longstreth's house. I left my work and went into the house, met Mrs. Longstreth at the back door, saw Mrs. Hamilton entirely down, off the step, on the entry floor. I saw some blood coming out of her mouth. Her hair was disheveled and flying over her face. Heard her say that Clough had killed her. Her mother said, "Where was it?" She answered, "In his room." Her mother said, "My dear, how came you there?" She answered that Clough had called her. Her mother had her in her arms, and she was leaning on her. I then went up into Clough's room and found him lying on his back in bed, where were several persons. Clough's eyes were partly shut. He groaned twice and asked if Mrs. Hamilton was dead. He then began to converse with Mr. Shin. Clough's language was, "Is she dead?" Clough then began to state where his mother lived, and gave his miniature to send to her. Mr. Shin was writing down with a pencil what he said, and I then, turning round to leave the room, picked up 2 or 3 pieces of side comb near the foot of the bed. I then went into the entry, picked up some more side comb, and a watch guard with a ring and key attached thereto, and a breastpin. I returned to Clough's room and placed these articles in the drawer of the table, which stood open. Considering, however, that they were not his, I took them out again and laid them on a bandbox on some shelves at the foot of the entry. I then found her shoe with some blood in, and a spot of blood on the floor near the shoe. It was the opinion of all who were present that Clough was dying at the time. The medicine was given to eject the laudanum and save his life. I returned downstairs, and the next thing I saw was 2 men carrying him. They took him towards the front street and then to the yard, where they led him about, as the opinion was that he was dying, and he was limber in every joint. One of the men shook him about pretty lively, and after that he walked. I then saw some persons leading Clough through the garden, and near a building, where he threw from his stomach a quantity of matter that resembled water, without any appearance of medicine or laudanum. William Reeves. I was at Mrs. Longstreth's on the day of the death of Mrs. Hamilton. I went there from Bechtel's garden, on hearing screams. They at first appeared like the screams of a child, but continuing. I jumped over the fence and entered Mrs. Longstreth's kitchen, where I found all the girls screaming. Inquired what the matter was, and they said that Clough had murdered Mrs. Hamilton. Went into the entry, near the foot of the staircase, and saw Mrs. Hamilton sitting on the carpet, supported by Luke Doughton, and the blood issuing from each corner of her mouth, and also from her side, just above the belt. I asked where he was, and was answered by someone that he was getting out of the back of the house. I then saw Sagan with 2 pistols in his hand, took one, and ran out to the back part of the house. Saw several men, re-entered the house and went upstairs, where I saw Mr. Shin, who had just entered Clough's room. Shin caught hold of both Clough's wrists. I went to the bedside, and Shin yielded one of Clough's wrists to me. I took hold of it. Clough asked, "Is she dead? Is she dead?" Skinner said she was. Clough then said, "Lord, have mercy on my soul." He then told Shin to take his miniature and send it to his mother, which was in the bureau at the foot of the bed. Shin inquired where his mother was. Clough answered in Orleans County, New York. Shin then asked his mother's name, and he answered that it was Joanna Clough, which Shin noted with a pencil on paper, putting the miniature in the paper in his pocket. Shin said he was not so far gone, but that he might be brought to, after feeling of his pulse, and sent for some medicine for him to take, which he did not wish to, shook his head, and kept his mouth shut. At Shin's instance, I then took hold of his nose. His mouth was forced open, and most of the medicine was forced down him. He then wished to be carried downstairs. I took hold one side of him, and we carried him down. While we were walking him about, he again asked if Mrs. Hamilton was dead. I told him she was. He then asked if she spoke after she was stabbed. I told him she did. He then inquired what she said. I answered him that she told her mother the cause of his killing her, and that she declared to her mother that it was because she would not marry him. He said it was not so. I told him then that it could not be possible that a woman would assert a falsehood in her last dying words. He said that nothing of the kind had passed between them. George Clift, who also had hold of him, then asked him how, in the name of God, he came to do it. He replied that he would tell that at some future time. I then told him to look at the blood on his hand, as it was bloody both inside and outside. He then extended his right arm and said, "Reeves, that is an honorable arm," which expression he repeated. I asked him if he was sensible of what he had been doing. He said he was perfectly aware of what he had been doing, and expected to suffer by the laws of his country. We walked him about and then took him into the yard. Soon after, the sheriff arrived, of which I informed him, and that he would soon have to go. He then inquired what kind of accommodations he would have in prison, and whether he would have anything but straw to sleep on, which I said I could not tell. Soon after, Mrs. Longstreth came out with Mrs. Reeves, said he was a poor, miserable wretch, and that his neck would have to pay for it. Clough took no notice of what Mrs. Longstreth said, but when Mrs. Reeves said that his neck ought to pay for it, he rolled up his eyes towards her and said, "Madam, I am perfectly aware of all that." When we wanted to give Clough more medicine and warm water in order to throw up the laudanum, after walking him about some time, he said it was of no use, as he had not so much laudanum in him as we thought he had, and not enough to kill or injure him. Joseph W. Allen saw Clough in the yard about 4 o'clock. He was talking with Dr. Cook. He asked me if Mr. Thompson had heard of the affair. I answered yes. I told him he had got himself in a bad scrape, and it would certainly cost him his life. He said he little thought in the morning that he could not control his passions better, but that he had cause. He then asked me if I thought money, honor, character, or credit would not save him. I told him his character was gone, that there was but little chance for him. He then asked me where Mrs. Hamilton lay, if she was dead, and if he would be permitted to see her. I told him he would not. He said he felt very bad from the effects of the laudanum. John McKnight was at Mrs. Longstreth's a little after 12 o'clock on the day of Mrs. Hamilton's death. She was sitting on the floor, supported by Miss Reeves and Mr. Doughton. She appeared to be drawing her last breath. Blood was coming from her mouth and side, and blood was also on her stocking. Coming out, I saw a number of men and requested them to see that no one escaped from the house. Mrs. Longstreth soon had hold of me, inquiring what she must do. She asked me if her daughter must die, and I told her I thought she must. I left her then in the care of some females. I went upstairs and saw Clough lying on the bed, and Mr. Shin endeavoring to administer an emetic to him, as he had taken laudanum. Afterward, in the yard, he said something which I did not understand until he used the word causes. They walked with him to the garden fence. I requested the men who had him to stand a little back. He writhed and said, "A man must have strong causes to bring his mind to commit such an act." He put his hand in his pantaloons pocket and said he had money. He then asked me if she was really dead. I told him she must be quite dead, and he shed tears. He asked if I thought that money would be of any service to him. I told him he might possibly want counsel. He asked me whom he should get. I named no person, and I told him he had committed a horrible act, and that he had better not assign any other causes than had gone to the world, or there would be less sympathy for him. He asked me what were the causes. I told him that I had heard from Mrs. Longstreth that he did the deed because Mrs. Hamilton would not consent to marry him. He wrung his hands and said that she ought not to say so. I asked him how much laudanum he had taken. He said nearly 1 ounce, but it had no effect on him then. I asked him how many times he had stabbed her. He said 7 times. When he asked if she was really dead, he said it must be so, for I was calm when I did it. June 4th. John McKnight. Cross-examination continued. Clough mentioned to me that he had been intimate with Mrs. Hamilton, and was so soon after she became a widow. He said that he had visited all or most of her friends in Philadelphia with her. He asked me if money would be of any use. I told him I thought very little. He said he was willing to submit to the laws and be hung if it was thought right. Joshua H. Fallingshed, Sheriff. I saw the prisoner on the 6th April in the backyard of Mrs. Longstreth's house. He sat between Mr. Reeves and Mr. Clift. Had very little conversation with him there. Brought him from Bordentown to this place in company with Mr. Cannon, Mr. Harrison, and Mr. Brown, who aided me. On the road he mentioned something concerning the affair, and said that he hoped he had taken innocent blood, but feared he had not. Before we started, some person asked him what he thought would become of him. He answered that he was aware of all the consequences that might follow. He did not mention to me the state of his mind at the time of his commission of the crime. Willett N. Harrison. Saw the prisoner at Mrs. Longstreth's the day he was brought to prison. He was in the yard, but I had no conversation with him there. I rode in the same carriage with him to Mount Holly, where he was committed to prison. I do not think the subject of the murder was spoken of at all during the journey. He made some few remarks, saying that the night before at the same hour, himself and Mrs. Longstreth's family were pleasantly situated together, and that he had no more idea of committing this deed than anyone in the barouche. He also said, "I suppose it will be the last time I shall travel this road," and remarked upon the beauty of the fields and of the country. He appeared very much depressed and conversed but little. When he did, his conversation was connected, but he appeared to be in great agony of mind at times. John P. Shin was at Mrs. Longstreth's on the day of Mrs. Hamilton's death. She was in a small sitting room, nearly opposite the bar room, in a sitting posture on the floor, about the middle of the room, and supported by Mrs. Reeves and someone else. She was about drawing her last breath, went to Clough's room and found him in his bed. I asked Clough how it was possible for him to commit such an act. He asked me to come in. I asked what he wanted. He answered, "Come in and hear the words of a dying man." While I was yet at the door, he asked, "Is she dead?" I told him she was. He then put his left hand on his breast and said, "The Lord have mercy on my soul." I went into the room and took hold of each of his wrists. He then told me that in the drawer of the table of the room I would find a miniature, to take it and send it and write to his mother. I got the miniature out of the drawer. I asked him what made him think he would die so soon, and he pointed to a stand that stood in the corner of the room. I saw a tumbler on the stand, and in it an ounce vial, which had contained laudanum. I then got some tartar emetic from my shop, mixed and offered it to him. As he refused to take it by compressing his lips, I proposed to make him take it, and several of the bystanders took hold of and held him and made him take it, which he did, spilling about 1/2 of it. He was then taken down into the yard, the men about half carrying and half dragging him, he refusing to walk. I gave him in the yard 5 grains more of the emetic, and then after some time, an additional 5 grains. I met Dr. Milnor, and he told me, if it had not operated, to give him 10 grains of sulfate of zinc, which I got and gave him. He was then moved about. Dr. Dewar advised giving him, as the other did not operate, 10 grains of sulfate of copper in 2 doses. But before it was administered, the former emetics had operated. Saw nothing more of him until the sheriff had him in custody. Witnesses for the defense. Charles L. Bartlett, resided at Princeton, New Jersey, was acquainted with Mr. Clough from a child. Knew him first at Unity in New Hampshire. He resided there with his father. Knew the members of that family well. The prisoner had a brother Benjamin, one named Jeremiah, and another Wesley. These are all I recollect. Was a schoolmate of Joel Clough. His father was a farmer. Joel was a bright, active boy at school, very mild, and of a warm temperament. Knew Benjamin. Have heard it said that he was at times deranged. I knew his cousins. Miss Mann was one of them. She was a long time deranged, or, as the people then said, bewitched. Am connected with the theological seminary at Princeton, of which I am a student. I am well acquainted with the family of Clough. It is very respectable. George Law. Live in Easton, Pennsylvania. Became acquainted with the prisoner in November 1829 at Easton. He had contracted for work in New Jersey on the Morris Canal and wished to have a conversation with me on the subject of mechanism. His general character was very good. He was an industrious, honest, sober man, and of a very mild disposition. It is customary for contractors to carry weapons of defense. It became necessary for me on account of the character of the men we have to do business with, who are disorderly, have not been much with Clough since 1830. Henry J. Pyle. Became acquainted with the prisoner about 12 months since, at Mrs. Longstress, where I was boarding 2 or 3 weeks with my wife. Thought Clough was attached to Mrs. Hamilton, as he always appeared to wish to be where she was. I have seen them walk together. Saw Clough at my house in Philadelphia. He was there also with Mrs. Hamilton. Mr. Clough and myself and wife went to the theater. The attentions Clough paid to Mrs. Hamilton were kindly received, but much more kindly at some times than others. After going to the theater, we all went to my house between 12 and 1 o'clock in the morning, and they stayed nearly an hour, when Mr. Clough went with her from my house to where she stayed. I have frequently conversed with Mrs. Hamilton about being married to Clough, and about 3 weeks before her death, I had the last conversation with her upon the subject, when I requested that I may be groomsman when she married Mr. Clough. She laughed and told me I should be groomsman when she married him. Mr. Clough presented her with an album. I asked her if the gold watch she wore did not once belong to Mr. Clough. She said it did, and that it was one he used to wear. I told her that Clough thought a good deal of her. She said she hoped he did, and everybody else. Cross-examined. All of us have rode out together, but never saw Mrs. Hamilton and Mr. Clough ride out alone. We started from Bordentown, all together once, and I believe twice. Have not made nor offered bets upon the result of the trial. Mr. Clough asked me to see about his having counsel, and I promised it. I have not made any attempt to speak to the jury about this trial. I did not know any of them, and I did not say that the constable was too quick for me. I have never said that Clough and Mrs. Hamilton stayed at my house all night, nor that they sat up all night. Have never heard Mrs. Hamilton intimate that his attentions were disagreeable. James Wallace. I have known the prisoner since September 1829. He was doing contract work and had a subcontract under me on the Morris Canal. Inquired into his mechanical and moral character and found it to be good. I thought him more than ordinarily mild and forbearing. I saw him last of March or beginning of April last. I observed a change in him. He showed a disposition to drink more than before, and to press me to drink also. His mind appeared to me to be rather unsteady. We left Albany the Sunday before the 6th of April. We drank 2 or 3 times at the bar in the afternoon. He wanted to drink every 8 or 10 minutes. I told him he must be beside himself, for it is not more than 5 minutes that you drink. When I was going to bed, he pressed me to take a glass of whiskey punch. I refused, and putting my hand upon his collar, said, "Mr. Clough, I don't see what the devil has gotten into you. You are more like a crazy man than anything else." He said, "Oh, never mind. I am so glad to see you." He did not seem natural to me, and I could not tell why. He looked fatigued. He was dull and stupid, and seemed to be a different man from what he was before. Clough was to take charge of my contract if I made it. I thought he had become intemperate, or that something was the matter with him, and I abandoned the idea and returned home. I left him in New York on the dock or boat, just about as I found him, except that he shed tears. Cross-examined. We arrived in New York on Monday, and same day I went to Burlington, went back on Wednesday and found him in the custody of an officer on a charge of taking some jewelry from a girl the Thursday evening before. I asked him how he came to get into such an affair. He said he saw a girl in the theater, hired a carriage and took her home. She jilted him. He took the jewels, cleared the house, absconded, and went to Albany. Mrs. Longstreth. Have seen letters or a part of them, which Clough wrote to her, and Mrs. Hamilton's possession. These letters were returned to him a few weeks before the catastrophe. Saw Clough a few minutes afterwards. Clough stated in his interview with me that he had given up all hope of gaining her affections, had demanded his letters, and they had been returned to him. He respected the family and ever should. I did not tell him that my daughter had made to me any communication concerning him. After the letters were returned to him, I understood that from that time his attentions would cease. He wished her to go a-sleighing with him. She refused, and went with others. He was much affected at this. They disputed pretty loud, and he was very angry. She told him it was nothing to him where she went, or with whom she rode. He had nothing to do with it. I do not recollect that he made any reply. I recollect there was a baptism, and she walked with him there, and returned with Mr. Lippincott, at which he was offended, and said some ill-natured things. When Clough first came to my house, he was mild and pleasant. Towards the latter part of the time, I saw him much out of humor, and he talked very cross. Was very angry one day with Mr. Wells, and if Wells had not explained or been humble, or made acknowledgments, Clough would have killed him. End of section 71. Section 72 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Joel Clough for the murder of Mary W. Hamilton, New Jersey, 1833, Part 3. June 5th. Arthur Stewart. I was acquainted with Clough for about 2 years when he lived in Bordentown. Never knew of any particular intercourse between Clough and Mrs. Hamilton, nor observed any unusual act of kindness or attention between her and him. I observed those of an opposite character. Lee Wells. Had an interview with Clough in the spring of 1832. He wished to know my intentions in relation to Mrs. Hamilton. I told him I must know his right to inquire. He said he wished to know my intentions with Mrs. Hamilton, and whether any engagement had been made. I told him none. Previous to this, he became very angry and said, "Wells, you must discontinue your attentions to Mrs. Hamilton, or else you or I must die." Cross-examined. Clough asked me if I entertained honorable intentions towards Mrs. Hamilton. I told him I did. Clough's attentions to Mrs. Hamilton were more than those of other persons. When I first boarded there, they appeared disagreeable to Mrs. Hamilton, but a short time before I left, she was more free in conversing with him than she was previously. I observed the change. It was more than it ought to be to a boarder and a friend. I did not think Mr. Clough a successful rival of mine. My attention ceased when I left there on 1st April 1832. We separated with a good understanding. Heard of reports about Clough's marriage with Mrs. Hamilton when I was in Bordentown. May have asked Mrs. Hamilton the question whether she preferred Clough to me. Have often spoken to Clough about Mrs. Hamilton, and have advised him more than once to discontinue his attentions. When I asked her whether she preferred Clough to me, she said, "Mr. Wells, you know better yourself." I had frequent conversations with Mrs. Hamilton about Mr. Clough, and she wished me to tell Mr. Clough to discontinue his attentions, as they were very disagreeable to her. I told Clough of what she requested, and he answered that time would decide the case. Charles J. Erie, Edward J. Dubarry, Humphrey B. McMickle, William McKnight, Charles Green, and William Arnold testified that they had known and observed the prisoner for years, that he was of good habits, of a mild and moderate disposition, and that his character was good. On the other hand, John Hopkins testified that his general character, when he worked and did business with him, was bad. Mr. Hazelhurst, with the prisoner, read from a number of medical authorities on the subject of mental maladies, the predisposing causes of insanity and madness and melancholy. Mr. Southard, for the state, cited Russell on Crimes as to the legal test of insanity and read extracts from it, and to quote the reporter's note of the trial, the cause on the part of the prisoner was summed up with great energy, eloquence, and zeal by Messrs. Hazelhurst and D.P. Brown, the former in a speech of 2, and the latter of more than 3 hours, in which every effort of reason, pathos, and argument was used to convince the jury of the insanity of the defendant, and to make an appeal to them of the justice of his acquittal, on the ground that he was at the time laboring under an aberration of mind. The cause, on behalf of the state, was summed up by Messrs. Scott and Southard, with that masterly eloquence, energy, power, and sublimity of reason and of pathos, for which they are so preeminently distinguished, the former in a speech of about 2 hours, and the latter concluding in a speech of about 4 hours, during the delivery of which the question of the prisoner's insanity was met and overcome with skill, learning, law, and talent, which completely broke down this barrier of defense, and carried conviction to almost every mind that the murder was the effect of premeditated purpose, growing out of disappointed, unrequited, and despised love, and jealousy, which prepared the prisoner's mind for the commission of the horrid crime. While delivering these powerful addresses to the court and jury, the learned counsel were several times overcome with their own feelings so completely that tears denied their utterance, and which communicated to almost all around. The prisoner covering his face and appearing to agonize to his very soul. Mr. Southard took the floor in reply to Mr. Brown at 6 o'clock in the evening, and would have brought this important trial to a close at that time, had it not been for the unfortunate illness of one of the jury, who was taken out of the courthouse 3 different times, but it was evident that he was too seriously indisposed to be able to sit out the argument, if it were to be finished that evening, and the court adjourned until 8 o'clock the next morning, when Mr. Southard concluded his remarks. June 6th. Chief Justice Hornblower. After a severe, close, and painful investigation of this cause for several days, we have reached that point where the labors and responsibilities of counsel have terminated, and where it becomes my duty to explain to you the rules and principles of the law, so far as the guilt or innocence of the prisoner is connected with, or dependent upon, those rules and principles. Soon the fate of the prisoner will be committed to your hands, and upon your verdict hangs the issue of life and death. He is mortal, and so far as human actions can influence our future condition, it may be his immortal and eternal destinies are to be irrevocably fixed by your decision. Not, gentlemen, that either you or the court have any power, except incidentally, over the life or death of the prisoner. You and we are delegated with no such authority. We have been selected to perform another and specific, though I admit, a solemn duty, namely, to ascertain the guilt or innocence of the prisoner, and there our duties and our power terminate, so far as we are responsible. The law makes no appeal to our judgment on the expediency of the punishment it annexes to crime, nor to our religious views or feelings on the moral fitness or legality of that punishment. What follows our decision, whether it be innocent or guilty, is the act and judgment of the law, and not ours. The privations and confinement you have so long and so patiently endured, the fixed and untiring attention you have paid to the evidence and the arguments of counsel are, I am sure, a sufficient pledge to the country and to the prisoner that your verdict, whatever it may be, will be the result of your cool and deliberate judgments, the honest convictions of your minds, the true answer of your consciences in the sight of God, and not the expression of prejudice or excitement, on the one hand, or of the unrestrained and controlling indulgence of sympathy and compassion on the other. There is danger, gentlemen, that the claims of justice may be overlooked and left to suffer amidst the conflict of contending passions, alike honorable to our natures, and yet alike dangerous to our reason. The cry of murder, the death struggles of the expiring victim, the reeking dirk and the garments rolled in blood, are well calculated to rouse our feelings and fill our souls with a holy indignation against the perpetrator. Instinctively almost, we wish to see the glittering sword of justice strike the avenging blow and vindicate her cause. 'Tis right we thus should feel, and men we should not be, if we could look unmoved on crime like that with which the prisoner stands charged. But we must guard against these emotions when we enter the sanctuary of justice, whether in character of judges or jurors. We are not, indeed, to banish them from our bosoms, but we must take care that we do not transfer our righteous indignation of the crime to the accused, and thus deny him the benefit of our sober reason and our powers of discrimination. So, on the other hand, sympathy for the accused, tender and compassionate feelings towards a wretched, perhaps an innocent, or at least unfortunate man, standing in the attitude of the prisoner at the bar, is a laudable, nay, an honorable attribute of our nature. But here again we must take care that we do not suffer our humanity to degenerate into weakness, and deny to justice and the majesty of the laws their just claims. If, however, gentlemen, you err at all, let it, I pray you, be under the influence of the latter feelings, for it is the benignant spirit, as well as the language of our law, that many guilty had better escape than one innocent man be punished. The prisoner stands before you charged with the crime of murder committed on the person of Mrs. Mary W. Hamilton. The crime of murder is committed when a reasonable being kills with malice aforethought another reasonable being, in the peace of God and of the state. Your inquiries, therefore, will be in the order and as follows. 1. Was Mary Hamilton killed? 2. Was it done by the prisoner? 3. Was it done with malice aforethought? The two first interrogatives involve nothing but pure and unmixed matters of fact, and to them the jury must respond, and that answer must, unhappily in this case, be in the affirmative. Mrs. Hamilton was killed, and she was killed by the hand of the prisoner. I would, gentlemen, that you and we had room to doubt on this point, but we have all had exhibited to our view and to our ears but too certain and too painful evidence of the fact. She was killed on the 6th day of April last, in the house of her mother, by the hands of the prisoner. It is not denied by him or by his counsel. Nothing, then, remains to be answered but the third interrogative. Did he do it with malice aforethought? Upon your answer to this question must depend the fate of the prisoner, and God grant that I may be enabled rightly to understand and so to explain the law to you that is involved in or connected with this question, that I may not be instrumental in doing injustice to the prisoner. What, then, is meant by malice aforethought? It is a wicked and unlawful design or intention to do a wrong or injury to another, and whether that design or intention has its origin in a spirit of hatred and revenge to the person, or in the gratification of any other passion of the human mind, it is malice aforethought. Nor is it necessary that it should have been a previous, deliberate, and fixed purpose to do the act, for malice is sometimes expressed or positively proved, and sometimes implied, that is, inferred or deduced from the circumstances attending the transaction. Malice is express, where a previous and deadly quarrel existed, and hatred ensued between the parties, or where threats were made, previous arrangements concerted, or the deceased waylaid. In the absence of such proof, it may be implied, from a variety of circumstances, and even from the deadly nature of the weapon made use of. And such was the instrument in this case. But then, the very fact that malice aforethought must exist to constitute the crime implies that the perpetrator must be a moral agent, a reasonable and accountable being. Here probably lie the hopes of the prisoner and his counsel, and whether he was or was not such a moral agent and such an accountable being at the conception and execution of this dreadful tragedy is for you to determine. It would seem, indeed, as if none but a madman could have perpetrated such a deed as we have here exhibited in evidence, who, we are ready to exclaim, but a maniac, an insane and deranged man, could have imbued his hands in the blood of such a victim, could have plunged the dagger into the bosom of virtue, the breast of love itself, and let out the life streams of her on whose life and happiness his own was bound up in unconquerable affection. It is almost incredible. Gentlemen, it is strong evidence of insanity. It is entitled to your consideration. Let it have its weight. But it is my duty to add, it is not conclusive evidence of that sort of insanity which exculpates from accountability and guilt. Frenzy and passion are nearly allied to, nay, they are a partial insanity. But it is sometimes such an insanity as increases rather than diminishes moral turpitude, as proves its existence rather than its absence. Such, unhappily, is the depravity of human nature, that disappointed love, as well as disappointed avarice, or ambition sometimes urges on its victim to crimes of deepest dye, to murder, and even to suicide itself. But such aberration may be only the actings out of a selfish, depraved, and wicked heart, the gratification of a malignant and vindictive spirit, that has not moral courage or virtuous sensibility enough to survive or overcome a defeat, or the humiliating refusal of preferred love. It may be malice, in its deepest, darkest colors, and its most resentful, malignant, and deadliest form. Such is the strange and mysterious composition of our nature. So closely allied are our virtues and our vices. So easily does the former degenerate into the latter, or the latter assimilate themselves to and assume the garb of the former. It is often difficult to determine where the one terminates or the other commences. Such is the passion of love. It may be pure and virtuous, chaste in its conception, holy in its motives, honorable and disinterested in its object. It may seek exclusively and supremely the happiness of the person on whom it is fixed, regardless, in a measure, of its own welfare, except so far as it stands connected with the welfare of that person. It is then a noble and ennobling passion, but it is sometimes a vicious love. It is rather the burning lust of unhallowed and undisciplined passions than the ardent flame of virtuous and sentimental affection. And when such is its character, it is not surprising, if unrequited and ungratified, it should turn to hatred and seek revenge. I do not mean to intimate that such was the nature and character of the prisoner's attachment to the deceased. It may have been as pure and holy as ever glowed in the bosom of a mortal being. It may have burnt and blazed too strong for the physical powers of his mind to endure, and the lamp of reason itself may have gone out, or but glimmered in its socket under the influence of its all-absorbing power. And if by such, or any other cause, the prisoner's mind had become unsettled or deranged, if reason had been driven from its throne, he was a wretched, miserable, crazy man, but not a guilty one. And here, perhaps, I ought to be more specific as to what amounts to, or constitutes such a derangement, as exculpates from the imputation of guilt, and saves from the infliction of punishment. It is a general rule that all homicides, that is, every killing of a person, is presumed to be malicious, and of course murder, unless the contrary appears from circumstances of alleviation, excuse, or justification, and that it is incumbent on the prisoner to make out such circumstances to the satisfaction of the court and jury, unless they sufficiently appear from the evidence and case made out on the part of the prosecution, or perhaps at most it is necessary for the state to show a homicide committed by defendant prima facie, clear of any alleviating, excusing, or justifying cause. In the case now before the court, as I have already remarked, the homicide is proved, and if not confessed, is not denied. The prisoner then is obnoxious to the charge, and liable to the dreadful consequences of murder, unless he can alleviate, excuse, or justify his conduct. It is not necessary for me to enter into a specification of what constitutes an alleviation, excuse, or justification. The defendant has not attempted to alleviate or to justify, but his defense is bottomed on a fact which, if true, is an excuse. That fact is a state of mental alienation, and if such alienation did exist, it is an excuse. It does then rescue him from the charge of crime, and shield him against the punishment due to guilt. But then, it must be satisfactorily shown to the jury that he was in that unhappy and miserable condition, and at this point, the difficulty meets us and presents two questions. First, what state or degree of alienation of mind constitutes an excusing insanity? And, secondly, did such an insanity exist? The first it is my duty to ascertain and declare. The second it is your province to determine. In ascertaining what degree of insanity will excuse, we may derive some assistance from the reason of the thing, from analogy to other cases, and from settled rules. Reason and good sense teaches us at once that it is not every weakness, imperfection, or fallacy of the human mind that puts an end to our free moral agency and exonerates us from accountability. For in the true philosophy of mind, in reference to moral actions, every departure from truth and virtue is but an act of insanity, the manifestation of a disordered mind as well as a depraved heart. In the case of children of tender years, of 9 and 10 years of age, who have been indicted, convicted, and executed for crime, the inquiry has not been whether by premature maturity of intellect they were capable of understanding and judging correctly of the moral law and all its bearings and relations upon themselves and others, but whether they had intelligence enough to know right from wrong, good from evil, or that they are committing a crime for which they deserved, or were liable to punishment. But without pursuing these remarks any farther, it is enough for me to say that the ablest and most humane judges that ever adorned the judgment seat have repeatedly decided that it is not necessary to render an act criminal and the perpetrator punishable, that every spark of reason should be extinct, that though it may glimmer in its socket and give but an unsteady and doubtful light, yet if enough remains to show it was susceptible of feeling its legal and moral obligation, though not sufficiently strong and steady to discover them and all the bearings and obligations, yet he is responsible and punishable. But if there is an absence and destruction of the reasoning powers, a dark chaos of the mind, incapable of feeling the restraints of law, or of discriminating between right and wrong, or fitful and illusory phantoms of the brain, that presents things in a false light, or imposes upon the disordered intellect as realities, what has no existence in nature, such a mind, thus in ruins, has ceased to be accountable for its acts. I do not mean to say that there must be a total and absolute extinction of the light of reason, if the prevailing character of the mind is insane, if only now and then it is pierced by a lucid ray, but its general character is disordered and chaotic. It would be dangerous, if not cruel, to convict and punish for a crime an individual that's already miserable and pitiable. With these remarks on the extent and degree of derangement necessary to exculpate a defendant, and referring you to the cases that have been read and commented on by counsel, I dismiss this branch of the subject. With this explanation, your next inquiry will be, did such a state of mind exist? In these investigations we can derive, after all, but little practical benefit from the learned and scientific works on medical jurisprudence. We know, for instance, that intemperance sometimes produces insanity, and insanity sometimes shows itself by intemperance. But the difficulty is to tell which is the cause and which is the effect. So in this case, whether a disordered intellect led him into the excesses he committed on board of the steamboat and in the city of New York, or whether those excesses were characteristic of the real moral feelings that led him to the commission of this horrid deed, is a question that the casuistry of doctors can afford us but little help in solving. After all, in their own language, it must depend upon the circumstances of the case. It may be, gentlemen, you will find evidence enough of such an alienation of mind as I have described, and God grant that you may, for we would rather, infinitely rather, find him a maniac than a murderer. And here you will refer yourselves to the evidence. You will remember and try to account for his altered looks and the absence of his wonted cheerfulness after his return from New York. He had left, it was thought, perhaps hoped, at least by the mother, never to return. But he came back. He came back pale and dull. Was it the paleness and dullness of a diseased body, a distracted and deranged mind? Was it the sad effects of his recent debauch and dissipation in the city of New York? If the latter, was that debauch, that disgusting conduct related by his friend Wallace, the actings out of an insane mind or a depraved heart? Was it the paleness of passion, the dull, gloomy, unsocial feelings of a heart bent on mischief? Had a fixed and settled purpose been formed in his bosom to destroy the gem he could not make his own, or was he the unhappy victim of his ardent but misplaced affection? These, gentlemen, are questions to which you must respond, and if anything, in the absence of full and satisfactory evidence of insanity, can save the prisoner, it may be found in the burning eloquence and untiring efforts, the soul-stirring appeals of his able and distinguished counsel. They have done their duty, and if the unhappy prisoner must pay, to injured justice, the forfeit of his life, his blood will not be found on any part of their professional garments. And now let me beseech you, gentlemen, that nothing I have said be understood by you as intimating an opinion unfavorable to the prisoner. I have not intended, in reference to the greater material facts in the cause, to express any opinion either for or against him. My object has been, however unsuccessful the effort, so to conduct this trial, that if the prisoner is acquitted, public justice shall be satisfied. If condemned, he may die in peace with me, and have no occasion to occupy his last lingering reflections with the thought that the court has done him injustice. That such has been my object, I think can confidently but reverently appeal to the searcher of hearts. To his guidance and direction, gentlemen, I fervently recommend you. Go to your chamber, and there in the fear of God, and as you expect to answer for the transactions of this day, at his bar, discharge your duty to the country and to the prisoner, and may the spirit of unerring wisdom, the God of mercy and of truth, preside over your deliberations, and conduct you to such results that neither justice nor mercy shall have occasion to mourn or be offended. End of section 72. Section 73 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Joel Clough for the murder of Mary W. Hamilton, New Jersey, 1833, Part 4. The verdict and sentence. The jury retired, and after an absence of about 2 hours returned into court with a verdict of guilty. While delivering this verdict, several of the jury were dissolved in tears and appeared to feel the effect of the high and solemn responsibility that they had discharged. The prisoner, on hearing his sentence, became much overcome by his emotions and feelings, and almost sunk under the contemplation of his condition. Mr. Brown gave notice of his intention to move for an arrest of judgment, founded on some supposed defects in the indictment, on which he wished a short time to bestow a critical examination, and for this purpose the prisoner was remanded, and the court adjourned to 5 o'clock. Mr. Brown, having signified his intention of communicating in writing with the court on the subject of his motion for arrest of judgment, and when the court reassembled at the hour of 5, information having been received from the Chief Justice that he did not consider such motion sustainable, the prisoner was placed at the bar. The Attorney General moved that sentence of death be pronounced upon the prisoner at the bar. Chief Justice Hornblower. Joel Clough, have you anything to say why judgment of death should not be pronounced against you? Clough. I have, and with uplifted hands I declare in the presence of the ever-living God, I am innocent. There was an attachment between Mrs. Hamilton and myself, and we were at one time engaged. She broke it off. I settled up my business at her request and left the place. There has been much said here about my character, the most desperate part of which is the occurrence in New York. With regard to Mrs. Hamilton's character, I have nothing to say. She was a virtuous and honorable woman, and I loved her. If there is virtue in the Catholic religion, I am prepared. I hope Almighty God will have mercy on her soul. I fear she died unprepared. When I left New York, my mind was greatly depressed. I threatened to take my own life, and she was aware of it. I went to bed that morning and made up my mind to take my life, and sunk into a swoon, as near as I recollect. In this situation, Mrs. Hamilton came to my room. I did not call her. She shut the door. I laid on my bed with my face toward the wall. She said, Clough, what is the matter? I said I felt very bad, and wished her to give me some laudanum. She asked me how much. I said, what you please. She gave me some, and said I must get up. There was a noise in the entry. I said, if you have anything to say to me, say it quickly. I put my hand in my pocket to get out my key to give her. I wished her to possess all that I had. She went out. I went to the door and saw Jane or someone in the entry. I pushed to the door. She peeped through. I was in the act of taking my own life. I had the dirk in my pocket. She came in. I closed the door. I told her I should take my life, and she interfered and put her hand on my shoulder. I told her to go out. I reflected a moment, and after striking her one blow, why did I strike her 11? Why did I not strike my own heart? I was very weak, and the dirk dropped out of my hand, and I could scarcely get to my bed. I was on the point of taking my own life. If she had stayed out of my room, she would have lived, and I should have been in my grave. I feel I am entirely innocent of her blood, for I don't recollect what I did. I was lost at the time. I settled up my business after our engagement was broken off, and went to New York and Albany and returned. I was not myself, and was on the eve of taking my own life. I never called her to my room. She came in voluntarily. If my death is required, I am willing to suffer. It is not for myself. I do not fear death. I have already suffered death. The honorable jury have not sufficiently enlightened on the subject. There are many things yet wrapped in darkness. I knew nothing of Mrs. Hamilton's coming to my room. There are things stated with regard to my character while in Connecticut, which I feel it my duty to contradict. I was appointed, on recommendation of Mr. Mallory of New York, superintendent on the Farmington Aqueduct, where Hopkins was employed as engineer. I considered myself master of my trade, and I soon discovered that he was incompetent to take charge of a work of that magnitude. Under my influence, after a violent personal quarrel, he was removed from that part of the line, and always entertained animosity towards me, and thought when he saw me confined in this box, it was a proper time to show his hatred and malignity. I feel that I am not guilty. I do not fear death, but fear that I am not prepared. The Chief Justice. Joel Clough, after as full, fair, and deliberate a trial as I have ever witnessed in the experience of 30 years' practice at the bar, you have been convicted of the murder of Mrs. Mary W. Hamilton. In the history of this trial, you have had the benefits of able and distinguished counsel, and if you had been their brother instead of their client, the tender ties of such a connection could not have added to the untiring zeal, the laborious and honorable efforts, the exertion of professional talents, the thrilling and soul-subduing eloquence with which you have been defended. The jury were literally of your own selection. You were not captious and troublesome in making that selection, but you did it with prudence and discretion, and not a jury was selected, but in accordance with your own feelings. The counsel for the state conducted the cause with benignity and mercy, but with those talents for which they are distinguished, and that firmness for which as men of virtue and of honor they dare not relax. Your triers, the jurors, have in the most patient and enduring manner submitted to almost unexampled privations and confinement for the period of nearly 8 days, until some, or one of them at least, almost sunk under the pressure of his confinement and his feelings, and by their fixed, solemn, and patient attention to every word and suggestion, must have given you the assurance that they desired not your blood, but most ardently and fervently desired to find you innocent, if that innocence could be found even in the negative virtue of a ruined and distracted mind. And as to the court, it may not become me to speak, but I think in view of that bar, before which you must shortly appear, I can say for my brethren and myself, that we have endeavored so to regulate and control the trial, as to secure to you all the advantages that the fair and impartial administration of justice can extend to the deceased. The final and the fatal result has been recorded, and that record speaks while mind and memory and judicial records last, and will continue to speak you, guilty, 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 of the murder of Mary W. Hamilton, in manner and form as you stood, charged by the grand jury of the county. And who was Mary W. Hamilton? Was she your enemy? Had she done you wrong? Was it her crime that beauty had spread her charms and smiled forth in all the loveliness of virtue, in every feature of her countenance, in the delicacy and elegance of her form, in the chaste and winning manners of her life? And was it because you could not make such a prize your own, that you resolved in the madness of your heart she should never live to bless another man, or make him happy, as she had made the former and lamented husband of her first and earliest love? But I press the inquiry no further. You say you loved her, and yet, mysterious love, you seized the unsuspecting moment of her kind attentions, when sickness, feigned or real, we fear the former, drew her, at your request, with kind attentions to your chamber to administer to your comfort. You seized that moment to plant the fatal dagger in her bosom, perpetrated the horrid deed. She lived to say, "Oh, mother, mother," I screamed. You did not come, and Clough has killed me because I would not marry him. I could not, mother. I could not, you know. I must die. But I forbear. I desire not to extract the dagger from her bosom and plant it in your own. I know your blood will not atone for hers, but I have said this much, that you may see and feel we have a just abhorrence of your crime, and to banish from your bosom all hope of a favorable interference by the court, with that department of the government in which is lodged the pardoning power. Banish, then, we entreat you, from your mind every hope and expectation. Put out at once the faintest ray of hope that may penetrate into the darkest recesses of your cell, and prepare to meet your God. The blood you shed was precious blood, but infinitely more precious is that blood which was shed on Calvary, and on that and that alone we commend you to look for pardon and eternal life. It remains only for us to pronounce the sentence of the law, and it is considered and adjudged that you be taken from hence to the prison of this county from which you came, and there be kept in close and secure custody until Friday, the 26th day of July next, between the hours of 11 o'clock in the morning and 3 o'clock in the afternoon. You be taken to the place of public execution, and there be hanged by the neck until you are dead. And may the Almighty God have mercy on your soul. His escape. A few weeks after his conviction, Clough was detected in attempting to break jail and transferred to a dungeon. Some time after he prevailed on the sheriff to remove him, and was then placed upstairs and, for better security, fastened by one foot with a heavy chain to the floor. By means of a steel pen, he separated a link and accustomed himself to loosing his shackle and refitting it as convenience dictated, and as candles were allowed him, he had burned the window frame at the upper tenon, that it might be removed at pleasure. By removing the frame, an aperture of 6 by 16 was effected. On Saturday night, July 20th, the sheriff left Clough at 11 o'clock. Removing the shackle and frame, and stripping off every article of clothing, he made an attempt to press through, but failed. He then rubbed himself with soap, and after a tremendous effort, succeeded. Dressing himself, he commenced scaling the wall. He gained the summit by boards found in the yard, and when there, descended again into the yard to lengthen the rope he had provided for letting himself down on the outer side. He thus wasted time and strength, and it was with the greatest difficulty, and after giving up in despair, that he regained the top. It was now daylight, and steering for the woods in the direction of Philadelphia, secreted himself about 3 miles from there. Alarm was soon given, and many citizens armed themselves and commenced scouring the country. One individual passed within a few feet of him, but he was first observed by a colored man, who saw him come out in the evening to the woodpile. Word was speedily conveyed to the town, and many citizens repaired thither, occupying every avenue and byway in that vicinity. About 10 o'clock he was seen by 2 of his pursuers. They knew him, and after interchanging a few words seized him. He offered no resistance, but begged most pathetically. "You know, gentlemen," said he, "that I have worked hard for my life. Do, for heaven's sake, let me go." They were not to be moved from the strict line of duty, and being speedily joined by several associates, Clough was soon remanded to prison. Great rejoicing was manifested on his being arrested, which was proclaimed by long and repeated ringing of the courthouse bell, firing of guns, etc. When Clough was recaptured, he was taken to a house nearby to get something to eat. While eating supper, one who was most active in search of him came in and exclaimed, "Halloo, is this Clough?" Clough then looked up and replied, "Yes, that is my name." "Well, sir," said he, "I have been looking for you all day. Where the devil have you been?" Clough remarked, "I have not the honor of your acquaintance. Who are you, sir?" "I am the devil." Clough laid down his knife and fork and looked very significantly at him, and replied, "The scriptures tell us to despise the devil and his words." His confession. Some days before his execution, Clough wrote out the following confession, which he delivered to his attorney, requesting them not to give it to the public until after he had been laid in the silent tomb. "For," said he, "the finger of scorn will no longer be pointed at me, and the opinion of the world will pass by my cold, stiffened corpse unheeded. The subsequent facts connected with the history of my unfortunate life are true, and are dictated with no other intention than to discharge from my mind all the facts and give the public the leading acts of my life, the motives and causes that impelled me to the commission of minor crimes, and also in regard to the great and awful crime for which I am prepared to suffer the death that human laws and public justice requires. I was born in Unity, County of Cheshire, State of New Hampshire, November 24, 1804. My father, mother, and the family generally sustained a respectable station in society. I had 4 brothers and 2 sisters, I being the youngest of the family. More than ordinary pains was taken by my parents to instill into my mind proper principles and furnish me with a suitable education. I was sent to school in New Hampshire, where I remained until my father sold his property in that part of the country and removed to Rochester in the state of New York. I was then, as near as I now recollect, about 14 years of age. During this time, I am not aware of having been guilty of any improper acts, other than those that are generally connected with schoolboys of my age, except in the indulgences of a most vindictive passion. And here I will observe, and it gives me deep pain and anguish to make the remark, yet I do it for the benefit of those I leave behind, that this passion, this unhappy temper, has been the besetting sin of my life. I being the youngest child, I was gratified by my dear parents in all those indulgences that my boyhood could suggest. Yet it was sometimes the case, when my wishes were foiled, I would burst out in the most violent passion, and while in this rage and frenzy, using the most profane language, and even denouncing my parents in the most inhuman manner, they would, instead of chastening me in a proper manner, grant me my request, and even hire me by presents to cease in my passion. And while at school, it was frequently the case that when my playmates and companions became victorious in the various games we were playing, I would fly into a rage and threaten them in the most violent manner. There is one incident, however, that occurred while I was at school at Unity, which, although I was not the actual instrument that committed the act, yet I was present in the secret. Indeed, I was indirectly instrumental. Near the schoolhouse lived an old friend who owned a fine apple orchard. Myself and some few of the schoolboys would frequently repair there between school hours and steal apples. Upon one occasion, we were detected by the old gentleman, who made our parents and teacher acquainted with the fact, and the consequence was that we received a severe flogging from the teacher, which my passion was illy calculated to brook without entertaining feelings of revenge, and it was soon agreed amongst us, the larger taking the head of the business, that we would satisfy our revenge by burning down the old gentleman's barn, which was done soon after, about 1 o'clock at night, during a most violent thunderstorm, which shielded us from all suspicion of the act, it being supposed to take fire by the lightning. Nothing more was afterwards heard upon the subject, and, until this time, remained a secret. My father remained in Rochester but a short time, engaged in no particular business, when he purchased a farm in North Murray, Orleans County, about 30 miles west of Rochester, and here he removed with all his family, which I think was in the year 1817. My eldest brothers were kept to work on the farm, and I was sent to school, where I remained the greatest part of the time that my father lived, and was, as usual, indulged in by foolish whims. While at school here, I contracted a fondness for playing cards, for amusement, but it soon grew more fascinating, got a greater hold of me, and I could only find amusement in playing for money. I was pretty successful at first, and enticed deeply in the game, and frequently would lose all I had won, and more beside. And when that was the case, I was seen to get mad, and charge those that I had been playing with dishonesty, which would frequently create a fight, and then I would use anything that first came into my hands, club, knife, or anything. At this time I was but 16 years old. When I could not get money honestly to play cards with, I would get it dishonestly. I had frequently got up at midnight, went to my father's clothes, taken the key from his pocket, got to the desk and take out $2 or $3. I was, however, soon detected in this by my father, who only scolded me for committing the theft. This was my course of conduct until my father died, when I was in my 17th year. At his death, he left his property, which was but little, to my mother. Very soon after the death of my father, it was found necessary to dispose of his children, as the property he left was entirely insufficient for their maintenance, and I was bound an apprentice to Oscar Mallory to learn the trade of brick and stone mason. I soon made myself useful to my master. Indeed, at this time, I had seen the error of my ways, and saw the necessity of exerting myself, which I did, leaving off many of my bad habits, playing cards in particular. And I so conducted myself as to obtain the entire confidence of my master, and I am not sensible that I ever defrauded him out of 1 cent. When I arrived at the age of 21 years, I was a complete master of my trade, and so much confidence did Mr. Mallory place in my ability and honesty that he gave me a power of attorney to manage the construction of the Farmington Aqueduct across the Farmington River in the state of Connecticut. I went there to take the whole control of the mason work, and while engaged in constructing the aqueduct, I had some difficulty with one of the sub-engineers, who gave some orders to my workmen in my absence, different from those I had previously given them, and when I returned, we had a severe and serious quarrel. I reported him to the chief engineer, and the result was, for his misconduct under various occasions, dismissed from the works. And here I will again observe that however culpable I may have been for many of my acts in this instance, I believe I was in the right, and that gentleman, God forgive him, was wrong. In the quarrel we had, I recollect, I became very violent, and perhaps, which I think I did, threatened his life if he again interfered in my business. After the difficulty with the engineer was over, we progressed with the work until it was entirely completed to the satisfaction of the chief engineer, who gave me a certificate of the fact. I then returned to Mr. Mallory, who was entirely satisfied with my conduct. I remained in the state of New York for some time, not being engaged in any particular business. I soon fell, gradually, into the habit of playing cards, and acting dishonestly while so engaged, either by taking advantage of the ignorance of those whom I was playing with, or treating others in the best way I could. While in the village of R, I went frequently in company, and soon formed an intimacy with a female of that village. She was young and handsome, and enjoying a reasonable share of the happiness of this world, with a respectable and wealthy aunt, having lost both her father and mother. Our intimacy soon grew into a strong attachment, particularly on her part. On seeing this, I took advantage of her confidence and misled her. I ruined her by false vows and lying protestations of love, and often had prayed to my God to forgive me for this, my blackest act of villainy. I saw her situation and fled from the place, and shortly after I heard of her death. She died in giving birth to the fruits of my villainy. I went to Bristol, Pennsylvania, and engaged in a contract with Morris and Dorrance to build an aqueduct across Knowles Creek on the Delaware division of the Pennsylvania Canal. I completed this contract to the entire satisfaction of Messrs. Morris and Dorrance. While engaged in Bristol, I indulged in all kinds of dissipation, except that of intemperance, almost every night playing cards or some of the games for money, acting in the most dishonest manner, cheating and defrauding whenever a proper opportunity offered. Upon one occasion, while at that place, in changing money for an old gentleman, I passed on him 2 counterfeit $5 bills at the Camden Bank, which I had but a few days before purchased for 50 cents. I left Bristol in 1829, and engaged a contract on this Morris Canal as a partner with an individual by the name of James Detroit. to complete one section in 3 weeks near the residence of Charles I. Eyre in Greenwich, within 1.5 miles of Easton, Pennsylvania, and in consequence of my partner not fulfilling his part of the agreement by furnishing the necessary funds for progressing the work. It proved to me an unprofitable job, being obliged to hire money. I, however, completed the work through the assistance of some kind friends, particularly Charles J. Eyre, who knew how I was situated, and he for his kindness has been remembered in my prayers. I arranged all my business here, and left for Bordentown in March 1831. When I first came to Bordentown, I went to the house of Elias Thompson, and there took boarding, and soon got engaged in the employ of the Camden and Amboy Railroad Company, and remained in their employ as contractor and otherwise until August 1832. I remained at the house of Elias Thompson about 2 months, when, through the persuasion of some of my friends, I left there and took boarding at Mrs. Longstreth's. At this time, Dr. Hamilton, the husband of the unfortunate Mrs. Hamilton, was living. He died, however, a short time after I went there. I soon experienced a most violent attachment for Mrs. Mary W. Hamilton, and very soon after her husband's death made advances to her, which, like a wise and prudent woman, she refused at the moment. This, however, did not discourage me, supposing it was in consequence of the too recent death of her husband. I then made up my mind to wait until the sufficient time elapsed, when I could, without indelicacy, press my suit. I will not, however, neglect to mention that during this time I did not omit working ardently so as to approach her under color of friendship, doing many little favors for her and her mother, Mrs. Longstreth, for the purpose of keeping in her favor, and paving the way for a bolder effort at a proper season. I was so completely captivated by the charms of Mrs. Hamilton that I could hardly suffer myself to be out of her sight a moment. Indeed, almost entirely neglecting my business, yet at the same time took good care to have my rolls made out sufficiently large to cover all my neglect. My enormous demands on the paymaster, Mr. Shippen, finally excited his suspicion, and he refused to pay me the amount of my roll list, and told me that he believed I kept false rolls. We had a few hard words when he referred me to Mr. E. Stevens for settlement. I went to him, and managed so as to come out clear of all suspicion, although I did act very dishonest in many instances. I soon began to see the necessity of exerting myself to make an impression and win the affections of Mrs. Hamilton. I made my advances towards her, and they were received at first with apparent good feeling and satisfaction. I continued there until we became quite intimate. I was frequently in her company, privately, yet she always acted with prudence and discretion. She went to pay a visit to her friends at Princeton. I inquired of her mother, Mrs. Longstreth, and ascertained the time she wished to return home, and went up in a gig to bring her. She appeared glad to see me, made inquiries of me about her family and friends. We came home together the next day, and her conduct towards me during this interview gave me much encouragement. During our frequent associations together, for they had by this time the entire part of the summer 1832 become very frequent, I observed I had a rival in my way, in the person of my friend William Lee Wells. I soon found that he was warmly attached to Mrs. Hamilton, and was jealous of my attentions. I no sooner discovered this than I sought and had an interview with him. He told me Mrs. Hamilton and himself were then engaged to be married, and at a certain time it was to take place. This was confounding news to me. I could not understand it. She had given me encouragement, in public and private, and I could not believe it was the case. I looked upon it as a mere tale, for the purpose of inducing me to withdraw my attentions from Mrs. Hamilton. A few evenings after this conversation with Wells, I was in company with Mrs. Hamilton in the back dining room. We were alone. We began to talk about Mr. Wells. I introduced the conversation for the purpose of ascertaining her opinion of him. I soon discovered that she was not indifferent towards him. She told me he was wealthy, that he had several $1,000s in cash, and that he was a gentlemanly man. I then discovered myself involved in a difficulty I never anticipated. I knew, however, Wells was not worth a cent, and that I had it in my power to destroy his prospects in Bordentown. He was engaged on the railroad. I made use of the means in my power, and did succeed by dishonest means to make a bankrupt of him. He, however, continued his addresses to Mrs. Hamilton. I then went to Philadelphia on business, and while there, Mrs. Hamilton and Mr. Wells came down. Wells did not know that I was in the city. As soon as he discovered the fact, he charged Mrs. Hamilton with having concerted the plan to meet me there. She denied it, and correctly did so, but she did not know I was in the city. Wells left the city. I waited on Mrs. Hamilton about the city, to the museum, theater, parties, etc. I left her in the city and came up to Bordentown. In a few days she returned. She then gave me to understand that she was satisfied with my attentions in preference to Wells. She had discovered Wells in many misrepresentations. She told me she was mistaken in the man, that he was not the kind of man she first supposed him to be. Wells did not appear to abandon his suit, but persevered. I again called on him and told my situation towards Mrs. Hamilton, and that I had discovered the falsity of what he told me, and that he must retract what he had told me, and cease visiting Mrs. Hamilton, or he or I must die. He looked at me a moment and asked me if I was in earnest, and with an oath I swore I was. He then told me that she had deceived him, and she would deceive me. I told him he must not say so to me. It was slandering her, and that she was not capable of deception. He saw that I was serious, recalled his words, and left me. In a few days after this, he was discharged by Mrs. Hamilton, after she had told him how he had deceived her. Wells had ardently attached to Mrs. Hamilton, and the attention by her had a serious effect on him. He was almost deranged, and in consequence of her treatment, he took a large quantity of laudanum, but not a sufficient quantity to destroy his life. He called on me while in this sorrowing state of mind. I pitied him. He told me his situation of mind, and that he was out of money. I loaned him some. End of section 73. Section 74 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Joel Clough for the murder of Mary W. Hamilton, New Jersey, 1833, Part 5. A few days before he left Bordentown, he asked to speak with me privately. We went into a room together. He there told me all his troubles, and how his business had been destroyed, his character slandered, and the treatment of Mrs. Hamilton. He was not aware, poor deluded and misused man, that I was the individual who had ruined him. He cautioned me to beware of Mrs. Hamilton. He said she had acted the coquette with him, and that she was conscious of her beauty and fascinating manners, and her only object was to attract admiration and secure the attention of gentlemen. I stopped him in his career of talking by telling him if that was all he had to say to me, I could not listen to him, and that I did not believe Mrs. Hamilton capable of acting with duplicity. This was my last interview with Mr. Wells. I was the cause of his ruin. He left Bordentown in a few days after this, and I did not see him again until I saw him on my trial as a witness. I now had frequent intercourse with Mrs. Hamilton, who appeared to be well satisfied. Indeed, she favored my attentions at all times. Our conversation in private was generally upon the subject of matrimony, and from our intimacy and living under the same roof, we conversed with freedom upon almost every subject connected with our intentions. She, however, with all the prudence she was so highly favored with, showed no advancing disposition, but appeared rather reserved than otherwise. I, however, possessed for her that deep and abiding love, that pure and unsullied affection, that formed and prepared me to overcome every difficulty, that I might enjoy her company, and secure her as a companion. I was determined, at all hazards, boldly to demand her hand, and if refused, to press my suit. Still, however, until I should be able to make an impression on her heart, and reduce it to my will, and I soon enjoyed, as I suppose, the pleasing hope. We exchanged many presents. She received mine with apparent pleasure, and seemed to manifest an interest in my business and prospects. I paid her and her little daughter every attention, the latter for the purpose of securing more strongly the affections of the mother. But all did not answer my great purpose, for whenever I approached her as a suitor and sought her hand, she immediately avoided me, and yet at other times she appeared glad of my company, and gave me much encouragement. In my frequent absence from Bordentown, I would write to her, and in my letters I would portray the anguish of feelings, the violence of my attachment for her, and request of her to answer my letters. She did not. She never did. During this time, in the winter of 1832, a Mr. Dayton came to board in the house of Mrs. Longstreth. He was a young man, a lawyer by profession. He had not been there long before I discovered that he was not my friend, and that he was doing all in his power to induce Mrs. Hamilton to discard me entirely. No sooner did I ascertain the fact than I commenced my attacks upon him, and upon every occasion when opportunities offered. Before the family of Mrs. Longstreth, I would express my opinion of him very fully, and not at all to his credit, and at last it came to his ears. We met, and many violent words passed between us. I told him I was ready to give him any satisfaction he required, and in any way he wished. I was wrought up to a fit of frenzy, and would have taken his life in a moment, had he not ceased his conduct towards me. I heard no more of Mr. Dayton for some time. I was engaged with Mrs. Hamilton. We went out riding and walking together frequently. She appeared still fond of my company, and encouraged my attentions, and beyond that I could obtain no satisfaction, either by words or acts. In February, I presented her with a ticket to go to the 22nd ball, and engaged to go with her, but when the time came, I found there was some difficulty with her, and I soon ascertained that it was because she had promised to go with me to the ball. As soon as I heard that, I told her to go with whom she pleased. She said she had no particular objection in going with me, except that it would increase and give credit to the report afloat that we were soon to be married. I thought that a proper excuse, and released her from all engagement she had made with me. She went to the ball in company with Mr. Dayton, and returned with Mr. E. Stevens, as I was informed. After this she treated me with coolness, and I was satisfied it was in consequence of some communication made to her by Dayton. I sought to ascertain from her the fact, but could not. She requested that I would cease visiting her. I asked her for her reasons, but she would not give me any. I afterwards understood the cause of her not wishing to go to the ball with me. Mr. Dayton had told her if she would go with him to the ball, he would introduce her to Mr. Stevens, a young gentleman of immense wealth, and one who had expressed for her a considerable attachment. This, doubtless, was the cause of her refusing to go with me to the ball, and afterwards refused my attentions. The anguish of my feelings at what I supposed to be the misconduct of Mrs. Hamilton in treating me in this manner, after she had given me every reason to believe my attentions to her were agreeable, was too great for me to suffer under. She had never agreed to marry me, but had led me along in such a manner as to induce me to believe she would one day have me. I was determined still to persevere, vainly believing that I might yet succeed in bringing her back to me. I went down to Philadelphia with Mrs. Longstreth, her mother, who had just recovered from a spell of sickness. I paid her every attention while going down to the city, and while in the city. On board the steamboat, I entered into conversation with Mrs. Longstreth about the conduct of Mrs. Hamilton. I thought to succeed in gaining her interest in my favor. I had done much to assist Mrs. Longstreth in her business, collecting her moneys, etc. I recollect telling her in the conversation that I looked upon Mrs. Hamilton as a female of the choicest character, and embracing every requisite calculated to please and render a man happy, and that I entertained for her feelings of the strongest kind, and that my friendship for her was greater than for any other woman living. Mrs. Longstreth replied to me, and said she did not doubt it for a moment, and that she was very sorry that Mrs. Hamilton did not go to the ball with me, if she had accepted the card of invitation, and that she had told her she had done wrong. She said she believed the whole difficulty arose in consequence of the improper interference of Mr. Dayton, and that she believed Mr. Dayton was much disappointed because Mr. Stevens did not return home with Mrs. Hamilton. People, she remarked, consider Mr. Stevens a bad fellow among women, but, added she, I would not be afraid to trust him at any time or in any place with Mary. I asked Mrs. Longstreth if she knew what opinion Mrs. Hamilton entertained of me. She answered me that she always spoke of me in the highest terms, and defended me upon all occasions. This was a great consolation to me, and tended to increase my hope. Mrs. Longstreth knew of my having made Mrs. Hamilton a present of an album, a gold watch, a variety of rings, and other articles, and she remarked to me that she did not approve of ladies accepting presents from gentlemen, rings especially, unless there was an engagement to be married. For, she said, Mrs. Pitcher accepted a ring from a gentleman, and favored the attentions of another, and was afterward attended with much difficulty and trouble, and that she always told her daughter not to accept rings or other presents of that kind, unless they were so engaged. When we arrived in Philadelphia, Mrs. Longstreth requested me to write to Mrs. Hamilton, which I did, informing her as to the health of her mother, and the time she contemplated returning. While in the city, I paid every attention to Mrs. Longstreth. I waited on her upon every occasion. I felt it my duty to do so, for she always treated me like a mother. While laboring under this state of excitement and uncertainty, I felt that I was prepared to perform any act that would facilitate my views and gain my point with Mrs. Hamilton. My love for her was violent. I felt I could not be satisfied that she should escape from me and be enjoyed by anyone else. I, however, began to experience a slight change in my feelings towards her, for I had become almost satisfied that she would refuse my addresses. I was determined, however, to make one more effort and attempt, if possible, to gain her esteem. I used every means in my power. I made her additional presents, which she accepted with apparent satisfaction. I urged her by every consideration of future happiness to believe me in my protestation of love, and assured her I possessed the means of making us happy. She listened to me attentively, and at last told me she could not love me, she could not marry me, and she requested me to take all the letters that I had written to her, and urged me to leave her, and never again speak to her upon the subject. I received the letters, and we parted. At that moment, my feelings of love changed into the most inveterate hatred. I resolved on revenge. It was with the greatest difficulty I could at all restrain my feelings. I set myself about settling up my business, of which I paid but little attention to for a long time, for I had neglected almost everything to wait on Mrs. Hamilton and enjoy her company. After I had closed my business, I went to Philadelphia. My feelings had become perfectly abandoned. I became dissolute and indulged in all the vices of the city, visiting the sinks of vice and misery. Indeed, I became regardless of all consequences. I felt that I had been trifled with, and had been a dupe to the convenience of Mrs. Hamilton. I visited one evening a house of ill fame, and there I made an engagement to remain all night with one of its dissolute inmates. In the morning, I awoke early and robbed the woman of many articles of jewelry of considerable value, particularly a gold watch, which I afterwards sold for $45. I left there the next day and went up to Bordentown, packed up all my clothes, paid off all my bills, and made arrangements to leave for New York. I told the family and my friends generally that I did not expect to return again. I left my trunks in the care of Mrs. Longstreth, told her I would send for them, and went on to New York. I remained there some days, indulging in all kinds of dissipation, visiting the theaters, visiting bad company, and committing larcenies of various kinds. While there, I committed a larceny similar to the one in Philadelphia, and the next day left for Albany. When I arrived in Albany, I disposed of the watch and jewelry I had stolen from the females in New York and Philadelphia to a jeweler in that place for a watch of a different kind and a valuable set of jewels, which I intended for Mrs. Hamilton on my return, when I intended to make my last and final effort. While on board the steamboat to take my passage for New York, I met an old friend who accompanied me down to New York. He observed to me that I appeared much changed from what I was when he last saw me, and that I showed a stronger disposition to drink. He wondered at the change, and spoke of it frequently, inquiring the cause. I did not satisfy him. We arrived in New York and took lodgings at different hotels. I had not been in New York but a short time before I was taken in custody by the police, charged with stealing the jewelry. I went before the officer. I then employed counsel. While at the office, my friend had discovered my situation and had come down to the police office to assist me. My counsel, Mr. Wiles, succeeded in getting me out of the difficulty, but it was attended with the loss of all my money, and I was obliged to leave in the hands of my counsel my gold watch and the jewels I procured in Albany as a security for his fees. They were afterwards redeemed by my friend for $65. As soon as I got completely relieved from this difficulty, I returned to my lodgings. I retired to a room to reflect on the course to pursue. My feelings at that time were indescribable. I felt that I had been trifled with, neglected, discharged, and despised. I felt that I was alone in the world, and no one to feel any interest in me. My very existence appeared to me a burden. While ruminating in this horrible state of feeling, I suddenly became nerved and strengthened in my feelings of revenge. That dreadful feeling appeared to me as a consolation. I determined to seek another interview with Mrs. Hamilton. I would appeal to her feelings once more, and if I should be rejected, I would pursue the dictates of my revengeful feelings. I left New York on Thursday, the 4th of April, 1833. Determined on the course I intended to pursue. I arrived in Bordentown about 4 o'clock in the afternoon. I repaired immediately to Mrs. Longstreth's, and in going through the hall of the main building, I met Mrs. Hamilton. She was in all her former loveliness. She met me with a smile playing about her lovely mouth, and shook hands. My hardened feelings relaxed. There was a momentary change in my determination, and for a moment, instead of possessing the feelings of a demon, I possessed the feelings of a man. Oh, my God! Why were they again changed? Why were they again suffered to return? Why was I made the instrument to remove from the world an angel, and throw a dark and heavy gloom around a once happy family? But I cannot dwell thus. She inquired about my health, asked me with a feeling of sweetness about the health of my mother, whom she supposed I had been to see. She inquired of me if I would have dinner. I declined. She looked me in the face and said, "Clough, you are not well." I answered her, I was not, and she knew well the cause of my disorder. We parted at the foot of the stairs. I went up to my room. When I got there, I threw myself on the bed almost exhausted. I remained there some time in a state of uncertainty as to the course I would adopt. I was called to supper. I went down. I could not restrain my feelings. I returned again to my room and threw myself on the bed. In a few moments, Mrs. Hamilton came to my room. She informed me that tea was ready and wished me to get up and take some. I told her I wished no tea, and that my feelings were such that I'd rather die than live, and that she was the cause of all my troubles. She made no answer, but turned away and went out of the room. In a short time she returned with her cousin, Mr. Eastburn. When she entered the room, she remarked to Mr. Eastburn that I was quite unwell, and that she thought if I would come downstairs and taste some supper and walk about the town, I would soon recover my health and spirits. She again went out, leaving Mr. Eastburn in the room with me. We conversed together about 20 minutes when he left the room also. I got up and went downstairs. I heard my name mentioned several times in connection with Mrs. Hamilton's, in terms of derision, and particularly by Mr. Dayton. He seemed to be aware of my situation of mind and body, and from his conversation appeared to exult in my misfortune. I went into one of the rooms where I found Mrs. Hamilton, seated with some company. I there heard much calculated to excite my passion. The conversation appeared to be about a Mr. Lippincott, and his addresses to Mrs. Hamilton. It was directed to her, and she appeared to be delighted with the association. Someone asked her when they were to be married. I could remain no longer. My brain turned. My heart contracted. I was mad with agony. I reeled out of the room. My feelings became wrought up to the highest pitch of desperation. As I left the room, it appeared to me as if Mrs. Hamilton laughed at my misfortunes and gloried in the trouble she had led me into. I retired to my room and threw myself on the bed. About 10 o'clock, Mrs. Longstreth and Mrs. Hamilton, as they were going to their lodging room, stopped at my door and inquired if I would have anything. I thanked them and answered that I wanted nothing. They retired to their bed. I arose and went downstairs, was gone about 15 minutes. I returned to my room, unlocked my trunk, and from it I took a dirk. I unsheathed it. I held it before my eyes. Fatal instrument. It was a present from Mrs. Hamilton, the property of her deceased husband, and given to me at a time when I supposed she loved me, and when I was anticipating every happiness. I examined it again and again. I recollected when she gave me that fatal instrument, she also gave me a lock of her hair. I sought the hair and found it. I examined it also, and after a long, horrible, demon-like reflection, I fully resolved, that she must die. I smiled to think that the dagger she had given me, and which I then held in my hand, unpolluted, should be the instrument in my hands to seek her heart's blood, and see it ooze for vengeance. Returned to my bed and slept soundly, for I was calm and collected. My hellish purpose was fixed. When I arose in the morning, I felt refreshed for a few moments only. The thought of murder flitted across my mind. The horrors of shedding innocent blood presented itself to my senses. The conflict at that moment was great, but my revengeful purpose prevailed. Mrs. Longstreth came into my room. She bade me good morning and asked how I felt. I told her no better. She held an orange in her hand and desired me to take some of it. I told her I would rather not. She urged me and said it would take the bad taste out of my mouth. I then accepted a part of it. She requested me to go down to breakfast. I told her I did not wish any. She, however, manifested so much solicitation and interest for me that I consented to go to the table. When I got to the dining room, I found the company seated at the table, Mrs. Hamilton at the head of it. She appeared to be in the most glowing spirits, laughing and talking with everyone. As I entered the room, I passed the salutations of the morning and seated myself at the table. Everything appeared to be said and done for the purpose of aggravating my feelings. After I had helped them that were around the table, I drank a little coffee. I could remain no longer. I left the table. I wandered about the town until nearly 11 o'clock, when I returned to the house again. Mrs. Longstreth remarked to me that I appeared very dull. I went to my room. Nothing of importance occurred throughout the day. In the evening, while I was in my room, Mrs. Hamilton came there and seated herself on the foot of the bed. She asked how I felt. I told her I could not describe my feelings. She remarked to me that I was doing myself great injury by giving way to my feelings. I told her I could not help it, and I did not care how soon I was dead. She arose from the bed and said, "Why, Clough, you frighten me." I, at that moment, had my hand on the hilt of my dagger, and was at the point of drawing it. I looked in her face and found her gazing at me with her former sweetness. I was overcome. I could not have used the dagger at such a moment. I fell back in my bed. I lay a few moments. My strength returned. She was still sitting on the bed. I told her as soon as my health would permit, I wished to go to Philadelphia to arrange some unsettled business. She knew, for I had informed her of my misfortune in New York. Giving the particulars, she knew I had by some means lost all my money, my watch, etc. She told me if I wished to go to Philadelphia, she would let me have her watch, and what money she had if I would accept it. I declined receiving anything from her. I could not understand the motives that induced her to make the offer, unless it was for the purpose of returning the watch which I had presented her in exchange for an old-fashioned silver one. I again reminded her of my situation, and of her being the cause of my troubles, at the same time telling her that I had given up all hopes of marrying her, and that I cheerfully forgave her all the wrong she had ever done me. I'd done this for the purpose of again trying her feelings, for my mind at that time was fully decided upon the destruction of her life. She replied to me that she was sorry that she was the cause of my troubles, and would be glad to relieve me in any way she could. She told me that she entertained for me the strongest friendship, but that she could not marry me, for she did not love me, and that I must give up all hope on that subject. She then left my room. I arose from my bed and walked about town for some time. I returned to my room with renewed feelings of desperation. I retired to my bed and slept soundly until the morning. Saturday morning arrived. I arose early, went down to my breakfast. I had no appetite. I soon left the table and took a short walk on the bank of the river. I returned and went into the front parlor. There I found Mrs. Hamilton and her little daughter, Caroline. I sat down on the sofa. Caroline came to me. I asked her to play for me on the piano. I gave her my music book. At that time, I was laboring under the most horrible feelings that can be imagined. I left the parlor and retired to my bedroom, fully prepared, the first opportunity that offered, to take the life of Mrs. Hamilton. I placed the dagger in my pantaloons pocket and threw myself on the bed and fell into a doze. About 12 o'clock I was awakened by someone who opened the door. My back was towards the door of my room. I turned over and found it was Mrs. Hamilton. She spoke to me and roused me up. She asked me if I heard her come into the room. I told her I did not, that I was asleep. She asked me how I felt. I told her very badly. She came to inform me that dinner was near being ready, and wished to know if I would have anything in particular to eat. Her motives for coming into my room was of the purest kind. She came in consequence of the indisposition of her mother to administer to my wants. In answer to her inquiries, I replied that I could not eat anything. I asked her to give me some laudanum, that I might sleep. The vial containing about 1/4 of an ounce of that liquid was standing on the table at the head of my bed, for it was the only time I felt free from my troubles. She prepared some, mixed with water, how much I cannot say, handed it to me, and I drank it. I expressed a wish to get up, but she observed my weakness and desired me to lie still. I insisted on getting up and succeeded, hardly able to stand and support myself. I leaned on her shoulder. While in this situation, someone was heard in the entry, when she observed to me, "Clough, I should not like anyone to know I was alone with you in this room." At this moment there was an awful conflict going on in my breast. My strength, perhaps, from the effects of the laudanum, was returning. I could hardly restrain myself for a moment. I knew her danger, and requested her to go out. I raised myself from her shoulder. She opened the door and walked into the entry, and there she found the black servant girl. She gave her some orders about dinner. My strength had entirely returned. I felt an exhilarating joy in my bosom. I felt my revenge was near. My determination became fixed. I put my hand in my pocket. I felt the dagger, and it appeared to me that I possessed the strength of a Samson. I seated myself on the side of the bed, waiting her return. She came in and shut the door after her. She came up to me. We conversed some time. I told her I wished her to take the keys to my trunk, and putting my hand into my pocket, I pulled out the dagger, and in an instant rushed from off the bed, struck her with it in the breast. She fell to the floor. I looked at her for a moment. I could not see her face. Her head was bent down. I hesitated. She arose, and while in the act of fleeing, I struck her again in the left breast. The dagger passed up to the hilt. I drew it and repeated the blow. She screamed for help. I could not see her face. It doubtless would have unnerved me. The fourth blow of the dagger did not penetrate, but glanced through her arm. She grasped me by the neck, and someone opened the door. She gained the door, with my left arm around her, and her right hand hold of my collar, while standing in the door with the dagger uplifted. Her youngest sister, Elizabeth, I think, rushed forward and seized my arm and exclaimed, Don't, Mr. Clough. Don't kill her." I shook her from my arm and struck the blow. The dagger pierced the breastpin and was for a moment fast. I drew it back and struck again. She then fell in the entry, still retaining her hold of my collar. She drew me down. I recovered on one knee and held her up in my lap, with her left breast exposed and turned towards me. I here twice or thrice buried the dagger in that innocent bosom. She turned her head towards me for the first time in this tragic sense. She spoke. I saw that lovely face. It was calm. She breathed in low and almost indistinct accents. "Oh, Clough, 'tis done. I can't marry you. I die." Here the dagger fell from my hand. My strength, too, failed me. I released her from my hold and fell back. She sprang on her feet and ran downstairs screaming and hallooing, "Oh, mother, mother!" I could hear her no more. I crept to my room and succeeded in getting on the bed, completely exhausted. My rage ceased, my revenge satisfied. But I had neglected one consideration. I had forgotten to take my own life. I felt satisfied. I soon ascertained she was dead. This was joy to my heart. I was happy and gloried in the result. At that time, I cared not for life, but I was gratified that I did not imbrue my hands in my own blood. The rest is known. I never realized the great importance of my situation until since my trial, when I have felt all the horrors of a hell within my bosom, and a curse upon my head. Often have I seen that lovely woman in my midnight dreams, in perfect loveliness, and wondered to myself how I could shed her heart's blood. I have prostrated myself before my God, and implored him to give me signs of his forgiveness. She knew my supposed wrongs, and how they operated upon my poor weak nature, and converted the tenderest affection into the most deadly hatred. I have suffered days and nights of sleepless anguish. My heart has been preyed upon by the worm that never dies, and my brain has been burned with an unquenchable fire. I have suffered 100 deaths, and gladly would I have suffered 100 more, could I be satisfied that the innocent woman that I sent so suddenly from time to eternity was safe in the hands of her God. Pride of character, and uncurbed passion, fondness for cards, has become the ruling and besetting of my life, and my prayer to heaven day and night is that all my sins be erased from the register of heaven, and that the whole world may be brought to see the folly of worldly goods, and direct their attention to things of godly importance that exist eternally. I have committed sins of the deepest and blackest dye, but through the blood of Jesus Christ, I hope and earnestly pray that I may be redeemed, regenerated, and saved from the pit of perdition and the tortures of hell that I so justly deserve. Remember, reader, when you peruse this brief sketch, which, as far as my memory serves me, is correct, when you wonder at the crimes I have committed, that human laws have been satisfied with an atonement of my blood. The execution. On the 26th of July, 1833, the miserable man was placed upon the scaffold for execution. He rode from the prison attended by Reverend Mr. Morehouse, Reverend Mr. Wilmer, and the sheriff, followed by about 12,000 persons. The place of execution was situated about 2 miles from Mount Holly, in the center of the highway. At about 12 minutes after 1 o'clock, a hollow square was formed around the scaffold by a battalion of infantry, consisting of about 500 men. Clough ascended the scaffold with a firm and resolved step, arm in arm with the clergy who accompanied him, followed by the sheriff. He was dressed in white. The fatal rope was coiled around his neck and breast. He looked upon the crowd, and then seated himself on a chair, apparently exhausted by his exertion. A hymn and prayer opened the religious exercises. Clough wept profusely, and seemed now to see his situation. His farewell letter to his mother, and an extract of his confession was read. The clergyman then shook hands with him, and he seemed much affected. They descended, and the sheriff approached him. Clough stood firm as the marble statue, and stared death in the face, with a calm resolution and determined countenance, and conversed freely with the sheriff. He assisted him to place the knot under his ear, shook hands with him without emotion. The cap was then drawn. The sheriff descended, and in an instant the victim of justice stood before his Maker to give an account for the deeds done in the body. Letter from Joel Clough to his mother, written only 48 hours before his execution. Mount Holly, July 24th, 1833. Dear Mother, I hope that the agonizing feelings which my situation has caused you have not been the means of consigning you to the tomb. But I am fearful ere this letter reaches you, it will find your place vacant. But should you live to receive it, I enjoin upon you by all the ties that ever existed between a mother and son, to strive in your advanced age to bear up under the awful and solemn result of my execution, which must take place in 48 hours from this time I am now addressing you. I have at this time chains upon my legs and handcuffs upon my wrists, yet I feel that I cannot leave this world without imparting to you a pledge of my affection. Yes, to you, Mother, who watched over my childhood. It was my duty to be a staff and support to you in your advanced age. But circumstances are different. The only comfort that I am able to afford you now, at this very late hour, is that I feel I shall be prepared to meet you in heaven. I am so well satisfied that it is through the Lord Jesus Christ that sinners are to be saved. That is in Him alone that I put my trust. Believe me, dear Mother, my only hope is in Him who can save the greatest sinners. Mother, the reason that I have not written to you since my trial is that I could not satisfy you as regards my spiritual welfare. I now trust that I am able to give you satisfaction, and although I am about to die an untimely death, perhaps it is a mercy that I am thus called, or it might have been the will of God to remove me from this world when unprepared. I am therefore resigned to my situation. Since I commenced this letter, I have been baptized by Bishop Doane, a Protestant Episcopal clergyman, in the true belief of the Lord Jesus Christ, and I hope to meet you perhaps soon in the regions of bliss, and also my beloved sister, who, no doubt, died in the same faith. There is no other hope for any of us. What is this world compared with eternal happiness? It is a world of trouble, and we all must sooner or later part with it, as well as all the objects of our affection. Although death may seem awful. It may be compared to a quiet sleep. And oh, if we are prepared, why should we fear to die? I therefore give myself to God, trusting in His Son. I also leave you in His hands, hoping that you will still be faithful, that we may meet where parting will be no sorrow. Mother, I bid you a long farewell for this world, and do bear up with fortitude under this trouble, that it may not shorten your few remaining days. Your son, Joel Clough. Mrs. Joanna Clough, North Murray, Orleans County, New York. Letter to a friend asking aid. Monday, April 18, 1833. Mr. James Wallace. Dear friend, the time has now arrived which obliges me to call upon you for assistance, not in a pecuniary point of view, but, dear sir, as a witness for me. If I can prove by you that my mind was in a kind of deranged state at the time I was with you in New York, it may be the means, with the assistance of other testimony, that I shall be able to procure of liberating me from an awful death, which will not only be the means of bringing upon myself an eternal stain, but a stain upon all of my connections, who are many, that I shall leave behind. You, of course, have heard that I am now imprisoned in this place on a charge of murder, inflicted upon Mrs. Mary W. Hamilton, whom you have once seen. The circumstances are of a peculiar nature. It was not a premeditated act. If so, nor no malice aforethought, and from the peculiar state of the case, you will be the most important witness I can have. And in the result of my trial, I think the die will be cast, with a few other witnesses, upon your testimony. Notwithstanding the multiplicity of your business, which I know must be very disadvantageous for you to leave, I do not see how it is possible to excuse you. You will also bear in mind that little foolish misfortune I met with in New York, and you know I told you the cause of it. With deep regret, I yield an acknowledgment to you that I done wrong in not taking your advice by leaving Bordentown and coming immediately to you and entering into business. But you must know the reason. Alas, she is no more, and I feel myself innocent. I also feel that it is not only a duty to myself to use the best exertion to get clear, but also a duty I owe my friends and relations. My friends have volunteered their services to assist me, to wit, Mr. George Law and Mr. Charles I. Eyre, besides friends from Philadelphia, and the most able counsel that can be procured are already engaged for me. I wish when you come, you would call on Mr. Barrett in New York, and have him assure you that nothing will be said concerning that late affair. Letters from Clough's brothers, Monday, April 18, 1833. Dear brother, with a heart full of grief I write to you. The news I heard makes me shudder. I hardly know what to say to you on this painful scene. I understand that you have murdered, which, if true, will cost you your life. I have just received a letter from you, and have now seen the newspapers confirming it. Joel, what have you done? May God have mercy on you. It is an awful thing. May the Lord have mercy on you. I expect there is no hope of your life, but can look to none but God. I hope that you pray to God to forgive you. I hope that you will have time to repent of the awful crime. It seems that you did not think anything about your friend's feelings, and especially your mother. Mother is in Rochester. How she will feel, you must judge. I expect she will live with me. Our prayer is that God will have mercy on your soul. After I began this, I received your letter and saw the newsprint. I think you had better write to your mother. Perhaps it will be a consolation to her. I bid you farewell forever, dear brother. Farewell. I remain your friend and brother, Wesley Clough. Joel Clough, Monday, 18th April, 1833. Joel, I cannot help you, but you must look to God, who is able to save the worst of sinners. Must I bid you farewell forever? I must. O Lord, have mercy on you. Once respected and very dear brother, Agreeable to your request, I write you. This day we received your letter and likewise the account of the crime you are imprisoned for. Your friends and acquaintances are struck with horror. For myself, I know not what to write to you. You wrote that you must have been influenced by greater power than mortal power. Neither of these form any excuse in our minds. It appears that, through the mercy of God, you have a short space for repentance, and I beseech you by all the ties of nature and friendship that ever existed between us, to improve the time. Jesus came into the world to save sinners. My prayer is that God will have mercy on your soul. H.W. Bates, Joel Clough. End of section 74.
Section 75 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Christian Smith for the murder of Bornt Lake, New York, 1817. The narrative. This is the common story of a neighbor's quarrel over land and property, which results in a lawsuit, mutual recrimination, hate, and revenge. There is finally an accidental meeting of the parties, and one of them kills the other. The scene is laid in a typical American county, and the trial, which takes place in a typical country village, collects the people from every part of the vicinity. The little courthouse is too small, and the court adjourns to the church, which will hold more people, but which is crowded to the doors. The killing is admitted, but fortunately the prisoner has a better reputation among his neighbors, who are trying him, than has his victim. The solemnity of the place, the awful occasion on which the auditory had assembled, the situation of the prisoner and his weeping relatives, who are all present, combine to excite a peculiar sympathy in his favor, which is heightened by the eloquent appeal to the jury made by his counsel. The jury, after 7 hours' deliberation, returned a verdict of not guilty, and the prisoner went free, but not before receiving from the judge a caution which he probably never forgot for a single instant as long as he lived. The trial. In the Court of Oyez and Terminer, Richmond, New York, May 1817. Honorable William W. Van Ness, Judge. May 31st. The prisoner was indicted for the murder of Bornt Lake on Sunday, October 27, 1816, by firing and discharging at the said lake a certain musket, loaded with shot, by means of which he, the said Bornt Lake, instantly died. Thomas Lester for the people, Mr. Price, Mr. Phoenix, and Mr. Wallace for the prisoner. Mr. Lester stated that he expected to prove in the course of the trial that the deceased and the prisoner, being neighbors, certain unhappy differences subsisted between them for 16 years, and that previous to the day laid in the indictment, the prisoner had expressed his hostility towards the deceased and threatened revenge. On the morning of the 27th of October last, the deceased was found dead in the public highway, near the land of the prisoner. A rammer and clasp belonging to a musket were found near him, and his back was pierced by a great number of wounds proceeding from gunshot. On searching the house of the prisoner, 2 muskets were found, one of which was found concealed in the rafters of the garret, without a rammer and clasp, and those found exactly fitted the musket. Mr. Lester concluded by saying that he expected to prove this to be a case of the most diabolical malice which had ever disgraced the records of our criminal courts. Witnesses for the people. Daniel Lake. Before the deceased was killed, and during the same month, I had a conversation with the prisoner on the subject of certain lawsuits and other differences between deceased and the prisoner, and offered myself as a mediator. He replied that this would be of no use, as an unsuccessful attempt of that nature had once before been made, that Lake still continued to trespass upon him, and that he, the prisoner, could not bear with the night walking of the deceased, and intended to fix him. The deceased and the prisoner had been at variance a number of years, and the dispute extended to their respective families. Cross-examined. The prisoner complained of diverse trespasses committed by the deceased to vex and injure, and among other things, that he had frequently let the swine of the prisoner out of his pen at night and taken them up under the town law and had recovered the penalty on the ground that the prisoner suffered the swine to run at large. William Lake, Jr. am a brother of the deceased. On the morning of the 27th of October last, I was at the house of James Burbank, which is about 170 yards southwest from the house of the prisoner, who lives a little off the road. At about 5 o'clock in the morning, I heard the report of a musket. I saw the deceased at about 9 in the morning, dead, about 25 or 30 yards from the prisoner's gate, in the highway, near the wagon track, lying on his back. The prisoner lived between the house of Burbank and of the deceased, and near the place where deceased was found. There is a barrack, and on the opposite side of the road, on the southeast side thereof, there is a thick wood. I found a rammer and band of a musket near the head of the deceased. Cross-examined. When I heard the report, I was sitting at the fire with Mrs. Burbank, and on going out I heard a voice which resembled that of a child in distress. By reason of the bushes and the unevenness of the ground between where I stood and the deceased was found, I do not think I could have seen either the prisoner or the deceased. Richard S. Carey, am coroner of Richmond County. I held an inquest over the body, which I found in the middle of the road, lying on his back, covered with a sheet. I found between 25 and 30 wounds, made with 3 kinds of shot, goose, duck, and pigeon, the largest of which were molded. A number of these shot were afterwards extracted. On going to the house of prisoner, I found he was absent, but his wife at home, and on searching the house 2 guns were found, one of which was without a band or rammer, and appeared to have been recently discharged. This gun was found in the garret, concealed in the rafters, and the band and rammer found near the deceased belonged to the gun so found in the garret. The band was at the end of the gun, and in drawing it off it must have drawn the rammer also. The witness hereupon produced a number of shot taken from the body of the deceased, and a shot bag containing shot found at the house of the prisoner, and the quality corresponded precisely. The witness also found a wadding of oakum, strongly colored with powder, in the clothes of the deceased, on his back, and some wadding of the same kind in the prisoner's house. It further appeared that the shot was considerably scattered, and the principal part of the charge entered the left part of the backbone, nearly under the shoulder blade. The gun must have been discharged at the distance of 10 yards from the deceased. Some of the shot were found in the neck of the deceased, and some as low as his waist, and several had penetrated nearly through his body. Mr. Beadle, I was at the place where the deceased was found early in the morning. There were no marks or indications on the ground near the body of the deceased of any struggle or scuffle between the deceased and any other person. William Lake, am father of the deceased. The evening previous to his death, the deceased, being at my house, was directed by me to be back next morning by daybreak, which he promised. I live about half a mile from my son's house, and the place where he was found was in the direct and usual route to his house. Deceased, when he went from my house the preceding evening, had a bucket and a bag of meal. About daylight, while I was in bed, I heard a loud report of a gun, from the sound of which I believed it must have been pointed in the direction of my house. Receiving information of my son's death, I went to the place and found the corpse in the situation described, surrounded by his wife and 6 children. I am an experienced gunner, and believe from the scattered wounds on the body that the gun must have been discharged at a distance of 15 or 20 yards. I suppose the deceased must have been shot from the barrack off the road. Footnote. As to the relative situation of the places mentioned in this testimony, the main road, spoken of by the witnesses, runs about north and south at this place, it being about a mile from the water on the south side of the island. The 3 houses of the deceased, the prisoner, and Burbank's are on the western side of the road and a short distance out of the road. The house of the deceased is north from that of the prisoner, and Burbank's south. Opposite the house of the deceased, on the opposite side of the road, there is a road leading in an easterly direction to the house of the father of the deceased, who lives near the water, and another leading to the same house, which turns off from the main road, nearly opposite the prisoner's house. To go to the black walnut spoken of by the witnesses, in proceeding south, you have to pass this last mentioned road, leading to the father's, a considerable distance. The barrack, near which the deceased was found, stands between the two roads leading to the father's house, but on the opposite side of the main road, and the road from the house of the deceased to that of his father is about 1/4 of a mile nearer than to follow down the main road south and take that opposite the house of the prisoner. End footnote. Van Ness, J. In what part of the body would the shot have struck the deceased, on the supposition that the gun was fired at him while he was proceeding along the road towards the house of the witness? The charge would have entered his side. There had been frequent quarrels between prisoner and deceased concerning cattle and fowls. A black walnut tree is on the land of the prisoner, on or near the line between him and Burbank. John V. Van Pelt. Am a justice of the peace. There had been lawsuits between deceased and prisoner. On the 15th of October, there was an action of trespass between them, wherein Lake was the plaintiff. The deceased was a suitor, plaintiff, more frequent than the prisoner. The character of the prisoner is good, and he is rather peaceable and quiet than quarrelsome. Richard S. Carey. The prisoner, on being requested by Mr. Orton to come where the inquest was held, came voluntarily, but declined answering any questions on the subject, alleging as a reason that he was informed that he was suspected of having killed the deceased. Reverend Peter J. Van Pelt was called as a witness by the prosecution to prove certain confessions made by the prisoner to him while confined in the prison in this village. Mr. Price, were the confessions spoken of made by the prisoner to you while you were visiting him as a minister of the gospel? I heard nothing from the prisoner but what I believe to have been communicated to me as a minister of the gospel. Mr. Price, I object to the testimony of the witness. While I am not aware of any express decision in support of the objection, I think it is dangerous in the extreme to permit a witness, in the relation of the one offered, to divulge a communication which must undoubtedly have been made and ought to have been received in the strictest confidence. It has been decided by DeWitt Clinton, while mayor of the city of New York, that auricular confessions made in the confidence of the church discipline were inadmissible evidence against a prisoner. Footnote. On an objection raised by the prisoner's counsel to this evidence, it was decided by His Honor DeWitt Clinton, then mayor of New York, that although confessions made to a Roman Catholic priest were received in England, and no privilege could be claimed by a priest of that order in the English courts, yet His Honor considered that in this country we were at liberty to establish a different rule. His Honor decided in favor of the privilege claimed, and that the testimony of Mr. Coleman could not be required. The case to which the counsel alluded was of this nature. A man belonging to the Roman Catholic denomination was brought to trial in the Court of Sessions in New York for grand larceny. On the trial, Mr. Coleman, a priest of that denomination, who, it appears, had previously restored to the owner the property laid in the indictment, having derived the information which led to a discovery of the goods by means of a confession made to him by one of the members of his church, was called as a witness on behalf of the prosecution to prove that the prisoner had confessed to him the felony. By the established canons or ordinances of that church, confessions are to be made by the members at least once a year, to the priest, in private, and from the examination of Mr. Coleman, it appeared that no other confessions were made to him by the prisoner in relation to this affair, except those made in the ordinary course of church discipline. According to the rules and ordinances of the church, the priest is forbidden to divulge these confessions, and the witness declared that no consideration whatsoever, not even the most severe punishment, would induce him to depart from the established ordinances of the church. End footnote. I see no distinction between that and the present case. There was no good reason for restricting such a rule to any particular sect or denomination. It had no relation to the character of the person in whom confidence is placed, and whether made to a minister of the gospel or a counselor at law is perfectly immaterial. It arises altogether from the presumption that a prisoner, for his temporal or eternal safety, considers himself compelled to make the confession. In this view, it is not to be regarded as voluntary, and therefore is inadmissible. Van Ness J. Have you, Mr. Van Pelt, any objection to state the communication made by the prisoner? I have not. Van Jess J. I think the testimony is admissible. I think there is a grave distinction between auricular confessions made to a priest in the course of discipline, according to the canons of the Church, and those made to a minister of the gospel in confidence, merely as a friend or adviser. Reverend Peter J. Van Pelt. Shortly after the prisoner had been committed to prison, he sent for me and professed to relate to me all the circumstances of his case. I visited him and had several conversations with him, with a view of exhorting him to penitence and preparation for his great trial hereafter. The account which the prisoner gave of the unhappy transaction is, in substance, as follows. The deceased and himself had frequently disputed and quarreled, and the mind of the prisoner, by reason thereof, became harassed and disturbed. On the night preceding the affair, the prisoner was restless and remained awake much during the night. About daylight, hearing a noise like the shaking of a tree on his land, he went to the door and heard the noise more distinct. He went out and ascertained with certainty that there was somebody at the black walnut tree. This induced him to take his gun and go to the tree. When he came up, it being still dusky, he saw a man under the tree on his knee, picking up black walnuts in a basket. Approaching, the prisoner accosted the other by saying, "I have caught you at last." By this time he found that the man was the deceased, who made no answer, but crept or crawled away with his basket containing the nuts through the fence between the land of the prisoner and that of Burbank. The deceased went along on one side of the fence, and the prisoner on the other into the main road. The prisoner, following the deceased, saying, "Deliver up the nuts, and give up yourself like a man." The deceased made off very fast towards his own house, and the prisoner followed him, demanding his nuts, which the other refused to deliver. The prisoner thereupon made towards the deceased, resolutely to get his nuts, but not to do any mischief to the deceased. Whereupon deceased seized the muzzle of the gun, when, fearing that he would wrest it away, the prisoner cried out for help to his family, repeating this, "Will none of you, or is there nobody to help me?" In the struggle, by a sudden and strong jerk, the deceased drew the band and rammer from the musket, by reason of which the deceased and the prisoner were separated. The deceased was going off hastily with the band and rammer. The prisoner followed, and being angry and bewildered, he discharged the gun, but whether he took aim at the deceased or not, the prisoner did not know. I asked the prisoner whether he saw the deceased fall. He answered no, but that he heard deceased, as he fell, cry out, "Lord, have mercy on me." The prisoner told me that when the gun was fired, he was but a short distance from deceased, and did not distinctly see him. That deceased was a stronger man. I am also of that opinion. The prisoner did not state to me that at the time the scuffle ensued, the deceased threatened the prisoner with any bodily injury. In assigning the reason why the deceased came on his premises, prisoner said he supposed the deceased intended to steal and carry away his property. The prisoner showed much contrition at having killed the deceased. The witnesses for the defense. John V. D. Jacobson. I was well acquainted with the ground on which the body of the deceased was found, it being about 100 yards from the black walnut tree before mentioned, and about the same distance from the house of Burbank. I had known both prisoner and deceased for many years. Violent quarrels subsisted between them, and frequent lawsuits were instituted. Prisoner seemed to be disposed to live in peace, but deceased refused to conciliate or listen to terms of reconciliation, declaring that he would give the prisoner law or words to that effect. During his life the deceased was a bad man, and his wife a turbulent woman, with whom he could not live in peace. Prisoner has 6 daughters and 3 sons, some of which are small, and the whole depend on him for support. He is a peaceable man, and never had any quarrels except with the deceased and Burbank, his other neighbor, and before this transaction I had never heard the moral character of the prisoner impeached. Have heard it said that deceased was an ill-natured, quarrelsome man of a bad temper. The father of the deceased owns property opposite to that of the prisoner and the deceased. The morning when the deceased was killed, it was calm and clear, and I believe that a person standing on the spot where the body was found and hallooing very loud might be heard at the house of Burbank, but not in one of his rooms. Cross-examined. The road generally used in traveling from the house of the deceased to that of his father runs between the dwellings of prisoner and deceased, and the place where the body was found is not the direct way from the house of the deceased to that of his father, but is southwesterly. Deceased might, in going to his father's house, have taken the road in which his body was found, but it would not have been in the direct way, and would have been, and is, considerably further. I first heard of the death of deceased from the prisoner, who came and told me. Abraham Orton. When the coroner's inquest was held, I requested the prisoner to attend, and he came and stayed, voluntarily, until the warrant for his arrest was issued. Mr. Wallace stated that the prisoner, in addition to the evidence already disclosed, would produce testimony to corroborate the relation made by the prisoner to the Reverend Mr. Van Pelt. A number of respectable witnesses would prove the disposition of the prisoner to be mild and peaceable, and finally it would be contended in his behalf, from authority, that under all the circumstances of the case he ought to be acquitted by the jury. Patience Smith. Am a daughter of the prisoner, and am 17 years old. Early in the morning in which the deceased was killed, and when it was quite light, father asked mother for his greatcoat, which he got, and said he was going out to see who was threshing off his black walnuts. I followed him for a short distance, and then returned to the house. Shortly after, I heard him call for help, 6 or 7 times or more, and also heard a sound like the violent trampling of feet and the jingling of a chain, and soon after the report of a gun. Heard father, during the affray, demand his property of the man who was near him, whom he frequently called by his surname, but who refused to give it up. I think that at the time the prisoner was at the walnut tree, I must have been at the house, and was there when I first heard him cry for help. Deceased was a little west of my father's house, and came out into the road near the walnut tree. During the most of the time that I was present, I saw the deceased pulling and dragging my father along with him, who resisted, and the course which they took brought them nearly opposite to and westward from father's house. I was in the road when I heard the gun discharged. I did not know father took the gun when he left the house. Cornelius Perrine, George W. Barnes, Reuben Clayson, Dennis Denise, Peter Jacobson, John B. Coles, and Isaac Coverley, on being sworn as witnesses on behalf of the prisoner, concurred in showing the general good character of the prisoner, and that he was a peaceable, good-natured man. Mr. Phoenix commenced the summing up for the prisoner, and Mr. Price closed. They contended that if he suspected that the deceased was committing a felony, though, in fact, no felony had been committed, but a trespass only, and if upon his attempt to arrest the deceased he resisted and fled, whereby the prisoner could not secure him without shooting at him, he had a right to do so, and if he was killed in his flight, the prisoner was justified in law. It was almost impossible that the prisoner could make the legal distinction between trespass and felony, with which scarcely any person but a lawyer, read on that subject, could be acquainted. With regard to the principal intention and motives of the deceased, they were precisely the same as that of a felon, and if the jury should draw the conclusion that the prisoner suspected and believed that the deceased had committed a felony in taking the nuts, it was their duty to acquit him. There could be no doubt that the prisoner entertained that belief, that the conduct of the deceased was like that of a thief. He broke into the prisoner's enclosure in the dark, before daylight, was detected in the act of taking the prisoner's property, and when he found himself discovered, crept between the panels of the fence, bearing off his booty, notwithstanding he was frequently requested by the prisoner to give it up and surrender himself a prisoner. That the gun was taken by the prisoner to be used in defense of himself and property, as necessity should require, was manifest. For, had the prisoner taken the gun with an intention of killing the deceased, he would have discharged its contents when he first came up to him, inasmuch as the opportunity afforded certain success, while the deceased was in the act of stooping down and picking up the nuts. But it was not until after a struggle had taken place, and the prisoner was nearly overpowered and crying for help, nor until after the deceased had attempted to fly, and while in the very act of flight, at a distance of 20 or 30 yards, the prisoner fired a random shot which unfortunately deprived his neighbor of life. Mr. Lester for the prosecution contended, and the court charged the jury, that the evidence would warrant a finding of guilty, but upon that subject they were the judges of the law and fact. But the court could not forego advising them that the evidence afforded the prisoner no chance of escape. His conduct before and after the commission of the crime had been brutal and barbarous in the extreme, and he was not a safe member of society. The jury returned after 7 hours with a verdict of not guilty. Judge Van Ness: Christian Smith, you have been tried and acquitted by a jury of your country for having taken away the life of one of your fellow creatures. I mean not to censure the jury who acquitted you. It is not my province so to do. I hope they will be able, upon future consideration, to reconcile their verdict to their consciences. But I should feel myself wanting in my duty as a man if I did not express my opinion that, notwithstanding their verdict, I consider you a very guilty man. Upon an ancient grudge, you considered yourself justified in doing what you have done, and the jury have, I fear, confirmed your false and fatal judgment. But beware, you have not yet escaped. Believe me, your most awful trial is yet to come. You are now an old man, and your days must be few in this world, and you will shortly be compelled to appear before another court, where there is no jury but God Himself. Unless you repent and devote your future life to an humble atonement of your guilt, your condemnation there is certain. I am thus plain with you, in order that those who have listened to your trial may learn that whatever may be considered to be the law of Staten Island, your conduct is unjustifiable in the sight of God and man. End of section 75. Read by Martha Weller, Champaign, Illinois, July 7th, 2023.
Section 76 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Action of John M. Trumbull against Thomas Gibbons for libel. New York City, 1818, Part 1. The narrative. A husband has a quarrel with his wife. They separate. The son-in-law, who takes the part of the wife, makes himself particularly obnoxious to the husband, who, in revenge, and to force the wife to return, prints a pamphlet containing gross libels on the son-in-law, which he sends to the wife, telling her that he will distribute them to the world if she does not return. The outcome is a suit for damages. The parties are in high life in the East and South, and both bear historical names. The counsel are all eminent in their profession, and the jury return a verdict against the defendant and assess the damages at $15,000. The trial. Footnote. New York City Hall Recorder. See ante, page 61. End of footnote. In the Supreme Court of New York, June 1818. Honorable Ambrose Spencer, Judge. Footnote. Ambrose Spencer, 1765 to 1848, born Salisbury, Connecticut, graduated Harvard, 1783, member New York Assembly, 1793, State Senate, 1795 to 1802, Attorney General, 1802 to 1804, Justice Supreme Court, 1804 to 1819, Chief Justice, 1819 to 1823, Mayor of Albany, 1824 to 1826, Member of Congress, 1829 to 1831. And a footnote. This was an action for damages for a libel, the damages being laid out at $100,000. The declaration alleged that the defendant, Thomas Gibbons, did on September 19, 1816, in the city of New York, maliciously compose, print, and publish a libel against the plaintiff. It appeared that Gibbons and his wife had been separated for some time, and that the plaintiff, Trumbull, was the son-in-law, having married Gibbons' daughter against his wishes. As a consequence of much bad feeling, Gibbons wrote a long letter to his wife, charging Trumbull with various crimes in which he printed in pamphlet form and circulated. In this, he charged the plaintiff with being a swindler, borrowing money and not paying it back, that he had ingratiated himself into his favor through his daughter whom he had seduced in her own home. June 24th. The trial began today and extended over 2 days. D.V. Ogden, Hoffman and Wells for plaintiff. Footnote, John Wells, 1770 to 1823, born Brooklyn, New York, graduated Princeton, member of New York Bar from 1791 to his death. End of footnote. Emmett and Griffin for defendant. Footnote, Ebenezer Griffin, 1789 to 1856, born New York City, graduated Union College, admitted to the bar 1811, practiced in New York City in 1842, when he removed to Rochester, one of the best-known advocates of his day. End of footnote. Mr. Ogden. The case is without precedent in the annals of our jurisprudence. The action was brought for a libel contained in a printed pamphlet, the most scandalous, indecent, and impious that could be framed. It was published by the defendant against his son-in-law and his own daughter, who had since descended to the grave. And if every word in the publication were true, the defendant was a monster, nay, worse than a savage. He deserved the execration of every person in a civilized society, not lost to every feeling of humanity, but giving publicity to such a daring and atrocious libel. For, had the daughter, previous to her marriage, been guilty of indiscretions and failings, the father ought to have been the last person to have proclaimed them to the world. But it will appear that so far from the publication being true, the defendant has confessed every word and sentence to be utterly false. Without attempting, at this stage of the case, to enlist the feelings of the jury by entering into a detail of the abominable conduct of this defendant, we shall proceed to the evidence. Mr. Ogden produced a printed pamphlet with a paper containing writing attached thereto, directed to Mrs. Gibbons, and in different places on the margin of the sheets, writing was introduced, intended either as additions to or explanations of the printed matter in the body of the work. Witnesses for plaintiff. Elias P. Dayton. The writing produced is that of defendant in the year 1816, and since that time, plaintiff and defendant were near neighbors to each other at Elizabethtown in New Jersey. Mr. Ogden read the whole publication, which occupied more than an hour. He omitted, however, in the reading, some things which were stated in relation to third persons. The defense. Mr. Emmett. There are 3 grounds of variance between the declaration and the publication read in evidence. 1. In the declaration, the publication is described as a printed pamphlet, but appears to be partly written and partly printed. 2. In the body of the publication there is a mark of reference, beneath which, on the same page, there is a note. In the record, the matter contained in the note is introduced as a continuation of the matter in the body of the work at the point of reference. 3. Plaintiff, in framing his declaration, has selected certain portions of the pamphlet, omitting a part, and without any introduction at the several points of omission. He has inserted the whole as one continued quotation, whereas he should have inserted at the commencement of the matter immediately following the part omitted, words to show that such omission had been made. Spencer J. With regard to the first objection, it relates merely to the description of the libel, and that whether written or printed is, in the opinion of the court, immaterial. The second and third objections resolve themselves into one, and the substance of the objection to the declaration seems to be that the juxtaposition of the matter was improper. Now, plaintiff had undoubtedly a right, as in this instance, to select such parts of the libelous matter as he judged proper, and omit the rest, and though after the several breaks or omissions, it was usual to preface the succeeding matter in the declaration with words importing that an omission had occurred. I do not conceive this to be necessary. The several objections taken are not tenable. Mr. Emmett. We bow with respectful deference to the opinion of the court, but beg leave to tender a bill of exceptions to the opinion. Mr. Griffin. This is one of the cases in which the truth of that remark, that unbounded wealth does not produce happiness, is abundantly verified. The parties in this case, previous to the time of the commencement of this controversy, lived at Elizabethtown in New Jersey. Mrs. Gibbons, the wife of the defendant, was in Georgia, and though there had been some kind of arrangement concluded that the plaintiff should go and accompany his mother-in-law on a visit to Elizabethtown in the summer of 1816, yet, by reason of some difference between the plaintiff and defendant, he was expressly enjoined and prohibited by his father-in-law to go to Georgia for that purpose. Notwithstanding this, preparations were secretly made by the plaintiff, and he departed without the knowledge of defendant, and brought on the wife to Elizabethtown. Here is the prime cause of all this difficulty. Though the wife of defendant, on her arrival, went to his house, yet in a short time she left it, and went to reside at the house of her son-in-law. She separated herself from her husband, and through the countenance and support of the son-in-law, measures were devised between them for a divorce from her husband, and the son-in-law accompanied her to a professional man in that state for advice and direction on the subject. Defendant took a part of his family in his carriage and went on to Saratoga Springs, where a portion of this publication was composed. From thence he went to Boston, where it was finished, and a confidential printer was engaged under an injunction of secrecy to print 50, and to return the proof sheet and the manuscript carefully to the defendant. This was done, and on his return to New York, he enclosed 5 to his wife in an envelope, endorsing 4 of them to her most confidential friends. It was intended, however, by him as a confidential communication to his wife, and the object of printing it was to terrify her into a compliance, and to bring her back to her family. It produced the effect, but she having delivered 2 or 3 copies to the plaintiff, he delivered them to those persons to whom they were directed. He was, therefore, the publisher, and the only publisher of that libel on which the opposite counsel had been so lavish of opprobrious epithets, and for which they modestly required at the hands of the jury enormous damages. The libel, it is true, was highly improper, nor would he attempt its justification, but would contend that under the circumstances of this case, which would be more fully disclosed in testimony, plaintiff alone ought to be considered responsible for this publication. It will further be shown that after these pamphlets had been distributed by plaintiff, an amicable adjustment of differences between the parties, a family compact, was entered into through the mediation of William Gibbons, plaintiff's brother-in-law, and the prominent terms of the compact were that those pamphlets should be taken up by plaintiff, and that his children, in the will of the defendant, should stand on the same footing with the rest of the family, and all past differences between the parties were to be buried in oblivion. Notwithstanding this solemn arrangement, entered into by the defendant with good faith, an agreement which ought to have been held sacred, because family discord, whatever may be its origin, ought never to be made public unless required by the most imperious circumstances. Defendant, on coming to this city, was arrested at the suit of plaintiff and held to bail in $100,000. William Gibbons. In August 1816, I went in a carriage with my father, the defendant, and one of his other sons with his lady, from Elizabethtown to Saratoga Springs, leaving my mother at the former place in the house of plaintiff. Her staying there was contrary to the wishes of father, and plaintiff, previous to the tour to Saratoga, had accompanied mother to Mr. Stockton, a lawyer at Princeton, for professional advice relative to a divorce which was contemplated between father and mother. Whether plaintiff advised mother thus to proceed, I do not know. About 1/3 of the pamphlet was written at the Springs, and from thence defendant, with his company, went to Boston, where the remainder of the publication was written, and I was sent by father to a printer, who engaged with him to print 50, and joined him not to make it public, and required him to return the manuscript and proof sheet. This the printer did, and delivered 50 copies to me, and the manuscript and proof sheet. Shortly after this, the company left Boston for this city, where they arrived on the 17th of September, and I was called on by father for 5 of the pamphlets. Father wrote Mrs. Gibbons. On 1. On the 2nd, Colonel Aaron Ogden. On the 3rd, Mr. Stockton, the wife's counsel. On the 4th, John Haywood, and on the 5th, Mrs. Glover. The whole were then enclosed in an envelope and directed to Mrs. Gibbons, and I lodged them in father's trunk, retaining 45 of the pamphlets myself, none of which have been since exhibited to any other person, except 2, for the use of the counsel on the trial. Arrived at Elizabethtown on 21st September, and shortly afterwards a compromise was effected between father and mother, through my intervention, and she returned home. At this time, plaintiff was absent at Princeton to consult Stockton relative to the business of separation, and on his return, I was sent to request Trumbull to come and see mother. When he came, she stated to him that she had come to a compromise, in which all the members of her family were included, and that the principal reason of her acceding to the terms of compromise was for the sake of plaintiff's family. The foundation and terms of the compromise were stated by her to be that Trumbull should take up the pamphlet she had delivered to him from Messrs. Stockton and Ogden, and on the side of defendant, he was to place Trumbull's children on the same footing with the other members of the family in relation to the final disposition of the property, and all differences were to be buried in oblivion. Plaintiff acceded to this, and promised to take up the pamphlets as mother requested. She told Trumbull that what she had done was perfectly voluntary and for the sake of her family. On October 6th, she departed from Elizabethtown for Savannah, in company with me, in pursuance of a previous arrangement, and the second day afterwards, I received a letter from plaintiff stating that he had received 3 of the pamphlets, 2 of which he delivered according to their direction, and apologizes for not taking them up. This letter bore date on 26 September. The reason why father did not accompany mother to Georgia, I believe, was that he was indicted by Mr. Ogden in New Jersey, and was also bound in a recognizance to the amount of $5,000 in another proceeding in that state, in which Trumbull was a party. My father was arrested in this city October 1st, previous to which no conference had taken place between plaintiff and defendant, but mother, after the arrest, had an interview with Trumbull, wherein she spoke in pointed terms of reprehension of that proceeding, told him he had made a very improper use of the pamphlets, and conjured him to discontinue the suit, which he refused to do, saying that he had a right to make use of the pamphlets to vindicate his own character. In consequence of an arrangement made by mother at Elizabethtown, I had an interview with plaintiff at the office of Mr. Ogden, one of his counsel, in New York, for the purpose of effecting a compromise. There I asked plaintiff whether a full recantation of all the charges in the publication would be satisfactory, to which he answered that something more was necessary, but did not say what. I stayed a few moments only at the office and then departed. At this time, and at several other interviews which were had with plaintiff the following year for the purpose of effecting a settlement, I was clothed with full discretionary powers, subject, nevertheless, to the ratification of father. After my return from Savannah, I again called on Trumbull to make a settlement, but he refused. In the spring of 1816, I was in Georgia, at which time Trumbull came there for the purpose of bringing on his mother-in-law to the north, who had received an invitation the preceding winter to come on. At the time Trumbull arrived, I did not know of the difference which existed between father and Trumbull, but he stated there was a difference, and in a few days afterwards I received a line from father advising me against Trumbull's bringing on mother. She came on with him, however, sometime in May, and afterwards, on my arrival at Elizabethtown, I found that a separation had taken place between my parents, mother then being at the house of plaintiff, who accompanied her often to Stockton for advice concerning a divorce. Cross-examined by Mr. Ogden. When Trumbull came to Georgia to bring on mother, and after he had stated the difference between father and himself, she called on me for advice, and I advised her to go on with Trumbull and make up the difference. At the time of the compromise, before the commencement of the suit, it was understood that mother was to return to Georgia, and all past differences were to be buried in oblivion. But father had required, as a condition of his forgiving plaintiff for producing the separation, that he should take up the pamphlets. Samuel Dawes. In the spring of 1816, being in the employ of plaintiff, and living a short distance from him, he sent me for a wagon to carry himself and his baggage to the place where he was to embark for Georgia, and on the way Mrs. Trumbull requested me to conceal the trunk by covering it, and the husband directed me not to disclose to any person that he, plaintiff, was gone. Previous to this, he had told me that he was to go to Georgia by the advice of defendant. Witnesses for plaintiff. Reverend John McDowell testified to his general good character from an acquaintance of 3 years. Cross-examined by Mr. Griffin. Plaintiff handed one of these pamphlets, which had been sent to Mrs. Gibbons, to me. I lent it to a Mr. Wilson, and afterwards suffered Shepherd Collins to peruse it, but did not leave it in his possession. At the request of Mrs. Gibbons, I enclosed it and put it into the post office, directed to William Gibbons, New York, on or about September 21st, 1816. There was an interview between the plaintiff and defendant at my house, at the instance of the old lady, but without effect. Isabella Post. In 1816, the wife of defendant being at the house of Trumbull, defendant asked me why I did not go there and assist his wife in attending Trumbull's children, who were then sick. David Trumbull, and plaintiff's father. At different times, on the request of my son, I have had conversations with defendant on the subject of the differences. Mr. Ogden. Did defendant state to you in any of these conferences that he did not believe the things contained in that pamphlet to be true? He said that he wrote and published the pamphlet with the view of driving his wife out of the country, as she had been brought there without his consent by plaintiff. Defendant further said that he could not substantiate the facts, and expressed a willingness to make an apology, and even went so far as to offer to sign any acknowledgment, which my son's lawyer would write, but was not willing to touch the purse. These conversations took place between the 20th of October and the 1st of November, 1816. There were about a dozen interviews between defendant and myself, in none of which did he mention anything about money to be advanced to my son as the basis of settlement. But I did suggest to defendant that he ought to provide for his children, to which he replied, in effect, that it was the privileges of every man on his deathbed to make such a will as he pleased, and he further said that he had already given plaintiff $50,000. In some or one of these interviews, defendant said that if his son-in-law would make an acknowledgment that he had brought on his mother-in-law from Georgia without defendant's consent, and also withdraw the suit against him, he was willing to place his children on an equal footing with the other members of the family. There were 5 specific subjects of complaint made by defendant for which he required an acknowledgment from Trumbull. 1. For his going to Savannah and bringing on the wife contrary to his express prohibition. 2. When she arrived, carrying her to see Colonel Ogden. 3. Going to Stockton to procure a separation. 4. Detaining her under his roof. 5. Retaining the pamphlet and not delivering it up. At the first interview I had with the defendant on this subject, and also in other conversations, he asked me whether I knew the oath he had taken, to which I answered no. He said he had sworn on the Holy Evangelist to an oath, which he exhibited in writing, and read that if this controversy was not settled by Trumbull, he would take his life, and also that of Colonel Ogden and the Reverend Mr. McDowell. And he also declared that if I went on my contemplated journey to Connecticut before the affair was settled, the first news I would hear would be that of my son's death. Knowing the defendant's disposition, I was not under the least apprehension that these threats would be carried into effect, though I believe from the circumstance of the writing that the oath was taken. Defendant further said that it was useless for plaintiff to contend with him, for that money had carried him through thus far, and it would do so hereafter. He further said that it was a matter of indifference to him whether he died on a gibbet or on a bed of roses. William Gibbons. Out of the 5 pamphlets sent to Mother, 3 of them were taken up or returned, so that at present there are only 2 out, the one to John Haywood and the other to Aaron Ogden. At the time the pamphlets were about being printed, I compared the manuscript with the printed copy, and otherwise assisted as father's agent. Mr. Ogden handed the witness a letter dated March 5, 1810, and asked if that was his father's handwriting. Being answered in the affirmative, counsel read it to the jury. The letter was written from Savannah to John Haywood, stating that John M. Trumbull of Connecticut, belonging to that ancient family celebrated in the American history, and concerning which so much had been said in the newspapers, had made suit to Anne, that all the parties were satisfied, and that their marriage was to take place in his house at a particular time stated in the letter. The correspondent, by the terms of the letter, was invited to attend the wedding. William Gibbons. In the fall of 1816, at the request of father, I was present at an interview wherein defendant reminded plaintiff that when he was about being married, defendant called him up and told him that as he married without his consent, he, the defendant, would not give him a single cent. The plaintiff at that time did not deny this, but nodded assent. Defendant has given the children of Trumbull property valued at about $45,000 and $50,000, for a part of which I am, with others, a trustee named in the deed for property at Elizabethtown, given by defendant for the benefit of Trumbull's wife and children. Besides this, defendant had frequently advanced to plaintiff small sums of money. David Trumbull, recalled. Plaintiff lent one of the pamphlets to McAllister, a relation. Elias P. Dayton, recalled. In a conversation I had with defendant in relation to the value of his property, at a time when Rice was worth $3 a hundred, he said his annual income was $52,000, and at the present time, Rice is worth $6 a hundred. Luke Tucker. Defendant was at home when plaintiff offered to sell witness the farm on which he lived. Defendant sent witness to plaintiff with word that if the present suit was carried on, he need not expect anything for his wife and children. Joseph Trumbull was present 2 or 3 years ago at a trial in Newark between Trumbull, the plaintiff in this suit, and one Jonathan Dayton, wherein counsel for Dayton was about calling on the present defendant as a witness to prove that Trumbull had rifled Miss Dayton's drawers. But defendant then declared in open court that Dayton could not prove that fact by him. This evidence, with the other in the progress of the trial establishing the falsity of the charges contained in the publication, was objected to by the counsel for the defendant on the ground that the plaintiff had not attempted to justify, and the libel and legal intendment must be considered false. The court admitted the testimony to go to the jury because they might suppose, in the absence of all testimony, that it was out of the defendant's power to prove these charges, which might, nevertheless, be true. The arguments Mr. Griffin for the defendant contended, principally in mitigation of damages, that this publication, whatever may be its character, was written by him under a high state of provocation. It never was intended for the public eye, but was designed to terrify his wife and bring about a reconciliation. This was manifest, as well from the intrinsic nature of the work as from the mode adopted by him in transmitting it to her. The parade of printing was made for the purpose of showing her that he intended to distribute the publication far and near, unless she abandoned her design of obtaining a separation and returned to her own home. The very essence of a prosecution for a libel was its publication, and in this instance the plaintiff himself was the publisher. The solemn family compact, which was entered into by plaintiff through the influence of his mother-in-law, ought to have been held sacred. Having violated it, it is manifest that plaintiff's sole object in persisting in this suit is money. Above all, when the father submitted, whatever injury he may have inflicted, whatever may have been the extent of his wrong, the son, with open arms of reconciliation, should have forgiven. I raise the question of law for the court, whether this action is properly brought in this court, inasmuch as both the parties are residents of a foreign state, and the publication, if any was made by plaintiff, was effected without the jurisdiction of this state. Spencer J. This was a transitory action, and in my opinion was well brought. In the case of Glenn v. Hodges, a case recently decided in the Supreme Court, it appeared that a slave belonging to the plaintiff, having run away from this into the state of Vermont, was about being reclaimed and brought back by the plaintiff, when the defendant rescued the slave under color of an attachment issuing from one of the courts in Vermont. An action of trespass, vi et armis, for rescuing the Negro, having been brought by the owner of the slave against the defendant in this state. On an objection to the jurisdiction, it was held that for injury to the personal property or personal rights, which are of a transitory nature, an action may be brought wherever the defendant is found. Mr. Emmett. It is proved that one part of this publication was composed at Saratoga Springs, and the composition was finished at Boston, printed by a confidential printer there, and then brought to this city. Now in the case of Baldwin v. Elphiston, it was held by Chief Justice Gray that printing a libel may be an innocent act, but unless qualified by circumstances, shall prima facie be understood to be a publishing. It must be delivered to the compositor and other subordinate workmen. Printing in a newspaper admits of no doubt upon the face of it. It shall be intended a publication unless it be shown that it was suppressed and never published. According to that authority, the mere delivery of even a newspaper publication to the compositor was not a sufficient act of publication. In the case now before the court, whatever may be alleged as to the printing in Boston, there was certainly no publication even in that place. The 5 pamphlets after they were brought to this city, and while in transit to, in their place of destination, were taken from the others and enclosed in an envelope to the wife. In this, there was certainly no act amounting to a publication within this state, and whether this was a subsequent publication in the state of New Jersey or not, for the purposes of this branch of the argument, was immaterial. Again, the pamphlets passed from the hands of the defendant to one who stood in the relation of a wife. Had he read to her in confidence the matter contained in the pamphlets, this surely could not amount to a publication, and except from the mere act of delivery, no act of publication whatsoever could be imputed to the defendant. I therefore contend that there has been no act of publishing within this state on the part of defendant, and in the second place, that plaintiff himself was the publisher. The plaintiff, therefore, should be confined to the jurisdiction of New Jersey. It had been decided by the Supreme Court in the case of Gardner v. Thomas that an action of assault and battery brought by one of the subjects of Great Britain against another for that offense, committed on board a British vessel on the high seas, ought not to be sustained in the courts of this state. In Marston v. Fabricus, decided in the King's Bench, which is a leading case, it was decided that false imprisonment lies in England by a native Minocrin against the governor of Minorca for such injury committed by him in Minorca. But the principle upon which the decision was grounded is this, that if a contrary doctrine prevailed, there might be a failure of justice, and the courts in England have sustained actions of that description on the ground alone of necessity. The retention of a case of this description in our courts rests in the sound discretion of the court, and according to the peculiar circumstances of this case, plaintiff ought to be sent back to litigate in the appropriate tribunal of his own state. The great question in this case is whether the jurisdiction and sovereignty of an independent state are to be invaded and rendered subservient to another, and there is no reason why the same rules should not prevail in relation to a suit brought by a citizen of a foreign state against another, for a cause of action wholly arising in such state as was adopted by the Supreme Court in the case of the British subjects on board British vessels prosecuting in our courts of judicature. Spencer J. Whether there was a publication according to the existing facts in this case is a question of law, in deciding which I shall lay out a view, as well the act of partly writing the pamphlet in this state as the act of sending the pamphlet from this city, the delivery of the manuscript to the printer at Boston, and also the permission or direction to the Sun to compare the manuscript with the printed copy were, in the opinion of the court, sufficient acts of publication to support the action. In the case of Gardner v. Thomas, cited by defendant's counsel, it was decided that on the great principles of commercial policy, an action not to be sustained by one British subject against another for an injury committed on board a British vessel on the high seas. But in that case, the court expressly say that they have a right to retain such an action, and that this rests in sound discretion. But in the case of Glenn v. Hodges, the question was expressly decided. The mere delivery of these pamphlets to the wife in confidence, unaccompanied by any direction to her to distribute them, would not amount to a publication. But it is sufficient for the court to say on this question that there was at least a technical publication of the pamphlets at Boston. End of section 76. Section 77 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Action of John M. Trumbull against Thomas Gibbons for libel. New York City, 1818, Part 2. Mr. Emmett, to the jury. It is your duty on this occasion to inquire into the acts of the parties and to develop their motives. We bow with respectful deference to the superior intelligence of the court. It is our duty, and I freely admit that plaintiff had a right to commence this suit in this state. But I ask, why did he so? Why fly from the jurisdiction of his own state to lay his claim before a New York jury? The great object was money. Instead of applying to the vicinage, to a tribunal where all the parties were known, and where their relative claims could be duly appreciated, he comes to this city because, forsooth, a New York jury, with passions inflamed, would give him more liberal damages than its own neighbors. And how does he appear before us? By his counsel, this atrocious libel is read, and instead of confining himself to the matter spread on the record, he unnecessarily drags in the whole of this extraordinary production before the jury, and deliberately reads the scandalous accusations against his deceased partner. When I heard this, my heart sickened within me. I was disgusted at this shocking spectacle of family discord. The son-in-law seeking to raise the passions and excite the feelings of a jury of strangers by the immolation of the mother of his own children, seeking to blacken the character of the father-in-law by the degradation of his own family. What if on our part, on this occasion, we had thus unnecessarily required all the facts in this production to be spread before the jury and the surrounding audience? Then, indeed, we should have furnished a theme of just reprehension, on which the learned counsel would, no doubt, have lavished all the thunder of their eloquence. And yet the jury are, by and by, to be told that this heartbroken plaintiff is to be remunerated for injured feelings and for the loss of reputation by enormous damages. But I hope that the means employed in bringing this action and the artifices resorted to on this occasion would recoil on the head of the plaintiff. Admitting at present that this publication is utterly wrong, and I shall not attempt to justify it, still I shall presently endeavor to show you that there was not such a publication, through the intervention of defendant, as justified any claim to damages. The wife of defendant, after her return to her own family from that of plaintiff, sought a reconciliation between the husband and all the members of her family. She did this for the sake of the children of Trumbull, who was then absent consulting counsel and endeavoring to procure a separation. He arrives, and after finding that a reconciliation had been effected, he enters into the arrangement and promises to take up the pamphlets which he had distributed. Almost immediately afterwards, he comes to this city and holds his father-in-law to bail in $100,000. The compromise would have redounded to the benefit of his own children. Why then was this extraordinary prosecution commenced? Why but to gratify the avarice of the plaintiff, to make a speculation on, or to extort from, a father-in-law, and to put in his own pocket the patrimony of his own children. Thus this arrangement, made in good faith on the part of the defendant, in which all his grandchildren were to be placed on equal grounds in the future disposition of the property, is frustrated, and this solemn family compact, which was calculated to heal past difficulties and bury all dissensions in one common grave, is set aside and disregarded. Had plaintiff not been actuated by sordid motives, had he cherished the least regard for his children or for the memory of his departed companion, would he not, at least, have met defendant when he extended the hand of reconciliation, and have endeavored to place those children in the affection of their grandfather? It cannot be concealed, and it will not be denied, that the defendant did wrong, but he was willing to make ample atonement. He made offer after offer. He was anxious that this affair should be compromised. He spared no pains to conciliate and prevent a public disclosure, and in the order to execute any retraction, any acknowledgment that plaintiff's counsel should dictate, he did more, perhaps, that ever such a father did towards such a child. But the son-in-law was inflexible. He saw the father of his departed wife and the grandfather of his own offspring, him on whose bounty he had fed and fattened, submitting in a manner without example, but his pride would not suffer him to acknowledge that he had done wrong. When the 5 specific subjects of his wrong were presented, he refused to submit and meet the father in the open field of conciliation. He would not even acknowledge that he had been to Savannah for unwarrantable purposes. This step was manifestly wrong, as the event is justified, and the acknowledgment was not unreasonable. But we find him rejecting all overtures of accommodation and persisting in a claim for heavy and vindictive damages. Such a claim, under the peculiar circumstances of this case, ought to be discountenanced by a moral and discreet jury, whatever may have been the conduct of the defendant. When the wife was brought by the plaintiff from Savannah, she went to the house of her husband. She had not long remained there before a separation was contemplated, and through the countenance and advice of the son-in-law, she leaves her own abode, and measures are taken to consummate this separation by a disgraceful proceeding at law. The wife had not long abandoned the roof of her husband before the talisman of conjugal fidelity was broken, and other enchantments soon succeeded. Gentlemen, age blunts our feelings, and perhaps the defendant, at his season of life, long after the headstrong passions of youth had subsided, and when the cool suggestions of a calculating prudence predominated in his mind, did not think of this serious injury as he once would. But I beg of you to imagine to yourselves the situation to which either of you, even at his advanced period of life, would be reduced to have a partner for 40 years, the early companion of your bosom, to be separated from you by a son-in-law, and measures taken by him for a divorce by a disgraceful process of law. But you will presently be told by the learned counsel that this publication is disgraceful to humanity, and its most odious features will be presented in their most glaring deformity, for the purpose of exciting your indignation against the author. And it will be insisted that the printing of the work is evincive of a cruel and deliberate system of mischief. But, gentlemen, the facts in this case will warrant me in saying that the defendant fell on this plan as an expedient to accomplish a specific purpose. He believed that, rather than have the matters contained in this pamphlet published to the world, his wife would abandon the design of a divorce and return to her own home. This thing was, therefore, conceived and executed, but as in terrorem, and all the parade of printing was but a part of the same plan. From the intrinsic nature of the production, he never could have intended that it should be made public, and if he did not intend a publication, then the aggravating circumstances of printing, upon which the gentleman will descant, loses all its force. But if the essence of a libel is its publication, and if it was a crime wantonly and unnecessarily to publish the one now under consideration, it cannot be denied but that the conduct of the plaintiff himself is far more reprehensible than that of the defendant. Technically, and as the court has been pleased to decide, sufficient for maintaining this action, there had been a publication. The defendant published this libel to his own son, but the plaintiff, who had the power of arresting it in its progress and entirely preventing its circulation, having the whole under his own control, presented it for inspection to his neighbors, and it thus acquired publicity by being handed from one to another. Shall the defendant, therefore, be punished in damages for that which the plaintiff himself did? And can he, who instructs counsel unnecessarily to spread and perpetuate on the record, and read in open court, matters concerning his deceased partner, which ought never to have been disclosed, and which never intended by the author to meet the eye of any human being except his wife, speak of a libel on female character? Shall he be allowed to recover damages as the husband of that wife and the father of those children, when he has dishonored the memory of the one and fixed an indelible stigma on the character of the others? The defendant permitted his son only, as his confidential agent, to see the work, and there was merely a technical publication in the town of Boston, among a community of utter strangers. This, I strenuously urge, is entitled to no more than a technical reparation in damages. The court has said that the mere delivery of a libel to a wife in confidence would not amount to a publication sufficient to support an action, and I insist that the delivery by the wife to a third person, without the direction of the husband, would not be actionable, though it might be the subject of a criminal prosecution against the husband. I think that in this prosecution, from its inception, there are features of depravity in the conduct of the plaintiff, which I have scarcely have ever witnessed, and notwithstanding the plaintiff hopes from the seed of this libel to reap a plentiful harvest of money, he should be instructed by the wholesome verdict of the jury that he, who sounded the trumpet of fame to the infamy of his own wife and children, was entitled merely to a nominal compensation in damages. June 25th. Joseph P. Shelton, one of the jurors, having been taken ill at the conclusion of Miss Dammott's speech, and the court having adjourned until morning. On the opening of the court, it was stated to the court that the juror was unable to attend the trial, and the parties executed a stipulation in writing that the verdict rendered by the 11 jurors should be of equal validity as if delivered by the 12. Mr. Alden to the jury. It has been insisted on the part of defendant that the publication was the result of sudden exasperation, but the jury will perceive that from the length of time necessarily employed in the composition, that it was the result of cool and mature deliberation. He commenced it at Saratoga Springs and finished it at Boston. As to the publishing, it was shown to his son and the son's daughter, the atrocity of which publication to these members of his own family was a crime against the laws of nature. It was shown to the printer, and to how many more by him was uncertain. And although it had been said that 50 only were printed, yet it was impossible to say what extent of circulation had been given to the pamphlets in Boston. There was also a publication in this city on the 19th of September by dating, signing, and directing those pamphlets to persons in New Jersey. If defendant did not intend to publish the pamphlets, why did he procure 50 to be printed? It was undoubtedly his object to drive the wife from the house of her son-in-law, and if that plan failed, defendant intended to give the pamphlet publicity. We are asked, why did the plaintiff fly from the jurisdiction of his own state and commence his action in this city? At the time the action was commenced, it was believed that defendant was on his way to Georgia, and even had this not been the case, as the plaintiff had the choice of his tribunal, he acted judiciously in commencing his action where the jurors were to be selected by lot, and not, as in New Jersey, by the sheriff. Here the influence derived from the overgrown wealth of the defendant could not avail him, as it might in his own state. The motive of the defendant in writing this abominable libel was to drive his wife from the house of her son-in-law, and to send her into exile in the state of Georgia, and this effect actually followed. There were powerful motives, no doubt, which induced her to apply to the law for redress. She went to the house of Trumbull by the consent of her husband, and for the laudable purpose of attending the sick children of her daughter, and the very motive which the opposite counsel assigned for procuring the separation of the mother from her daughter, and the only friend she had in the northern country, shows their client to be utterly destitute of the common feelings of humanity. The principal ground of extenuation was that plaintiff, without defendant's consent, went to Savannah and brought on Mrs. Gibbons, but she had been previously invited to come on. A previous arrangement had been made that the son-in-law should accompany her, and when he arrived at Savannah, she came on with him through the advice of her own son. The libel had not been looked into by the opposite counsel. This would not do, and by not attempting to justify, they admit every sentence of the pamphlet false, admitting that defendant had cause for libeling the son-in-law. This affords no justification for sitting down deliberately and framing this atrocious libel against his own wife and daughter. The compromise, the great family compact, on which so much stress had been laid, was not established, except by one who was a particeps criminis in this infamous publication, who is directly interested in the event of this controversy, and whose conduct throughout the whole transaction is very reprehensible. Admitting his statement to be correct, it does not appear the plaintiff agreed to do anything more than take up the pamphlets, which he had done, as far as was in his power. There never was a publication written more immoral, indecent, and almost blasphemous than this, and it is admitted to be false, and much of it is actually proved so. The object of the plaintiff in this prosecution, the counsel avowed to be money, as the only means by which defendant can be punished, and the patrimony of the grandchildren secured. Damages should be awarded as a compensation to plaintiff, and as a punishment to defendant, and they should be proportionate to the extent of the injury and to the overgrown wealth of defendant, for a sum in damages which would ruin a man of moderate fortune would not be regarded by defendant. It is your duty and your privilege to render a verdict to the full amount of damages laid in the declaration. Spencer J. The court has had no doubt, from the patient attention bestowed by you throughout the tedious trial of this cause, that the remaining part of your duty will be performed with that strict impartiality which the cause of justice requires. The parties are to me, and, no doubt, are to you, utter strangers. This was a source of peculiar gratification, for whatever may have been said in the progress of the trial, relative to the advantages of a trial in the neighborhood of the parties, I believe, from experience, that an impartial decision could be better obtained before strangers than in the vicinage. During the trial, there have been several questions of law presented for the decision of the court. Among other questions, I decided that the action was properly brought in this court, and also that there had been a sufficient publication in judgment of law to support the action. There is in law a distinction between verbal slander and a libelous writing. To support an action for slander, it is necessary for the plaintiff to show that the words spoken imputed to him some crime or misdemeanor cognizable by law. But to support an action for a libel, it is not necessary that the act imputed to the plaintiff should amount to a crime, for any publication calculated to hold up another to public reproach or ridicule is a libel, and the principal reason of this distinction is that words may be uttered in the heat of passion and without mature reflection, whereas a writing is generally the result of deliberation. There is no doubt but that the matters contained in the publication upon which this action is founded are libelous, unless the defendant can prove them to be true, and if, as in this case, he does not attempt to establish the truth of the publication, it follows necessarily that it is utterly false. But on this occasion, plaintiff has been permitted to prove some of the charges false, though the counsel for the defendant objected to this evidence on the ground that he had not attempted to justify. This evidence the court admitted, and on mature consideration believes it to be right. It has been said truly by defendant's counsel that, to support this action, it was necessary that the libel should be published, for should a man compose the most malignant production against another and keep it in his own possession, no action could be maintained against him. But in this case, according to the opinion already expressed by the court, there has been a sufficient publication of this libel by defendant. He published it in Boston and subjected it to the inspection of his son, William Gibbons. It has also appeared in the progress of the trial. that in addition to the pamphlet intended for the defendant's wife and directed to her, there were 4 others endorsed by him and directed to different persons. Some were delivered by her to plaintiff, and she herself distributed others, in doing which she acted as the special agent of defendant, who may so far be considered responsible for her acts, but in the opinion of the court he ought not to be responsible for the publication of those delivered to plaintiff. These facts being established, the next question is, what damages ought plaintiff to recover? On this occasion, the defendant, instead of justifying, has set up in extenuation the reason and motives which actuated him in making the publication. The plaintiff, in the first place, is charged with going to Savannah and bringing the wife of the defendant to Elizabethtown. There were frequent instances where suits were brought by one man against another for running away with a wife and depriving the plaintiff of her society. But it seldom, if ever, happened that bringing a wife to the husband was considered by him blamable, and in the view of the court, instead of the defendants imputing this to the plaintiff as a fault, the husband ought rather to consider himself laid under an obligation. That the plaintiff went with his mother-in-law to consult counsel relative to a divorce is another charge against him. Why she went to consult counsel, we are not informed, but in the absence of all testimony on this subject, it is but just to refer to the publication itself and to the abominable principles which it contains, to arrive at the reasons which induced her to leave the house of her husband and apply for professional advice in obtaining a final separation. This, therefore, affords no excuse for the conduct of the defendant. This libel was published, not in the heat of passion. It was the result of cool deliberation. The object was to drive her from her purpose by presenting to her view a tissue of falsehoods, the most indecent, immoral, and abominable that the mind can conceive. According to the testimony, this very unjustifiable procedure produced the effect intended, and the wife returned to the house of defendant, and shortly afterwards embarked for Savannah. It has been urged to the jury that plaintiff himself entered into a family compact, wherein all past differences were to be buried in oblivion, and his children were to be placed on an equal footing with the other members of the family with regard to the future disposition of defendant's property. But we find that plaintiff entered into no other agreement than to take up the pamphlets delivered to others. Other grounds of defense have been assumed by defendant's counsel, but I deem it a duty to instruct you that, in my view, this libel was published by defendant without any justifiable cause. In determining the amount of damages, it will be necessary for the jury to recur to the charges against plaintiff in the body of the publication. These may be classed under 4 distinct heads: incontinency, or criminal intercourse with defendant's daughter before marriage, stealing or pilfering certain letters, habitual mendacity, and hypocrisy by making a mock of religion. Admitting all these charges to be true, what must have been the depravity of that man's heart in committing to paper and deliberately printing such matters as this pamphlet contains against the members of his own family? But the publication stands before us as wholly false, and we have no reason to believe a word of it to be true. In the first place, in awarding damages, it would be your duty to render to plaintiff ample reparation for the loss of reputation sustained by means of the publication. It has been shown that this character is fair and unblemished, and on this occasion it has not been impeached. In the second place, plaintiff is entitled to compensation for the injury inflicted on his feelings by means of the libel. To arrive at a just measure of damages, under this head, perhaps the best mode is to place ourselves in the situation of the injured party, and to imagine what must have been the feelings in our own minds in consequence of the publication of such an atrocious production. But in the last place, damages in a case of this description should be awarded with a view to the punishment of defendant, for the purpose of correcting the morals of mankind, and a public example should be made of defendant for the purpose of deterring others from the commission of similar enormities. On this head, the court will not venture an opinion, inasmuch as the measure and extent of damages in cases of this description are subjects confided exclusively to the sound discretion of a jury. It is proper, however, for the court to instruct you that in your deliberations on the subject of damages, you ought not to be influenced by the consideration urged by the counsel for the plaintiff, that his children are to be deprived of patrimony belonging to them in the future disposition of the property by their grandfather. With this subject the jury have no concern. The damages awarded shall also be proportionate to the wealth of the defendant, because a sum which would operate to ruin of a man in moderate circumstances would not be felt nor regarded by a man of overgrown wealth. Though a man of this description ought not to be deprived of his freedom by a jury, yet such a verdict should be awarded as should teach him, as well as others, that in this community the sword of justice is whetted, and ready for the punishment of those who will thus violate the laws. It has been proved that the defendant has a vast annual income. It is to be lamented that with such advantages in his hands, with such opportunities afforded him for doing good to his fellow men, defendant should not have made a better use of his property. For I myself am constrained to say, from an impartial survey of the whole case, that in my experience in a judicial capacity, for a great number of years, I have scarcely, if ever, witnessed a production fraught with so much indecency, immorality, and I might also add a blasphemy, as the one on which this action is founded. On the suggestion of Mr. Emmett, the court further instructed the jury that defendant was not answerable in damages for the 45 pamphlets which were retained, nor for the reflections contained in the libel against his wife and daughter. But the jury, nevertheless, in looking into the motives which influenced the publication, might recur to the whole production. The jury returned a verdict in favor of the plaintiff for $15,000. End of section 77.